With your lordships kindly, one matter for big group tomorrow, my lord. What has happened, my lord? The auction purchaser had made the payment of 8 crores, my lord. Due to the interim order granted by this honorable court, we are not in a position to issue the sales certificate, my lord.
What is that? He has deposited the money.
My lord, the auction purchaser has made the payment of 8 crores, my lord. Now the bank has to issue the sales certificate to him. Because of the interim order, our bank is not in a position to issue the sales certificate.
It will come next week. Yes.
The amounts have been paid, my lords, but the documents are still retained with the bank, my lords. There is a dispute of
Next
Monday,
week.
my lords.
Next week we'll see convenient.
My lord,
Date may be given, my lords.
extreme urgency is this that my
Yes.
lordships, I have already paid the loan, my lordships.
Uh-huh.
I've already paid the loan, my lordships. My lordships, my home is being seized. I stay in the temple premises, my lordships. And my son is preparing for the 10th board exams, my lordships. My lordships, I have become
When is
homeless.
that file?
My lordships, it was filed in the month of May. I have already paid the loan.
No, anyhow, we can take it up next week because it's filed in the month of May.
No, my lordships. After that, I've paid the loan, and now they are not. I'm not in the possession of my home, my lordships. They have.
That's what I'm saying. It is, you're not in possession of your house from May. So we can take it up next week. Take that. Yes, next.
My lord, it is a family matter, my lord.
There's an urgency in this matter, my lord. We have started, the third party has started construction and the order we have laid, the sales certificate has been issued.
What is that petition?
A DRT matter.
What is the construction by third party?
The third party has started the construction in the social property.
Who are you?
We are for the petitioners, my lord.
No, you're a borrower.
Yes.
Huh?
Yes, sir, my lords. We are the borrowers. We have challenged DRTs or.
When is that? Which year is that petition?
What?
When that petition is filed, red petition is filed.
It was filed at least 4 months before.
No urgency this side of the vacation.
Yes,
Yes, no, yes.
Bank is incurring expenditure for security of the property. We have taken physical possession.
When?
Also first 1 year. This WP, there is an interim order. The 6 lakh he has paid. We could not issue sale confirmation. That bidder has also taken back his money. Now we are incurring
Next week.
My lord, it is RPSC matter, my lord. Matter is settled between the parties.
Tomorrow.
Go to the mediation.
Tomorrow.
Huh?
Direction to return of documents. The parties are settled out of court by way of OTA.
Next week, yes.
Lordship, this is with respect to the 10PA declaration. This court has made some oral observations and so also asked me to produce the latest statement and all that. That for modification of that, I filed an IEA. Lord.
Next week,
Oh,
yes.
okay.
When was it? Huh? We'll have it after vacation, not now. Yes.
My lord,
No.
my lord, the court has asked to file the inspection report regarding the use of property, my lords. Interim order is operating, my lords. So bank is unable to proceed further.
Bank can wait. Yes.
Yes, we obtained section 14 order, my lord. Policies are not supporting to shoot.
Monday. Yes. No. Yes. Court can't hear all these matters at the fag end of the vacation. It is done in the month of June. We are in December now. Yes.
Maintenance is saying yes, my lord.
That also no urgency. Yes.
Execution petition is going to file, my lord. The opponent, my lord. And
He is going to file the execution petition.
they are threatening like.
So,
We have filed a for stay, my lord.
what is that?
My lord, it is MFA, my lord.
So if it is numbered, it will come. Fresh matters don't mention. I'm repeatedly telling everyone. Yes.
Pending matter, my lord, wherein lordships granted visitation rights during Dasara vacation. Lordships, in fact, at Fest for Christmas, your lordship said, let the Dasara vacation finish. Father has no visitation rights for Christmas vacations. That being the reason, my lord.
Why are you waiting till today?
Ma'am?
Why are you waiting till the fag end of the vacation?
My apologies, my lord. Sorry.
That's a whole difficulty. Yeah, all this custody matters they've realized before summer vacation, Dasara vacation.
After Dasara, also what happened was we tried to mediate, my lord, which we reported before your lordships. Unfortunately, we could not
Let's-
arrive.
Next week, because how the court will complete all these matters, that's the whole question. Yes,
My lord, the petitioner is neither a borrower or guarantor, but he is a tenant. The bank is unable to proceed with the surface action. From past 1 year, he is not complying the office
what is
objection
not
also.
able to, from
My
1
lord.
year, that can be taken care of in January. Yes.
My lords, Respondent Bank is fraudulently taking the possession of the scheduled property tomorrow itself, my lords, maybe, and the vacating notice is going to expire today, my lords. The petitioner and the tenants will be homeless if the possession will be
When
taken.
is it filed?
My lords, 2023, but we have also filed an I and we have been trying to take,
I'll
list the
not take
matter
up
since
any
3
of
days,
those
my lords.
matters. Yes, call the list.
My lord, I submit a small submission.
Make submission.
lord.
2023, he's not making any payment, Your Honor.
And submissions to lordship.
Enjoying the stay, my lord.
Huh?
Since 2023, he's enjoying the stay. He's not making any payment, my lord.
All those things, because he is enjoying from 23, we will help them to have it this December also. We'll see in January. Yes.
My lord, it's an MC matter that was filed in 2018. The orders in the trial court is depending on the hearing of the WP in this matter. We're ready for.
Not now. Yes.
The trial court has ordered maintenance, my lord. Paying of maintenance is stayed by the honorable court in the petition filed by the husband. The matter is pending before the trial court, not paying the maintenance amount. Madam,
Which year is that?
2025, madam.
When was the order passed?
December 24.
Your lordship,
Next weekend.
your lordship, we have challenged the 13 clause 2 notice, my lordship. The bank has issued a sale notice recently. The matter was posted for final arguments. So recently the bank has issued the sale notice. So request to take up the matter tomorrow,
Which year is that writ petition?
25, my lord.
Next
My
next
lord,
week.
anytime next week, my
Huh?
lord. Anytime next week, my
No,
lord.
no.
The urgency is that
Lord-
the bank has issued the sale notice. The bank people,
Happen. Yes.
they're harassing the
this is-
petitioner, my lord.
My lord, this is a wife's petition challenging the visitation order. The father is residing and employed in Singapore, my lord. The family court has passed an order which grants him visitation as and when he comes to India, my lord. So now he is coming very frequently and harassing the petitioner and the child, even in the school, my lord. There's no schedule that's fixed by the
He's
court.
coming from Singapore to harass the mother and the child.
No, my lord, he's coming to Bangalore often, and every time when he comes here, as there's no schedule fixed by the court, it only says as and when he comes to Bangalore, my lord. So,
Difficulty to the mother.
my lord.
What is the difficulty for the mother to give the visitation whenever he comes from Singapore? Just like that, he cannot come.
Please, my lord, she is giving visitation, my lord, but the father is even going to the school and harassing the child, and serious complaints have been raised by the school, my lord, which have been attached in this writ petition. It's a fresh matter, my lord. The other side has been served, and they have also entered appearance, my lord. And even for the vacation, they have given overnight custody, which the child has never exercised even a single night with the father, my lord. The matter may be kindly heard before the
Like the
vacation.
DRT, for all these matters also, there should be a separate tribunal to be constituted. Because every to visitation given, not given, however it is, everything is a problem.
Please, my lord.
We'll see next week. Yes.
My lord,
Next
my
week.
lord, if a schedule is fixed, the mother will oblige, my lord.
Next week, next week.
Great.
Yes.
The family court has directed the respondent to pay 15,000 rupees, my lordship. Whereas he's earning.
Is it a fresh matter?
No, my lordship. It is RPFC 20.
No, I'll not hear any of the old matters now.
My lord.
For final dispute, my lordship, last week, my lordship.
Maybe. I don't have time for all that now. Yes.
Interim order not been extended, my lordship. in this case, my lordship.
What were you doing that day when the interim order is not extended?
I was mentioned, my lordship, because of some errors, my lordship, it has been without, my lordship.
No.
Maybe taken up in the next week, my lordship, any date, my lordship.
No. Yes. Fresh matters don't mention, the matters will come. Yes.
My lord, possession within 7 days they are taking, my lord. 7 days.
File it, it will come. Yes.
My lord, even I cannot file DRT petition because when the pregnancy of this writ petition. The order may kindly be.
When
passed, my
when
lord.
is that writ petition filed?
1 year back.
No urgency for this
My lord,
court to take up the
7 days
matter.
time is given.
No. Yes.
My lord's petitioner has not, my lord's petitioner has not completed the interim order, my lords. The order was in 18/9/2024, my lords.
What are you doing from 18/9/2024 till 2025? And why should we take up the matter now out
My
of
lords,
the?
matter was listed,
No. Yes.
matter was listed
Kind
on
submission.
file 11, my lords.
Call the list.
Kind,
Page wise
At least for
adjournment,
withdrawing, my
number
lord.
1, page
At
number
least for
3,
withdrawing
page number
the
1 to
petition.
14.
You want to withdraw?
Yes. Because I
Tomorrow
cannot
for
file the
withdrawal.
DRT because
Yes.
ನಾಳೆ ಕೊಡಿ sir.
Publish.
List number 3, list number 1, page number 3, serial number 12 to 14, page number 4, 15 to 23, page number 5, 24 to 29, page number 5, 6, serial number 30 to 32, page number 7, 33, page number 8, 34 to 41, page number 9, 43 to 49, page number 10, serial number 50 to 57, page number 11, 12, serial number 58 to 60, page number 12, serial number 61 to 64, page number 13, 56, 67, page number 8, page number 14, serial number 68, 69 to 72, page number 19, 73 to 77, page 1, list number 1 for orders matter, serial number 1, A precaution, Reddy.
Very good.
Yes.
But in this matter, not, both of us may not made efforts not to see that the whole litigation may not is put to an end, because husband and wife are not residing separately since 10 years. Husband is looking after my lord, the elder one. He is now ready to look after my lord, the younger child, and look after his entire my lord expenses, education expenses. Now the issue on which we are unable to settle is my lord about the
No, that's
permanent
what I
alimony.
asked is,
That's
what I
exactly.
asked is, no, about the permanent alimony and all now, if there is no consensus, we can't help it.
That's exactly.
Now, coming to the maintenance,
Please.
now, how much is his monthly income?
Not 90,000 rupees as per my lord the
90,000.
affidavit filed.
Now, what are the expenses of the second child?
Second child, my lord, monthly, my lord, needs around 15 to 20,000, my lord, including school fee and other expenses, transportation and other expenses.
Oh, there should be some specific amount. What is
Right. Around 20,000, my lord.
If not, they would have paid the fees. Not let them so. I think your entire thing. Or
You have to say what is the fees.
Lord, I've given, my lord, the details in the writ petition number 20087. I've given
You can tell
details.
the court now.
For all these years, my lord, from first standard to fifth standard, I have spent rupees 9 lakhs, my lord. 9 lakhs 32,000.
That is not for which he has
Along
filed the
Tell
writ
me
petition.
what you have spent. We are on, what is that you are spending each year, this year?
Each year, my lord, around 1,20,000, my lord. Two installments, the fee will be paid, my lord,
Hmm.
including,
And the mother is able to take care of all this.
please, my lord.
Mother is able to pay this 1,20,000.
This for paying, has to pay by borrowing or by raising loans. Otherwise, the education, even according to your lordship, my kindly see, my lord, even according to the respondent, my lord, he is spending 60,000 rupees per year for his first son. Education expenses as per the assets and liabilities filed in the before the court below.
Now, the maintenance, it cannot be more than 30% of his salary. What is his earning is. Whatever are the expenses of the wife. You can't, you have to, if you want to, spend an amount of 1 lakh and odd, that is her lookout. When as per the evidence on record, if his income is 90%, it can't be more than 25 to 30% of his salary.
And my elder
And he's
son,
taking care of the elder son.
elder son is in Australia,
apart
New
from
Zealand
his
now.
other assets. 90,000 is apart from his other assets, my lord.
What is there on, go show to the court, the evidence and the order of the court that he is having more than,
No, the assets and liabilities, my lord, filed by him.
yes, page number.
Your lordship is having RP, my lord.
Yes, I'm having the, sir,
RPs.
where is that? The review petition. Yes, review petition is here.
In page 84, my lord.
In page?
In page 84. the assets and affidavit filed by the respondent.
Don't think it is 84. 84 is something else. Usha
Page
Medicals.
84 of not my synopsis that I have filed in the RP. I have filed not a synopsis with list of dates and the documents in the RP
This is yes, my lord.
to make it convenient for the honorable
Yeah,
court.
please,
But I have
please.
produced all the documents.
My learned friend is correct, my lord.
Page number?
Not page 86, my lord will find, but item number F, my lord, 84,000 rupees, my lord, is monthly income.
As an 2023.
No, my lord, it has been enhanced to 90,000 rupees as on today. And my lord, my elder son, but I've sent him to, my lord, Auckland, New Zealand. But I need to incur expenses, not for his higher education, which I'm doing.
According to him, he needs 50,000 expenses monthly, my lord. And he is claiming rent also. In spite of, he is saying that he is
No,
owning.
he is your son also.
No, he is, no, he is owning 8 houses according to him. Which
No, I'm saying the elder one, you're referring to his expenses, is your son.
Yes, my lord, I am not saying that.
Yes.
That's what I'm claiming though. Even let the second son also be taken care of with the
Definitely,
same
definitely.
standard of living.
Definitely.
The same standard of living, because since from the his birth, my lord, till today, he has not paid even a single rupee towards his medical or education expenses.
You the order will relate back to the date of application.
Please, my lord.
Yes.
Even
So,
the respondent counsel has spoken to learned senior counsel that matter should be taken up in the your lordship chambers, provided.
My request, my lord, to my learned friend was, I have made, my lord, more than 10, my lord, attempts with sitting with both the parties, my lord, to see that everything is otherwise, my lord, these kind of cases are clogging, my lord, our system. They are not residing together since 10 years, not, and ultimately the result we know. But this is only the only thing is not maintenance or not lump sum amount. But we made an effort and not they are stuck at certain not figure. If your lordship not permits us, not can I request, not can we both of us request not to take up this matter not in chambers for a few minutes, so that not some may not sense may not enter both of their minds to settle these kind of issues.
this is matter on Tuesday at 5 PM in the chambers.
Please.
Tuesday, then Wednesday.
Got one humble submission.
Obliged, please.
Proceedings of-
Already list has started.
No, my lord, I've been thrown out of the property today, my lord. I'm the owner of the property. The loan is not in my name. Some third party apparently alleged to have taken the loan, and my utensils are being thrown out. To get the FR number, my lord, it took 5 minutes. There was a network issue. Maybe taken at 2:30 or the end of the day. Kindly, my lord, there's a grave urgency. I'll be able to depict before this honorable court. The respondent has nothing to do with the suit schedule, petition schedule property, my lord.
It's not possible to take a lunch motion. It will come on Monday.
Kindly, my lord, I've been thrown out. My utensils are on the road, my lord, as I'm speaking.
Don't tell, you must be having knowledge about it.
No, my lord,
Not
seal
that-
and seizure. My lord, seal and seizure, I'll be able to produce the documents. My lord, a CMIS comes to be allowed as far back as 2024. I didn't even know about it. Today, I've just downloaded the online copy and I'm providing it before this honorable court.
Miscellaneous.
Under section 14 of the SURFACE Act, he has taken a personal loan. It is not even on the, it's not even a housing loan. Based upon that, I've thrown out of the property today, my lord.
But I'm telling you, you have to give the notice to the respondent bank, otherwise I'll not take it up. Whoever- whichever is the
Canara Bank is there, my lord. I'll serve a copy upon it and come.
It's on them, and if I know that if any of this, the proceedings on the Surface Act.
Please.
Or in your knowledge.
Yes, very well, ma'am.
I'll dismiss the
Yes.
petition on, with exemplary cost.
Very well, ma'am. Yes.
Yes. 2:30.
Grateful.
Serial number 2 for orders.
But anyhow, you shouldn't have made a mention when the list has already started and the
Fine.
mentioning time is over.
FR number.
Your client, nobody is like, you have to go as per the procedure.
Very well. That's why I apologize.
Yes.
Serial number 2 for orders matter. Geeta or for petition appellant.
Respondents in this case, please.
What is this memo for return of TCR?
Yeah, fine. My lord, to withdraw the money.
The memo is when seeking to return of the TCR. And as the Respondent wants to withdraw the money deposited by the petitioner.
It can be disposed of.
appellant, huh?
It can be disposed of, my lords.
No time now.
Yes.
Appellant insurance company. Registry is directed to return the TCR.
Sale
Yes.
number 3.
Much obliged, please.
Grateful.
For appellate. Owner's appeal, my lord. The entire liability fastened, my lord, on the appellant has been challenged.
What is this council submission?
Submission is, my lord, with regard to the valuation, I have valued the appeal for 20 lakh rupees. Whatever the valued before the trial claims tribunal, that has been challenged. They are raised the objection, it is not correct. It has to be come before the division bench. Since the value is more than 15 lakh.
Office objection with regard to the value of the appeal is upheld as per order dated 10/11/2025.
Office objection is, my lord, the value.
Upheld.
My lord,
By order dated 10/11/20.
it has to be overruled. On that day, my lord, I could not appear. Therefore, my lord,
That order is passed
my lord,
already.
what they say, my lord, we'll have to less the, my lord, award amount passed by the tribunal. Even 3,85,000 is, my lord, minus, my lord. It will come more than 50 lakh. Therefore, it has to be listed before the division bench.
That is a different aspect.
Yes, ma'am.
What is the objection? Please look at it.
Value of the appeal is to be
Is
mentioned.
correctly stated in reply.
Yes.
The following office objection is attended by way of submission. Value of the appeal to be stated correctly.
Yes, ma'am.
What is that it is stated?
Value is valued at rupees 20 lakh, my lord. The appeal is valued.
It will go. Why they have taken the objection is the question.
I have made a submission, my lord. The value of the appeal is correctly mentioned. That is what the submission.
What was claimed before the tribunal?
20 lakh. My lord.
Hmm.
Same.
Then
Same.
that's why I'm not able to understand why did they raise this objection?
That is what.
Ask them to come.
That is what. Twice I have written. My lord.
Sale number 4. Sale number 4.
In this case, appear for appellant. Petitioners 3 and 4 are fathers, parents of the deceased died. I have produced 38 page number death certificate, not entitled your lordship. 38 and 39.
Court is fed up with
During
this,
pendency of the petition, died your lordship.
So then you have to seek the leave of the court.
No, your lordship, they not entitled for claim, that is office raised objection.
But you have to show it, show in the.
I have
cost
produced page number 38.
Please come to the cause title before the trial court. Yes.
Trial court, that is petitioner number 3 and 4, your lordship.
So all the parties should be here in the, in the cause title that is shown.
No, only for, I claim for.
You might be claiming for somebody, but all the parties should be there in the cause title. Then you should mention that so and so died by LRs or whatever it is that has to be stated.
I have stated note, your lordship, that is kindly your.
Not note, the office objections or append petitioner shall file the office objection shall be complied within a week. Yes.
Sale number 5. Inna Padma, petitioner.
For the respondent to the.
Rajshekar.
No representation. This is matter after vacation.
I speak before vacation, not immediate.
What is the urgency for you?
For maintenance, not that is.
2022 matter will not hear now. Yes.
Subsequent not my team is also came to be dismissed by I have filed RP.
Yes.
Sale number 6. Aleshappa.
Office objections to be complied. Yes.
Sale
Any
number
interim order in this?
KVL location.
No.
What is that?
Sale number 6.
Give that.
My lord, loan account closure, my lord.
Huh?
Loan account has been closed.
It is submitted by the land council for the respondent that the loan amount is closed. Hence, the petition is dismissed as infructuous. 7.
Sale number 7. Kendra SN.
Give that memo. A memo is filed stating that the matter is settled out of the court. Hence, wants to withdraw the petition. Memo is taken on record and dismissed as withdrawn.
Serial number 8.
Lord, a physical copy has been not served to us. Whatever was pasted on the door, we have taken the photo of it.
The count.
Spite of visiting several times the bank, they're not.
Legible and better copy of an
Yes, my lord. They have not given us the physical copy. They whatever this is pasted on the door. We have visited the bank several times.
To
My
understand,
lord, the petitioner's daughter is undergone a complicated surgery. Post surgery, she has again undergone complications. She's been hospitalized in Nagpur, Maharashtra hospital. The bidders are running around to take possession of the property, my lord. That is the urgency.
No, they're only asking you to file a legible copy.
My lord,
Legible,
they're not giving in
copy.
spite, my lord, my compulsion, they're not giving us the legible copy of it in spite of visiting the bank. That's the reason why I filed the IA.
Type, I think. You can type and file a copy of what it is.
That
So
can
that
be done.
it's for the court to understand. How
That
how will the court read a
Well,
copy when the copy is not legible? That's why they have asked you, what is the council submission for this? Now, how can the court read like this? You have to type it, isn't it?
Yes, my lord.
At least a typed copy needs to be filed.
My lord, that can be done, my lord. A date may be any short accommodation. my lord.
The office objections shall be complied with and the petition shall.
Any
file
short accommodation would be.
The typed copy. List this matter on Thursday.
Much obliged.
Serial
Yes.
number 9. Srinivas SV.
I appear for the petitioner.
Respondents, my lords.
What is this maintainability of the writ petition?
Lords, there are two applications. There's a common order passed against two applications. And the office objection with respect to objections not being filed to the said applications is that the respondents have orally submitted that they do not have any objections to allow my applications. That is IA number 10 and 11.
So you have stated that no objections are filed. Have you stated that no objections are filed by the respondent?
It's already stated, so.
Then what about this maintainability?
Maintainability is with respect to, they have mentioned that the two IS cannot be challenged under the same writ petition. That is the office objection. There is a common order. It's a recall and reopen application was filed to recall PW1 for further cross-examination.
Lordship, if I may make a submission, we have not mentioned that we do not have any objections, my lords, because for 2.5 years.
File the objections before the court.
My lords, we'll file the objections, my lords.
At
It's
page
just
number
a false submission
15.
was being made, so
I'll show it to my lords at page number 15, annexure A.
They have filed objections.
No, they have not filed any objection.
Show your, where is that office objection? I mean, the objections that are filed by you to the IA.
We have not filed, my lords. We'll file the objections. They are saying in the family code, my lords, we have mentioned that we do not have. Here we'll file the objections, my lords. Since it's maintainability of the writ petition itself is in question, after the maintainability gets cleared out, my lords, we'll file our objections, my lords. We have
The
strong.
office objection.
My lords,
with
one
regard to
submission,
the
my lord.
Maintainability is overruled.
My lords, one
This is
sub,
matter next week. So and so the respondent, any objection, if objections, if any, shall be filed. Yes, 10.
one, my lords, one submission, the matter is listed on 6th of January, my lords. In the order sheet itself, it's clearly mentioned.
I said I'll take up this matter on Wednesday next week.
Great.
Yes.
Grateful.
Serial number 10.
Petition. 13B
What has
petition.
happened? Read this. I asked you to give it a. What happened? R&S, what did you say? Password? Ask him to come. What has happened? Find him, find out. Yes, 11.
For the petitioner, my lords.
Serial number 11.
My lords, office objection is, my lords, only, my lords, annexure B to be properly stitched, my lords. During the course of the day, I'll do it, my lords. It may be heard on merits, my lord.
For respondent, they have not served the paper.
I'll serve it, my lord.
Office objection shall be complied with during the course of the day. The paper shall be served on the council appearing for the respondent. List this matter tomorrow.
Please, my lord.
Yes.
Serial number 12.
I prefer petition appellant, where I had filed an application for extension of time, where this matter has been disposed of by the Honorable Court on 8/8/2024, with the direction to dispose of the matter within 6 months, where the trial court sought an earlier occasion for extension of time. Now the trial court is insisting to seek the extension of time before the Honorable Court for another 4 months.
Why should you see? It is for them to see.
That itself I request the court. Court has said yesterday itself to kindly you seek the request and make a submission.
No, if it is not able to do it, it is their duty to do to seek extension, then we will address it.
The court itself has requested me, where
How can the court request you? We'll ask
orally
the
I
court,
had
why
been
is the
requested.
court doing all
In
this?
my affidavit itself, I have been stated.
Please come. What is happening to the?
But now the evidence of the different,
Where is that? Where is that? Where is your affidavit?
page number 4. no? Para number 6.
I think this is a new trend by the court. The present IA is filed by the appellant seeking extension of time. This court has disposed of the appeal on 8/8/2024 and directed the trial court to dispose of the suit itself within a period of 6 months. Thereafter, a letter was addressed by the principal City Civil and Sessions Court, Bangalore, by the judge so and so on 30/6/2025. And this court has granted another 6 months' time to dispose of the matter. It is stated that the trial court orally instructed the petitioner, the appellant, to seek extension of time to dispose of the suit in the present appeal. This court is not able to understand how when there is a timeline fixed by this court and it is for the court to dispose of the matter as per the timeline, why it is insisting the parties to file this kind of an application is not known. The registrar judicial is directed to seek an explanation from the judge in this regard. This is matter on Wednesday. Yes, next.
Number 13. Cell number 13. A.M. Venkatesh.
When I sought for dispensation of the award passed by the award copy, not necessary, madam. Award copy I have sought, dispensation of the award copy.
How can the award be dispensed with?
Judgment is maintainable on the basis of the judgment only. The award is not necessary, madam. Order 41 rule 1(1).
It says award is not required. Which is executable?
Well, what happened in the order portion? It is written 4,50,000. 4,80,000 is the award.
Because you have not sought for the clarification from the court.
Yes.
Where there is a typographical error.
Yes.
No, you will say that the award itself is not required.
But that is 41 rule 1. Appeal is maintainable on the basis of judgment only.
So
award
now,
is not
for
necessary.
example, if it is award, judgment and decree is not required according to you.
Yes, that is what order 41 rule 1(1) says.
The petitioner, the IA number 3/25, filed for dispensation of rectification of the award copy. With respect to the office, rectification of the award copy, that IA is dismissed. The petitioner shall file the award copy. Yes, 14.
Cell number 14.
My lord, award copy is necessary, my lord. It may be taken up after 4 weeks, my lord. But I have to correct it there.
Whatever objection shall be complied with, the award copy shall be filed within 4 weeks from today.
Cell number 14. Ketan G.
Notice to the respondent.
HR Renaka may be directed to take. HR Renaka, KSRT is the only.
Only one respondent. HR Renaka is directed to take notice on behalf of the respondent, KSRTC, and the applicant should serve the copy of the same. Yes. Registry is directed to call for the TCR. Post for final hearing.
Insurance company serial number 15. Insurance company challenging on the ground of liability.
By what happened to the certified copy of the judgment?
Certified copy we have produced on MFA number 8628 of 2025.
I number 1/25 is filed seeking dispensation of the production of the certified copy of the judgment as they have filed it in MFA number
8628 of 2025.
8628 of 2025. Accordingly, I number 1/2025 is allowed. Yes.
Insurance company challenging on the ground of liability. As on date of accident, there is no DL, my lord.
When was the accident?
Accident occurred on 22/1/2023.
it is submitted that as on the date of the accident, the driver of the offending vehicle was not having a valid driving license. As such, the insurance company is not liable. Court said pay and recover.
No, my lordship, actually in this matter, my lordship, implication of driver, my lordship. As a police charge sheet, everything, my lordship. It shows driver of the FIR complaint, everything, it shows tractor
No,
and
just now
trailer.
you said about the DL.
Yes, my lord. Actually, driver of the one of the person, my lordship, is driving
I
vehicle.
think now it has become very easy for the insurance companies just to say, we are on the ground of liability.
Implication of driver, my lordship.
That is a different aspect, no? Implication of driver is a different aspect. Not having a driving license is a different aspect.
My lordship, as per FIR, my lordship.
I will not hear this.
My lordship.
This is matter after vacation. No, I just go by in all your appeals. I don't even open the file.
No, my lordship, actually FIR.
No, you have submitted before the court that it is on that ground. Why should I hear it?
One of the.
Not fair to the
My
court.
lord-
No, I will not hear. This is matter after vacation. 16.
Serial number 16,
If appellant in this case, please, my lord.
Yes, notice to the respondents.
Much
serial
obliged.
number 17,
17, my lordship. Insurance company liability, my lordship. As on date of accident, there is no policy, my lordship.
There is no,
Date of accident, my lordship. 17/1/2016, policy covered, my lordship, 1 March 2014 to 28 February 2015. Date of accident,
finding of the tribunal. Please come to that.
my lordship. Tribunal considered, my lordship, insurance company as liable to bear the compensation.
On what ground?
As of date of accident, my lordship, policy, insurance policy produced by respondent number 1 insurance, that policy was not issued as our date of accident, my lordship.
Let's see, where is that finding?
Finding para number 17, my lordship.
You say it is a insurance policy produced by the first respondent is a false insurance policy, and that policy was not issued by it.
Please, my lord. We have,
However, there is no single line of averment in the objection stating that the insurance policy produced by the first respondent is fake insurance policy and it was not issued by the company. So you have led some evidence contrary to your pleadings.
yeah, whatever the policy has been produced, my lordship, that policy shows that the insurance company has been policy issued as of date of.
Case of death or injury.
Case of injury, my lord.
The
2,97,000.
counsel appearing for the insurance company submits that the vehicle was not having a insurance policy, and in spite of the same, the court has granted the compensation. Considering the same, they shall be stay of all further proceedings 50%. 4 weeks.
serial
Yes,
number
next.
See, my much
18,
Notice to the
For
respondents.
the appellants, my lordships filing dispensation for R1.
Memo is filed seeking dispensation of notice to R1, dispensed with notice to the other respondents. Yes,
serial number 19,
Filing dispensation for R1, my lord.
yes, same R1, notice to other respondents. Yes,
serial number 20,
The dispensation for the R1, my lordships.
yes,
serial
Obliged, my
number
lordships.
21,
notice to the respondents.
serial number 22,
What, 21, yes, notice, 22,
For the appellant, there is one more appeal, my lord, sir.
Huh?
There is one more appeal granted to this, my lord, sir. 4191 of 2025.
notice is ordered,
Yes, my stay has been granted. Mr. Mandlache has filed wakalat, my lord.
notice to the respondents. The list along with so and so.
serial number 23, Menna Rangeroda,
First respondent make can be dispensed. First respondent, notice to first respondent make.
Dispensed with. Memo is filed seeking dispensation of notice to respondent number 1, dispensed with. Yes, notice to the other respondent.
serial number 24,
The appellant in this case, my lord, filing a memo for dispensation of R1, my lord.
Yes, R1 notice dispensed with. Notice to the other respondents.
serial number 25, V.K. Narayan Swamy,
Delay only 37 days delay. Application.
Why memo is moved?
That's, it has not been posting up to 7.
For notice, you have moved a
And the
memo.
execution petition has been filed, that is why.
Yes, notice. Next 26.
serial number 26,
And for petitioner, my lord, that trial court have been ordered directly with, because The reason is the petitioner is 80% disability is there, my lord.
Hmm.
For the reason,
How much is the maintenance awarded?
petition number for respondent number 1, 3,000, 2, 3,000 they have been ordered, my lord. The disability,
Corner number one,
the set 3,000, my lord. 2, 3,000.
have you contested the matter?
No, my lord, because of the disability, together with that, they have been filed
Age?
partition suit.
What is the age?
Is a 6 years, my lord.
Age of the petitioner?
Petitioner age is 40.
What is the disability?
41, my lord.
What is the disability?
Blindness, my lord. 80% blindness. The certificate it is there, my lord.
That's the whole
Is in a
difficulty. You are
visibility, absolutely.
you 80% disability, with that you are married.
No, my lord. For the reason she has got contact with other guy, and she is staying with the other guy, my lord. In relationship, they have been married. His own sister, daughter, my lord. They married.
It is submitted.
And partition suit also have been filed. They have been decreed. That is been decreed.
Granted 3,000 to the wife and the 3,000 to the child. And the petitioner is visually disabled. As per the disability certificate, the disability is 80%. Constitute the same history of all further proceedings on the condition that he shall pay 3,000. And the arrears also at 3,000 within 12 weeks. Notice to the respondent. Yes.
Number 27. 27 over 28. 27 and
28.
For the respondent, 27.
Yes.
28.
27.
27. V. Anand.
My lords, I have filed an appeal challenging the same order. I have also filed for enhancement, my lords. Both may be taken up.
You have moved the memo.
No, my lords.
List along with so and so, give the number after vacation.
Cell number 28.
This,
V. Rajanna.
yes, Ramana.
Ramana.
I am for petitioner. The petitioner is, the petition is coming to hearing on vacation of the interim order IA filed by the respondents on 12/8/2025. On that day, the session is by 12 o'clock started. We came to hear only 2 minutes late and dismissed for no representation. I have filed recall the order along with the interim.
We will hear the matter itself.
Please, ma'am.
Will not recall the order. Please argue. I'll hear the main writ petition itself.
Yes, ma'am.
Argue.
Okay. The petitioner is the husband of the
What, where is the
respondent.
impugned order?
Yes, ma'am. And also son also is there.
Come to the impugned order.
Yes, ma'am. Both are with the
Come to the impugned order, which page it is?
page number 58, 59.
This is in Kannada.
Yes, ma'am.
How much is granted?
5,000 to mother and 3,000 to child.
What is your income?
Mine, there is no any income. We are agriculturists. And also we have executed the gift deed in favor of the wife, 20 acres. All the document also filed before the Honorable Court, please. That is page number.
This is matter as part heard tomorrow. No representation for the respondent. Next.
Extend the interim order, please. That is,
Without recalling the order of
Yes, ma'am.
dismissal, how can the interim order be granted? I'm saying tomorrow.
already is there previously.
Tomorrow.
Yes.
Tomorrow I'll pass orders. Yes.
Cell number 29. Rakesh B. Bhatt.
Lord, I'm appealing to the respondent
Kindly
number
pass
1
over
and
the
2.
Kindly pass over the matter.
Lord, I may be permitted to file the synopsis yesterday, it was directed to file the documents. My lord.
Oh, yesterday's
Please,
matter.
Yesterday's.
Because again, there is a batch at 2:30. I can't take any passos today.
Now immediately the seniors will come. There is.
Please ask him to come, not
Please.
pass over, before 1:30.
Please.
Cell number 30.
Oblige me.
For the petitioner, my lord, the matter is settled. I filed the memo for withdrawal. I request this honorable court, my lord, as to direct the respondent to hand over the original papers. It's only my request.
I am for the respondent number 2, my lord. Since he is not the borrower, my lord.
Huh?
Since he is not the borrower to produce that original documents.
Huh? How can,
My lord, what is the due amount we paid the
who are you?
respondent? I am also one of the purchaser.
Only one property, my lord, that has been mortgaged to me. The same property only sold to the petitioner also. Now the petitioner has settled my dues.
That's why we
They
paid
are
the amount, my
asking for
lord.
the original documents. Now they are asking for the original documents.
Then when you have taken the money,
Yes,
what is the difficulty in giving the original documents?
That the original borrower is not the petitioner, my lord. If they come and ask me for
He's
the
a
original,
purchaser.
they
said
have
he's a-
purchased the property from someone else, my lord.
The
Not
senior
from
ಹೇಳಿದ್ದಾರೆ
that,
ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಆಗ್ಲಿ ಕೊಡಿಸ್ತೀವಿ ಅಂತ ನೀವು
Adre
ಪರ್ಮಿಷನ್
Then
ಮಾಡ್ತಿದ್ರಲ್ಲ.
why did you accept the money from somebody who is unconnected with the transaction?
my lord, if court directs me to produce the original document, we'll ready to.
I just can't take these submissions from the bank. As if bank is helpless. Whatever the court says the bank will do, no. Because money is, somebody is giving you money, you will take. But why will he pay the money? For somebody has borrowed the loan from you.
The same property has been mortgaged to me, my lord, also.
Why did you accept the money from him? Which bank is this?
That's Kotak Bank.
All kind of things the banks are doing. Now he will give you money, you will not give him the title deeds, and why he paid, why you take? Nothing, no basis for that. Where is the order of the court?
No, my lord, in between out of sight, they are entering agreement. They undertake to
Learned counsel for the petitioner submits that the petition is a bona fide purchaser of the subject property under a registered sale deed dated 28/11/2022 and has put up construction after availing the loan from the HDFC Bank. Then where is the direction to him to pay the money?
there is no direction, my lord.
Then why did you pay?
We are entered in the outside settlement. They have entered the agreement.
Then please settle all that
Thereafter,
outside.
my lord, they undertake to
How can the court say that to direct the bank to release the title deeds in favor of a person who is not a original borrower, who has not mortgaged the
kindly next week, my lord, we'll discuss with the senior, my lord.
list this matter after vacation?
Next Monday, my lord, we'll conclude.
Yes, Sarivan. What is that objection? Where is he?
Pass over.
What's his name?
Cell number 3, Nagaraj HR.
Call this. No, he was telling as if he is a claimant, owner of the vehicle.
Cell number 31.
Leadership, in this case, they are not here today, it seems. But firstly, I want to express my gratitude to leadership in this matter. What has happened is that earlier my son used to dump the Christmas gifts in the dustbin outside my office. Now he can't stop asking me for gifts. Every day he messages for a MacBook, for shoes, for gym wear. At least he's talking to me. And I'm giving him meals on a daily basis. Every single day I'm saying, but he doesn't want to meet me.
He doesn't want to?
He doesn't want to meet me. But every day I'm making meals, sending it to him, whatever he asks for, ocean water, etc., etc. But he's not meeting. So whether it is the fear of somebody, whether it's legal strategy, but leadership, it is parental alienation. Now, leadership, the fact of the matter is I want to just show one point. I have met the counsel personally on the 6th of this month and informed her that you did not come on the hearing and the matter is on the 11th. And also sent an email to her yesterday saying that this is the, if I may be permitted to send it to the court. Basically showing that these are the serial numbers of the case is listed tomorrow, marked to the counsel as well as the party, so that they can't take an excuse that they're not aware of the proceedings today in the court. Now, leadership, this case has leadership has already seen. I'll wish to argue.
Difficulty is court can't pass orders in this now. Today I have several matters.
Ladyship, the point, I will stay till tomorrow, ladyship, will take it up tomorrow. But the fact of the matter,
It's not tomorrow, I have a larger bench in the afternoon.
ladyship, this matter was listed last week also, ladyship said come on this
It's a
day.
2025 matter.
Ladyship, the fact is that
Every time you have been, you're completely, making a mention, and this is all coming up before the court out of turn.
ladyship, the fact is,
Well,
ladyship, I'm only, this is
no,
our
I
only hope.
understand, I understand,
This
but
is
you
the
have to
only
understand
court
that
which I hope from, ladyship.
if it is like my time permits in the next week, I'll see.
Ladyship, what
Otherwise,
is,
I can't take up this side of the vacation.
ladyship, the only issue is that there are four writs which are pending. One is for early hearing of the matrimonial case. One is for the
That I can't pass because it is a matter of which year, 20?
23, 22. But ladyship herself said that I should move an application striking of defense. That writ is also on that because she is not letting the child being met at all. Ladyship has also mentioned in the order that there is no compliance of the order passed by ladyship itself. So the fact of the matter is that we are just, spectators at their.
Before the family court also. Now they will not take up any of these matters.
But ladyship, the fact
hear
is,
these matters after vacation. What is going to
but ladyship, the only issue is that this has been pending for 5 years, this case. If ladyship says the guardianship case was filed in 2020, the marriage is 22 years, separation is 6 years,
GNWC is filed when?
2020.
That matter I can pass orders directing them, decide the matter expeditiously.
The fact of the matter is that they, for the MC case, on 6 consecutive days have not filed evidence. Now that 6 has become 12.
T20 matter will direct them to dispose of by March.
The fact is that one is the MC case, one is the GNWC case.
MC will not.
I have not moved an application for GNWC. I moved an application for MC. Reason being, ladyship, because that is the case where they are delaying the matter. There's been close to 12 adjournments they have taken, and ladyship has already
I'm
passed.
not passing any orders in this, in the matters which are MCs which are beyond 2019.
Ladyship will only pass an order in the first writ then. Writ is basically for shifting of custody, ladyship.
Shifting.
Ladyship, the fact is, ladyship, this is the only court where I can argue those points on parental alienation. I've got copious research articles by international journals on parental alienation.
Look at his age.
Ladyship, that is what I want to argue this point, because if it is a question of law that even a teenager, what is parental alienation, how it affects a teenager? And it's a myth. The article states that it's a myth that if the custody is reversed, it will be a bad effect on the child. It's a myth. It's a myth that if the child is removed.
Because I know that you will advance all these arguments. Now there is no time today.
But ladyship, I have got so much of, ladyship, have it tomorrow or any time today, ladyship.
So it's not possible.
We have come specially for this matter. Last time also we've been waiting. They see the number of dates in this matter, ladyship, which we were, every week it has been taken up.
After vacation, we'll see. Let's just matter after vacation.
Ladyship, but then at least fix a date in this matter, ladyship, because.
Let's just matter on, look at it. What is 11th of January? 12th.
Ladyship mentioned as the last opportunity because the other side will not.
Representation on behalf of the respondents from the last 2 occasions. Due to paucity of time, let's just matter on 12th of January.
Serial number 32.
12th of January. Grateful, ladyship. Thank you.
Yes.
Nagesh.
I'm the. My lordship,
What is this extension of custody time?
My lord, may kindly be passed over, my lord. The counsel and record is currently engaged in arguments in another court.
No passover. Let him come. I'll take it. It has to be before 2:30.
Please, my lord.
Before 1:30.
Short passover.
Yes, short passover.
My lordship, I want to mention that my vacation custody, there is a stay on it because the mother has refused to undergo this Niman. So I hope they make it.
Short
Yes, my
passover.
lord. Yeah, I hope they make it by.
Grateful.
Yes.
Serial number 33. Lakshmikant K.
I'm for the petitioner, my lord.
Lord, interim order, your lordship has passed on 10/11. The order is that before 5th of this month, my lord, he ought to have paid 20,000 rupees, not paid till today.
My lord, the order is
Single
within
paisa is
8
paid.
weeks, my lord.
8 weeks is the
not due,
arrears.
Lord.
Arrears, your lordship said within 8
Let's
weeks.
look at the order.
Please, my lord.
This order is passed on 10/11/2025.
Yes, my lord.
Then you should have paid some amount by 5th of December. Have you paid?
No, my lord, there is a 8 weeks time.
20,000 per month. 8
Per
weeks is for the arrears.
Arrears.
Then what about 20,000 by 5th of this month? I said 5th of every succeeding month, you should pay the amount 20,000 and arrears also at 20,000.
I will pay arrears along with, this also, madam. I will pay this amount
you
also
can-
along with the arrears.
It is not as per your wish and will that you will pay
A little bit confusion in the reading.
tomorrow. I'll list this matter tomorrow. By
My
tomorrow,
lord,
if you are not paid, I'll
My lord,
vacate the
Monday, my lord, please.
List the matter on Monday. By the time the amount of 20,000 is not paid, the stay granted by this court will be vacated and on that ground, the writ petition will be dismissed.
Please,
Yes.
madam.
Till number 34.
When you take the interim order, it's happy. When the time comes to pay, you will not pay.
I
Yes.
apply, madam.
34. Mahabaleshwara.
For respondent, my lords, as on date, 48,77,692 is outstanding.
48 lakhs?
77,692.
Yes.
Just for a moment, page 12, my lords, my account statement. They have regularized my account. They show that my installment overdue is 0. My account status is active. Right, well,
Which page?
Page 12, my lords. First page of my account statement.
When the account was declared NPA?
8/5/2025, my lords.
8/5?
2025. Subsequent to that, my lords, 5/8.
Let's see, 8/5/2025.
Notes, that is on page number 19, my lords. As on that day, my lords, the POS was 46,19,627. The notice that
Where do you get the dates on this page number 19?
My lords, page number 19, and in fourth column, my lords, dates
8/4/2025.
8/5/2025.
8/5.
Yes, my lords. Page number 19, last but third column, my lords. That is when they have stated my account has become NPA.
Then what happened?
Then, my lords, at page number 24, my lords, on page 23, last but second column, 2/12/2025, 1,15,604. My account has been regularized on that day. I have paid all the overdues. And their statement.
What are your
it left-
instructions?
It left.
I'll take instructions, madam.
Let them not dispute it because
Lend counsel for the petitioner, submit sir.
tomorrow they
Though-
are telling that they will take.
Lend counsel for the petitioner, submit sir. Though there is no dues, still it is stated that the account is declared as NPA on 8/5/2025. It is submitted that the account
Has been regularized.
was regularized when?
Notes on payment of that amount.
When?
212, my lords,
No, no.
1,15,000.
It is submitted that the account was declared as NPA on 8/5/2025. And later, on payment of the due amount, the account was regularized on?
In the month of this month only, my lords. 212 I paid. I don't know when they have regularized, but it shows there is no overdue.
They have regularized
Status
the
is
account
active.
in the month of
This
November,
month.
December.
December.
It is submitted that now the petitioners, what is the stage now? Notice is issued.
Notice is issued, section 14 order is passed. They have to take the physical possession.
It is
They are
submitted
telling
that
tomorrow they
now
will take it.
that the petitioner, the respondents are trying to take the physical possession of the property. Land counsel appearing for the respondents of the side. He'll get instructions. Till and considering the submission and the fact that that there is no outstanding outstanding dues, they shall be stay of the respondent bank shall not take any coercive steps till the next date of hearing. This matter immediately after vacation.
Great.
Yes, certified.
V. Suresh.
V. Suresh is directed
Great.
to take notice. You should have, name should have been printed. It is already there. Yes, print the name of Mr. V. Suresh. Yes, 35.
Till number 35.
Hearing, my lords,
Sincerely,
for the petitioners, my lord. This is your lordship recollect the subvention scheme, my lords, between the builder, buyer and the bank.
Huh.
So this, my lords, a fresh matter. in
This
which I-
coming up the list, the batch is there in the afternoon. This also along with the batch.
Please, my lords. Meanwhile, my lords, there is a division bench order as well as Supreme Court order to maintain status quo.
With regard to what?
With regard to the interim order, my lords, with respect to petitioner number 3, they have already initiated the DRT proceedings, my lords. So,
No, let this also go in the afternoon, we see, along with other matters.
please, my lord, but meanwhile,
No,
your
let's see in
lordships
the
will be burdened
afternoon,
in.
afternoon. Yes.
till number
Please.
36. 36.
Madam, for
Mario
the
Noel,
petitioner, my lord, agree by the visitation order, my lord, we have filed this appeal. My lord.
Anchor is but for the caveator. You have served
Yes,
copy on it?
reserved a copy.
Yes, what is
My lord,
this?
what has happened is the child is only 2 years old, my lord. They have passed a visitation order for the child to come to the visitation center. Every time the child comes, my lord, the next day she's falling ill or having some concern, my lord. The problem is from the time she was conceived, the father has not been in touch with her. He has not paid any money as well. There are 2 criminal cases.
These are all the general arguments. Any
No.
specific thing that the court should alter the
My lord,
investigation?
the only request is he's got 2 criminal cases as well on him, my lord. He's a complete bad influence on the child, my lord.
How? In the
No.
visitation center?
My lord, in the visitation center, he's just coming, giving whatever food he wants to the child. We have requested him that she's only a 2-year-old child. My lord, he's bringing sweets and other things and giving the child. He's just not listening to anybody, my lord. My lord, such a case, it's completely affecting the child, my lord. Any kind of physical interaction with him, she's just running away.
What is that? Any
So
kind of?
whenever he goes to the child, she's running away, my lord. She doesn't want to have anything to do with him. My only prayer is let the matter be referred to mediation. This visitation order may be stayed. Let any outcome be decided over there. They can both comply, my lord.
What is the media? How it will have an impact on this? Even
No, let them.
whether mediation success or mediation is a failure,
Yes.
this remains to be the
This
same.
will be there, my lord. But at least maybe through online visitation or something, she can get familiarized with the father, and then they can take it forward, my lord. My lord, at least for 6 months, let her see the father through visitation. I mean, through online visitation. After that, my lord, they may go for physical, my lord. My lord, she's only 1.5-year-old. Let her get familiarized with the father. Let her see through video.
This is the age where she'll get familiarized with the father by meeting person.
Correct. My lord, that's what we also thought, my lord. We have taken her for visitation, but it's having an adverse effect on her, my lord.
Why it will have an adverse effect?
That's what, my lord. She doesn't know him from the time she's born.
So many people, everybody, the child meets every day, not necessarily that she should know from her day-to-day life or
Right now,
from her
only her
birth.
mother and grandfather she knows, my lord. If she sees him through video, my lord, at least for 2 months, let them
So
do
if you
through
send
video.
her to the school, the teacher and all, she should be knowing from
No,
her
my lord,
birth.
that's the problem. She's not going to school, my lord. My lord, for 2 months at least, till after vacation, let her see the father through video.
No.
We will make through video. After that, let her meet him, my lord. My lord, only just let her get familiarized with the father for 2 months. After that, we will continue the
Let her
physical.
get it this way.
My lord,
That is
here
good
it's
for
having
her.
an adverse effect, my lord. That's
No
the only
adverse
problem.
effect will be there. Yeah. Adverse effect on the mother might be, but not on the
Not
child.
mother, my lord. She's taking a dislike to the father. Every time she sees him, she's running away. So it's
Why should
defeating.
she? That's what I'm saying. Why? It is not a normal conduct of a girl of 1.5 years or 2 years, as you're saying, unless and until there is a tutoring from you.
No, we are not tutoring, my lord. We want her to meet, but the only thing is, we were thinking if she sees through video, she'll get familiarized with him. Then they can have the physical visitation, my lord. At least for 2 weeks, let them see through video, my lord. That's
No,
our
no.
only. My lord, at least for 2 weeks, let them see through video. After that, we will do, my lord. After vacation.
Out of
we
all
can-
your arguments, only one direction one modification I can make is that he shall not give the other like eatables and all which are not good for the child. Except that I can't modify the order.
My lord, only we are requesting is for video visitation for at least 2 weeks. After vacation, let them, at least he'll get familiarized with the father, my lord. My lord, through video, let him see as per first and third Saturday. Let it go on only for 1 month. After that, we'll come and make a submission here. By then, they will also may come, my lord. Only for 2 weeks till.
A child of 1.5 years will sit before the video and will interact with the father
No,
for 1 hour.
now they are doing that, my lord. Whenever the child is not well, she's looking at the father through video. They are doing talking, my lord. My only request is that same liberty may be given for the other 2 dates as well. Till after vacation. After that, she will see the father, my lord.
Take a chance after vacation. This is matter after vacation.
Cell number 37, Chandrasekhar Patil.
My lord, sir. The impugned order is passed in 125 subclass 3 proceedings.
How much is granted?
80,000 rupees per month is granted, my lords.
Why she is before the court seeking enhancement?
No, this is a petition wherein IA number 9 and 10 are filed by the respondent husband seeking visitation and custody rights of the minor daughter in a 125 subclass 3 proceedings, my lords. By impugned order, Honorable Family Court has granted visitation custody rights to the father every alternative Sunday from 10 a.m. to 5 p.m. my lords. That is the impugned order which we have challenged. Now arrears of maintenance more than 40 lakh is due and pending. And at this juncture, he comes up with multiple application in the main petition, 125 petition, as well as implementation petition, only in order to change the course of the matter. And in addition to that, he was directed to pay the school fee of the child, which he did not pay after some time, after the passing of the attaining finality of the order passed in main petition, my lords.
Main petition means
125 proceedings.
125 proceedings are concluded.
It is not yet concluded. On IA number 2, a sum of rupees 60,000 rupees was ordered, granted to the petitioner and her daughter, my lords. Subsequently, it was announced by this honorable court to 80,000 rupees, 60 to the mother and 20 to the child. In addition to that, since he had undertaken to pay the school fee, this maintenance amount was granted to us. Subsequently, he had went before the apex court, wherein his SLP got dismissed, my lords, without granting leave. And now the amount of more than 40 lakh, now it is 45 lakh, which is due, and he has not paid a single pi. And in the execution petition, implementation petition, he comes up with the IAs, multiple IAs.
Execution petition.
In the execution petition, these IAs are filed, my lords.
Where is that order?
Order is at page number 15 is the order sheet. And in addition to this, he also files GNWC petition, wherein IA number 1 and 2 in the GNWC petition is the similar applications. Page number 16 is the order starts from page number 16.
Which court is this?
Principal Family Court, Bangalore, my lords.
Which page is the order?
Order starts from page number 16. It is written in the order sheet itself. On a common order is passed on IA number 9 and 10. One is sought for custody, the other one is sought for visitation rights.
The two applications are filed by the
Two applications are filed by the
respondent
respondent husband.
under section 10 of the Family Courts Act.
Yes, my lords.
That is section 21 of the Protection of Women.
Yes.
You are saying that it is filed in the execution case.
In the execution petition.
In your execution, he files these
He
two
files
applications.
these two applications
And they are entertained.
and granted with the visitation rights.
Please come. The present writ petition is filed. Agreed with the orders passed by the family court, wherein the court has allowed I number 9 and 10 filed by the husband under section 10 of the Family Court Act, read with section 21 of the Protection of Women from Domestic Violence Act, read with section 151 of the CPC, whereby the father is permitted to take custody of the child from the house of the mother on every alternative Sunday at 10 a.m. and hand over the custody in the same day evening at 5 p.m. On Saturday, if the child has got any activities, it is the responsibility of the father to take the child to such activities. Learned counsel appearing for the petitioner mother submits that the mother has filed the criminal miscellaneous number
408 of 2019.
408 of 2019 seeking maintenance, and the order was passed granting maintenance of an amount of rupees 60,000, and the same was questioned before this court, and this court has enhanced the same to 80,000 as the father was also ready to take care of the educational expenses of the child. It is submitted that the said order is assailed before the Honorable Apex Court and the same was dismissed. Thereafter, the wife had filed the miscellaneous seeking miscellaneous for execution. It is submitted that in that the husband has filed 2 IAs where the outstanding is running into
45 lakh now.
Running into 45 lakhs. It is submitted that the family court, and when the husband has come before the family court in the execution petition, by filing an application under seeking custody, the court, without considering all these facts, has granted the custody. It is submitted that the court has no jurisdiction to grant the custody of the child in the execution proceedings, considering the submission of the learned counsel for the petitioner and the fact that in a execution petition where 45 lakhs is outstanding, when an application is filed by the father seeking visitation, court ought not to have passed such an order. Hence, there shall be stay of all further proceedings pursuant to the order dated 16/9/2025. The petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 12th of January. If the memo is not filed by that day, the stay granted by this court stands vacated.
My lords,
Yes.
further proceeding, order may be stayed, my lords, because
The proceedings pursuant to this order.
yes, ma'am.
I have not stayed the execution proceeding.
Grateful.
Have you asked her? When is it? What she says? No, last time you said, again, why did she pass this? When did you put, when did you inform her last time? No, when is that? This order is passed when? For appearance of parties and their parents for, this is on 17th October. Oh. Because she can't have these kind of repeated complaints. Yes. Where is this advocate is there?
It is Nageshri, passed over at serial number 10. No.
Yes.
Serial number 38.
38, I am appearing for the petitioners, my lordship. My lordship, the case against the petitioner is that, my lordship, the trial court has passed a rupees 10,000 rupees monthly maintenance to the wife and child, my lordship.
What is your salary?
My salary is 14,500, my lordship.
14 or 40?
14,500, my lordship.
Hmm.
And she is earning 15,000, my lordship.
Where do you get that?
My lordship,
Please come to
kindly
the-
peruse, my lordship, at page number, kindly peruse the page number, my lordship. Page number 34, my lordship. Monthly income 14,500, 2,000 rupees 11 cents, my lordship, other 11 cents. He's getting
Since last more than 12 years, respondent has been working in no, where is her salary?
Her salary is, my
I have
lordship, at
limited
page number,
source
my
of
lordship.
income of 15,000 per month.
At page number 38, my lordship.
Come to the impugned order.
Impugned order at page number 82, my lordship. IA is filed by the petitioner under section 24 of Hindu Marriage Act is hereby allowed in the part. The respondent is hereby directed to pay the interim maintenance to the true turn of 10,000 rupees per month.
Where did the court discuss about your income in the order?
My lordship, at page number. It has not been discussed in that way, my lordship. It is at least discussed here, my lordship, with regard to the at page number para number 3, my lordship. At page number 71, it starts, my lordship. The respondent has filed objections to the said IA, my lordship. At para number 3, my lordship, of the impugned order, my lordship.
Yes.
The respondent has filed an objection to the said IA number 2, wherein he has denied all the averments made in the applications and the contended that he is working as supervisor.
Yes.
As supervisor, hardware shop.
Supervisor at hardware shop
Yes,
and
ma'am.
drawing monthly salary of 14,500 will be allowances of rupees 2,000 per month.
My lordship, her salary is, my lordship, at 38 page number, her salary. At page number 38, my lordship, her salary, it shows the monthly income as mentioned at serial number, my lordship, at 15,000, my lordship. Tailoring she is doing, my lordship. She is leading lavishing life, my lordship. She is paying 15,000 for rent, my lordship. in
You're
that year.
having FD of 10 lakhs, where
That is-
your share is 5 lakhs.
Yes, my lordship. That also I have mentioned, my lordship. at-
And amount of rupees 3,50,000, he has also.
Those are
produced.
all things, my lordship. I have actually got a land, my lordship. I was supposed to build my house, my lordship. For that, I have made a FT, my lordship, wherein these, the respondent herself is a nominee, my lordship. My child is a nominee and my respondent is a nominee, my lordship, for each and everything.
When counsel appearing for the petition submits that the court has granted interim maintenance of an amount of rupees 10,000 per month to the respondent and the child. It is submitted that his income is 14,500
And
and
2,000.
allowances of 2,000, that is 16,500. The wife is getting income of an amount of rupees 15,000 and the court had granted the 10,000 maintenance, which the petition is not in a position to pay. Considering the same, there shall be stay of all further proceedings. 5,000. Arrears also at 5,000. That 5,000 by 5th of every succeeding month. The petitioner shall take out hand summons and file a memo to that effect by 12th of January, or else on that ground also, the stay granted by this court stands vacant. Yes, 39.
Much obliged.
Murali PS. 39.
I pay for the petitioners. Petitioner, not a senior citizen, is the auction purchaser of one of the site, which was
Which is the bank?
Union Bank of India.
Yes, Union Bank of India, who appears?
Divya Purandar, Vignesh Shetty.
What is the name?
Vignesh Shetty, Divya Purandar.
Vignesh Shetty is directed to take notice of the papers on him. Is this matter after vacation? This is a matter on Wednesday.
Please.
Serial
Yes.
number 40.
Let's have a copy.
MC Ravi Kumar.
2 weeks time may be granted to file a objection, statement of objection, my lordship.
Let's hear them first.
Day before yesterday.
Representation on behalf of the petitioner. List this matter after vacation. Yes, 41.
41. Is still there?
Question the order of maintenance. The court has granted 15,000 each to my children, 2 children.
30,000.
30,000.
What is the age?
Lord, one is a major, around 19 years. The other one is 14 years. Lord, the
Girl or a boy?
major is the girl.
Hmm.
Lord, the issue, my lord, is what I'm earning, my lord, is comparatively less than what my wife is earning. The court,
How much you are earning?
my lord, kindly see para 18, my lord.
No, you can tell the court how much you are earning.
My lord, annual income for the previous year, my lord, is 1,15,000, my lord.
Annual income.
Annual income, my lord. In fact, she has dispossessed me. I'm staying in
15,000.
1,15,000, my lord.
And what is her income?
Her income, my lord, is 4,92,000, my lord. Paragraph.
Annually.
Yes, annual income. Paragraph 18, my lord.
Come to the order. Where is the order?
Annexure A, my lord, it starts from page 21. Paragraph 18, if I, my lord's attention, page 37.
Hmm.
Petitioner has produced copies of his income tax returns for the assessment year so and so. As per the said documents, the total income of the petitioner in the aforesaid assessment years was rupees 3,31,000 change, 2,39,000 change, and 1,15,000 respectively. Petitioner also produced copies of the income tax returns of the respondent for the assessment year so and so. As per the said document, the total income of the respondent is so and so. The petitioner also produced copy of the memorandum of deposit of title deeds.
It takes 3,31,000, 2,39,000, 1,15,000.
Yes.
What do you do? Why is it coming down?
My lord, I am working in a private company, my lord, small self-owned this one. And on the contrary, she is running event management and she has dispossessed me. I am staying in a PG. My mother is staying in an old age home. Para 19, she had borrowed a loan and she admits that fact that the loan is borrowed for her and I am repaying that loan. Para 19, my lord. Then para 20, that on perusal of the entire material on record, at this stage, it can be prima facie inferred that the petitioner owns immovable property and is self-employed. Likewise, the respondent is also self-employed and owns immovable property. In her affidavit annexed to this application, the respondent has clearly stated that the house in which she is residing is the ancestral property purchased by her father-in-law. Since the respondent is also earning, she owns immovable property and she is residing in the house of the respondent. At this stage, I am of the opinion that respondent is not entitled for interim maintenance, but the children of the parties are entitled.
The court has granted 15,000 each maintenance to both the children. It is submitted that his annual income is 1,15,000.
Yes, my lord, 1,50,000.
And the wife's annual income is 4,92,000. The wife is staying in the house belonging to the petitioner.
Yes, ma'am.
And but petitioner, it is submitted that the petitioner is residing in a PG. The court, without considering all these aspects, had granted an amount of rupees 15,000 each. Considering the submission, there shall be stay of all further proceedings on the condition that the petitioner shall pay 5,000 each to both the children by 5th of every succeeding month, and the arrears also at the same within 12 weeks. Notice to the same hand summons.
Yes, my lord.
By 12th of January, you should file the memo,
Yeah, I'll do that.
or else the stay granted by this court stands vacant.
Lord, I am the petitioner before the MC case. Let the proceedings go on, my lord. Only.
The only pursuant
Yes,
to this
yes.
order, I will never stay the MC proceedings.
Yes,
Cell number 42,
deeply
Nitin
obliged.
Kumar, for petitioner.
My lords, appearing for petitioner, my lords. My lords, and the writ petition is filed for the stay of the possession notice, my lords, which has been issued by the respondent bank on 6/11/2025, my lords. My lords, day before yesterday, my lords, they have taken the physical position, my lords. In lieu with that, my lords, yesterday I have filed an IA for release of the position, my lords.
Please
And
have to notice us to go to the respondent. Please take out hand summons. Petition is permitted to take out hand summons on the respondent. If the memo is filed, list this, whenever the memo is filed, list the matter.
Cell number 43, Nafis. Aziz.
I'm for the petitioners in the matter, your lordships. I'm challenging the possession notice, your lordships.
Yes, Union Bank.
Vignesh Shetty is,
Yes, Shetty is directed to take.
your
notice.
lordship, I'm ready to deposit 25% of the loan
No,
amount.
no, with 25%, I will not grant any interim order.
Yes, your lordship.
Yes, notice to the respondent.
Any date might be fixed.
The petition shall serve the copy of the writ petition on the
Yes, your
count on
lordships.
Mr. Vignesh Shetty. This is matter on Tuesday.
Much obliged.
Cell
Yes,
number
44.
44, Kiran Kumar.
No representation after vacation.
Cell number 45,
So if you're not arising out of maintenance proceedings, my lords, my 311 application comes to be dismissed and sent before this honorable court, my lords. On 2 occasions, I've cross-examined, and when I seek a date, my lords, it was dismissed.
Where is the order?
Only for further cross-mail.
Where is the order?
My lords, page number 20, my lords, showing page number 20. Was the reason assigned was, my lords, the advocate was supposed to cross-examine was held up before the Kalburgi bench of this honorable court, my lords. That was the reason.
Let's see.
Please,
Let's
please,
read
please.
where it is.
Page number 20, my lords.
Please read. the
Order dated 14/8/2025, my lords.
Please read.
Was the relevant portion, my lords. Page number 20, last para, my lords. Now, by filing this application under section 311 of CRPC, learned counsel for the respondent intends to recall PW1 for cross-examination on the grounds that the respondent counsel was at Kalburgi High Court and was unable to appear before the court on 7/7. That is the reason I
It
said.
appears that, let us read this. It
Please.
appears that
Please.
matter is being pending at page number 21. It appears that matter is being pending for cross-examination of PW1 from 19/4/2024.
Please.
The cross of PW1 was taken as nil on 24/8/2024, and thereafter the matter was posted for respondent evidence. On 21/11/2024 was recalled, but it is not completed till 7/7/2025. Again on 7/7/2025, due to absence of the respondent and his counsel, further cross-examination was taken as nil. On 22/7/2025, again the respondent was absent and counsel for the respondent sought time for respondent evidence. Now, by filing this application under section so and so, why should we entertain?
That's one opportunity. My lords,
This kind of practices we will not entertain.
That's difficult.
Court has given a reasoning why it is dismissed, and it is a valid reason. Please
My
come.
lords, since on that particular date, my lords, on
It is not
7,
about a particular day. It is about what's happening from December.
my lords,
I
even
mean,
on the
from-
merits,
From
even,
2024.
please, my humble submission, even on the interim application, my lords, interim application of the petition was dismissed, my lords. The interim application was filed by the wife. On that ground also, my lords, I have a very good case on merits, my lords. And
If
one
you have a very good case, you should have pursued it.
only for
Agreed with
further
order
cross,
dated
my lords.
15/8,
And
2024.
my lords, even the respondent had delayed conduct of the examination. my
Court
lords.
has already given a long rope to you. No further time can be granted. Agreed with
Plus
orders passed.
one
on-
last opportunity, my lords.
No.
Any
Agreed with
specific
orders
date may
passed
be
on
given?
14/8/2028. Whereby the court had dismissed an application that is filed by the petitioner under section 311 CPC CRPC. The petition is before this court. Learned counsel appearing for the petitioner submits that as her advocate was in Kalburgi, on the day they could not cross-examine. The court cross-examine as such they have come up with an application to recall the stage and reopen the case for cross of PW1. But the court without considering the same had dismissed the petition. Next para. Having heard the counsel for the petitioner peruse the order impugned dated 14/8/2025. The court has observed that the petitioner who is a respondent before the court has filed an application under section 311 of CRPC seeking recall of the stage and reopen the case for cross of PW1. As per the order sheet, it reveals that matter is being pending for cross-examination of PW1 from 19/4/2024. The cross of PW1 is taken as nil on 24/8/2024, and thereafter the matter was posted for respondent evidence. On 2/11/2024, again it was recalled, but it is not completed till 7/7/2025. Again on 7/7/2025, due to absence of the petitioner herein and his counsel, further cross-examination was taken as nil on 22/7/2025. Again, the respondent was absent and counsel for the respondent sought time. Again, not the respondent, again the petitioner was absent and counsel for the petitioner sought time for the evidence. Thereafter, this application is filed under section 311 of CRPC. The counsel for the petitioner intends to recall PW1 for cross-examination on the ground that the respondent's counsel was at Kalburgi High Court and he was unable to appear before the court on 7/7/2025. The court has observed that the reasons that are stated by the respondent is not satisfactory. Already sufficient time is granted. No good grounds to recall PW1. Hence, the application is dismissed. Next para. This court has perused the order passed by the family court. The family court has given enough time for the has given time to the petitioner to cross-examine PW1. In fact, even on the earlier occasions also, when the cross-examination of the PW1 was recorded, was closed as nil. Again, on the application made by the petitioner, the court has accommodated and reopened the case. The litigant who is not vigilant and who is not pursuing the matter diligently is not entitled for any relief from the court. Hence, this court finds no illegality with the order that is impugned, that the order passed by the family court. Accordingly, the petition is dismissed.
Bill number 46, Mara petitioner.
Yes.
The petitioner is availed a
Who
loan.
appears for the respondent?
No, Shriram Finance.
Take out hand summons. The
My lord, I
petitioner.
have given a representation to for one-time settlement. They are not considered my representation in spite
It
of
can't be a mandamus to consider one-time.
13(3) of the act, my lord. If I given a representation, they
The
have to
petition
consider
is
within 15
permitted to
days.
take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. Once the memo is filed, list the matter.
Some protection may be given, my lord. Till then, the possession notice already issued. If they taken a possession of the property, then I have paid.
If you want to take the hand summons, you give a memo, it will be listed this side of the vacation.
Bill number
Yes.
47.
I am permitted to move the matter in if the matter is served in the vacation.
Yes, that's what I said. The moment you file the memo, it should be listed. If it is not listed, you move it. Court will take.
Surendra Kumar R. N.
Appear for petitioner.
Yes.
The respondent bank has issued a notice.
Yes, Karnataka Bank who appears.
One submission, my lord. The scheduled action is fixed on 13/12. There is urgency in the matter.
But if 13/12 is, what is today?
It's 11th, my lord.
The so-and-so. Who appears for Karnataka Bank?
Karnataka Divya Purandar.
Divya Purandar is directed to take notice on behalf of the respondent bank. Land counsel shall serve the copy on the counsel list the matter tomorrow.
Bill number 48.
Yes.
Short passover, seniors on his legs.
Mahabali-
Before 1:30, will be.
For a Passover. Very well. Passover is not at, because 2:30 there is a
Yes.
batch. I'll take it up around 1 o'clock.
Very well.
Get from.
Yes, next.
Cell number 49 for admission matters.
I applied for a respondent number 1.
Appearing for petitioner. My lordship, for the
Papers are
settlement, for this settlement, kindly refer to the Lok Adalat. ma'am.
Yes, refer this matter to the Lok Adalat.
Cell number 50.
I am for applying my insurance company challenging on the ground of liability. Limitation barred by time.
When was the accident?
Accident occurred on 15/9/2022.
59?
2022.
What is the delay?
6 months, my lords. The
It is
claim petition
submitted
filed
that
on
the accident had taken place.
9/9/2023.
The claim petition is filed with a delay of 6 days.
6 months, my lord.
6 months, and it's not maintainable. It is submitted that the court had failed to consider the same. Considering the same, there shall be stay of all further proceedings, 50%,
Please, my lords.
4
Madam.
weeks. Notice to the respondent, 51.
Cell number 51.
Notice.
Notice to R2 kindly be dismissed.
Memo is filed seeking dispensation or notice to R2 dispense with the notice to the other respondent.
Cell
Yes,
number
52.
52. Cell number 52.
Don't write other respondent. Look at it, whoever is the respondent, write that. 52.
Cell number 52. Muralidhar N.
No representation. List this matter after vacation.
Cell number 53.
I appear for appointment. Notice to R2 kindly be dismissed.
R2 notice dispensed with, notice to the other respondent. Yes,
Cell
54.
number 54.
Notice dispense for R1.
54.
R1 dispensed with, notice to the other respondent. Yes, 55.
Cell number 55. Cell number
Notice to the respondent. 56.
Cell number 56. Alesh.
Notice to the respondent.
Cell number 57.
Respondent, madam. Copy is.
RPFC. Yes. Manjunath, the respondent
Balakund, yes,
party.
my lord. Manjunath Balakund.
Party in person.
Yes, my lord.
Hmm.
I am for respondent, my lord. Copy has to give that some documents have been produced.
Respondent party in person.
No, no, it says it is party in person.
Basavaraj Godachi.
Petitioner, my lord. I am for,
No, no.
oh, sorry, my lord. I am petitioner, he is the respondent. Proxy counsel I am for the reason.
It can be adjourned after vacation?
Kindly, my lord.
Yes, no representation under the party in person. This is matter after vacation. Is 58?
Cell number 58. 58.
Kindly, short accommodation.
Huh?
Short accommodation.
Yes, after vacation. Yes, 59.
59. Cell
No
number
representation
59.
after vacation.
Cell number 60.
Yes, after vacation.
My lord, in this matter, matter has been compromised, my lord.
Which one?
Reporting 60, still number 60.
Huh.
60. Another council has been present, please, ma'am.
Hmm?
Kindly short passover for the 17.
Come before one.
Please, please, ma'am.
64. Cell number 61. 61. B. Ravindra.
No representation after vacation.
Cell number 62. Vinod Kumar.
No representation after vacation.
Cell number 63.
Let's-
Physical hearing B group.
Your lordship, this is
Mr.
the matter
Arun.
wherein an interim order, conditional order was passed. That has not been complied with. Subsequently, again, before your lordships, they have taken and they have incorrectly mentioned, and your lordship has passed an order to not take coercive steps. Based on that now, they are not paying maintenance. They have not complied with the earlier
Let's-
order.
It
And
Can
your
can it be
lordship-
taken up on Monday, my lords? Mr. Arun Govindraj, my lords, is indisposed of today, is unwell. If it can be taken up on Monday, my lords,
Monday,
please.
Monday. Tuesday, any day.
Please.
Please, your lordship. When, Monday or Tuesday? Monday, your lordship, my time.
Monday.
Yes, next.
Interim order, my lord, maybe.
Interim order, all your granted is extended. This
Cell
is
number 64.
Take this matter before this court, Lordship. There's no urgency as such. Because already the visitation has been taking place, Lordship. There's no urgency as such in this matter. May I have it after vacation, Lordship.
Kindly pass over.
No, what is the urgency now? The visitation is going on.
No, my lord, we have filed to IS. The paramount importance is the welfare of the child. She has a little cognitive difficulty. We filed 2 IS. One is for change of therapy center and the other to permit us to take him to.
The
take
copies
child
have
to
not
the
been served
doctor.
to us, Lordship, with regard to this.
My senior is.
Let them serve the copy, then the list, date will be
copies
fixed on
only.
this, lordships.
We've served the copies.
He says here it is not served, the IA copy.
We served it through email.
No, I have not received any email, lordships.
Just 1 minute. Senior is.
We have made this application, Lord, so that
Say that the papers were not, the IA copies were not served on them.
I can give them one more set immediately. Madam.
We will have to have this matter tomorrow.
Please, madam.
Give the papers to them.
Yes, madam. Immediately.
Yes, next.
Then number 65,
Nale.
Yes, 65.
then number 65, Garam, see.
Petitioner. The second round litigation, my lord, as after the order passed by your lordship. My lord, may kindly see the order passed by your lordship at the earlier point of time, my lord, on the same line regarding maintenance, my lord. There are 23, my lord.
Para 23 of the
23 of the writ petition, your lordship. Order passed by your lordship. Annexure A, my lord. Para 23 minutes. Annexure A. Para 23. The entire document placed on record, my lord, may kindly see. Before the court, if appreciated, in totally clearly shows that the respondent is highly qualified, that she is capable of fetching suitable job. The respondent has not assigned any satisfactory reason as to why she is not making any efforts to fetch suitable job to meet her needs. The respondent, with reference to the amount credited to her bank account on 14/12/2001, so and so dates, at Axis Bank, contended that she borrowed hand loan from her brother for her living expenses, which cannot be disbelieved. In the light of her resignation letter dated 1/11/2021, which is
he was directed to pay 20,000 per month.
20,000, your lordship. That was that order, my lord. Your lordship was pleased to set aside, my lord, because there was no application of mine, my lord, while passing the order. Kindly see the order passed. That order passed by your lordship. You get it, my lord? Yes. I'm sorry. That order, my lord, came to be set aside. Annexure G2, my lord.
Page number.
Page number 106, your lordship. 106. Para 5, my lord. Page 108, my lord, relevant page, your lordship. The court below has directed the husband to pay a sum of rupees for amount of rupees 20,000 per month towards the maintenance of the respondent wife from the date of application during the pendency of the proceedings or till she secures a suitable job, whichever is earlier. While passing the said order, the court below has observed that wife withheld the relevant document and failed to produce the copy of the bank account, which she maintained in HDFC Bank before the court below, even though she referred to the same in her affidavit of assets and liabilities. The court below has also observed that withholding the relevant materials, documents needs to be taken into consideration in view of the specific contentions taken by the husband. The court below observed that the wife has not approached the court with clean hand and the adverse inference needs to be drawn. The learned advocate for the petitioner during the course of the argument dated 29/3/2023 submitted that in order to harass the husband, she quit her job and still she is leading lavish life, putting status to the effect that she is enjoying two jobs peacefully. The court below, having considered all this, as the husband is drawing 89,000 per month, and as there is no material on record to show that the wife is having an income, directed the husband to pay a maintenance of rupees 20,000 per month. Agreed then, thereby the husband is before this court. The relevant parameter, the para 9, your lordship. Para 9, relevant para, my lord, where my lord has observed. Para, having regard to the learned counsels on either side, pursuant to the, my lord got it, my lord. Peruse the entire material on record. There is no dispute about the educational qualifications of both the petitioner and the respondent. That is husband
After
and wife.
remand, where is the order?
My lord, without considering, my lord, the observation made by this honorable court.
Where is the order now?
And now, my lord, your lordship, again, the present order came to be passed, your lordship. At annexure. Yes. Page 96, your lordship, G1. G1, my lord. Relevant page, my lord. Para 8, my lord, may kindly see page under your lordship. She has not made any attempt, my lord, for last 4 years, my lord, to get the job. Para 8, your lordship. Page 100.
Where is the reasoning starts from which paragraph?
I am sorry, annexure A, my lord, may kindly take it up. Annexure A, my lord. This is the impugned order, your lordship. Dated 30 May 2024, my lord, which is under challenge, your lordship. Earlier order is that, my lord.
Where is the consideration by the court in spite of making a
Lords,
specific
Lords,
reference?
I would draw my lordship's attention towards page number 12, my lord. At the time, my lord, when the order, first order was passed, my lord, even, my lord, the husband has not filed the relevant documents. And there was a specific order by the court in the earlier petition saying that both the parties have to produce all the documents.
No.
So, my lord,
No,
the matter was
apart-
referred
no,
back.
Apart from saying that both the parties have to file their respective statement of assets and liabilities, court has recorded that she is having an account in HDFC Bank and those documents are not filed.
My lord, that was a wrong note submitted by the other side advocate, my lord, wherein, my lord, we have produced all the documents. My lord,
In the present order, paragraph 7, read it.
My lord, kindly turn to page number, my lord.
No, read paragraph.
Yeah, yes, my lord. Even, my lord, in the page number 1112, my lords.
Read paragraph number.
Yes, my lord. I know
7
that, my
At page
lord.
number 99.
Yes, my lord. I would take my lordship's attention towards 112, my lord.
What it says is the respondent furnished the particulars of her HDFC bank account in serial number 25 of para 1 of her affidavit of assets and liabilities. But she did not produce the bank account statement.
Yes, my lords.
So what was the court doing? When this court has specifically has noted that aspect, why the court had simply, and why the court said, why when she was working earlier, why she is not
My lord, kindly
working
turn to
now?
page number 63, my lords. It is not me, my lords, who has not produced a document. It is husband who has not filed relevant documents. Kindly page number 63, my lords. He himself has stated in his assets and liabilities affidavit saying that he has not produced bank statements.
Why?
No, we
May
have
kindly turn to
produced
page
a
number
lot.
63.
Why both of you are not
No,
filing
we
your-
have
Kindly
produced,
turn
your
to page
lordship.
number
That is the-
63, my
that-
lords.
That is the,
No, here it is.
Yes, my lords.
You are the one who is seeking maintenance.
Yes, my lords.
You are not complying with the judgment of the apex court in Rashish.
No, my lord, at that time, my lord, I had filed, my lord, the documents are with me, but somehow, my lord, it wrongly note has been taken that, my lord. And even, my lord, at page number 63, my lord.
One more observation by this court in the earlier order was,
Yes, my lord.
you were working and you stopped working after filing this maintenance application.
No, my lord.
No,
I have
said, what was she doing? What was her salary? Why she is not doing or why she is not able to get a job?
Lord, I was sent back to my parental home on the pretext of Ashada. When Ashada was completed, I called my husband saying that I wanted to come back. The scenario was completely changed. They said, no, they will not take me back. So, my lord, I got into depression. So I quit the job. And my lord, I worked previous to that, my lord, I was.
You quit the job. Where is
Lord,
your
I
explanation?
I have filed my resignation letter, my lords. In the second assets and liability documents, I have filed all the resignation letters. 3 resignation letters I have submitted. The last date of my job was 2021. Wherein, my lord, when I was constrained to be in my father's home, I went into depression because I thought a very beautiful life with my husband. So suddenly they made the change. They made their mind change. I should not go back to my marital home. It is a complete They hoisted a plan,
What is your qualification?
BMBA.
B, my lords.
So forever you have decided that with this depression, you will sit at home from 2020.
No, my lord, I am not in a position to work now because of my depression. The respondent is before your lordship, my lords. She is before the court, and and many times, my lord, in my office, I've told her to continue the job. No, she's telling that she is not in a position to do the job because she thought of living a very good life with the husband.
Then she should take some counseling, some therapy that is required, because it is not normal life. Everybody will get some problems or the other. For that person, for that reason, you can't go in depression and say, I will never work, I will have maintenance from my husband.
For doing a job, my lord, my mind should be conscious. I should be 100%
I can
perfect.
understand 1 day, 2 day, 1 year, but it is,
4 years.
MC is filed in 2020, we are in 2025.
Yes, my lords. When MC was filed, my lord, I did not file application. It was filed in the year 2021, after 1.5 years. Because when the atrocities have happened to me, then I have invoked this section. When I quit the job, I have invoked this section. Not to harass husband, I have filed this application. I have not filed this application to harass my husband.
Keep sitting at home idle from 21 to 25. It doesn't, don't appear to be a reasonable.
I might prepare myself for the for joining a job, my lord, but right now, my lord, I am not in a position to do, my lords. My lord, and wherein, my lord, my father has spent a number of amount for the marriage.
That you will get it. You file the MC. MC is filed, you will seek
Definitely,
for alimony
definitely, I am going to file all the documents, my lord. Wherein, my lord, presently, my lord. And my lord, I am also filing a medical document, my lord, if your lordship permits, my lord.
What is that?
It's a medical prescription, my lord, wherein, my lord, it shows that, my lord, I am taking treatment for my depression, anxiety, my lords.
Here. This is in the year 2021.
Yes, my lords.
So it remains to be the same from 21 to 25.
Continuing the same tablets even to this date.
Now, once this case is disposed of, once the MC itself is disposed of, then what she'll do?
She'll try to come out of the
She should have done it by this time.
trauma what she has undergone.
5 years. 5 long years.
But it takes time for a person to person, my lord, to come out of all this situation, my lords.
Yes.
Lord, 1 second, my lords. One second,
What
madam.
was she earning while she was working?
Sorry, my lords.
What was her salary while she was working?
She was working 30,000. She was drawing, my lords. And I have filed my second the list of documents. Last time she was working in a strategic outsourcing company and drawing a salary of 30,000 rupees per month.
What is the salary of the husband?
Husband is 94,000, my lords. 94,000 rupees, 912 rupees. Page number 63 of assets and liabilities, and page number 27.
What is the amount that is lying in your HDFC bank account?
No amount, my lord. 30 HDFC bank. Balance. 29,000, my lords. 29,000.
In other accounts?
Everything have been submitted before a lordship.
So please tell the court, what is her
bank statement I have produced. Axis Bank, it is 10,000 is lying as on 31/12/2022, my lords, at the time of filing, my lords. At the 6/3/2024, my lords. It is 10,987, my lords.
Yes, your income is 90,000.
94,000.
Flexible, 85 to 94, it is variable.
It is elicited in the order.
No doubt, it is variable.
94,584.
Is that the wife is not working, though she is qualified, number one. Number two?
Number two, my lord, she is capable of fetching the amount. She left the job. She left the job after knowing fully well, my lord, to only to harass the.
No, my lords, those things are to be evidenced, to be substantiated before the court below, my lords. These are all vague submissions, my lords.
Please wait, let him submit whatever he
Yes,
wants to
ma'am.
submit.
Even in the status report, my lord, in the WhatsApp and other things, my lord, she herself, that's what I just now read over, my lord. She states herself, my lord, I am enjoying 2 4. She is working. That means to say, if she is under depression, my lord, definitely. There was 5 years, my lord. She has not made any attempt. There is no continuous treatment said to have been taken.
Even in the first order also, court has given a finding.
Finding.
The observation of the court is till she secures the job.
And that's
Yes.
what.
And if that is the case, what she was doing from the first order till now, either on her medical grounds or what she has, what are the efforts she has made to secure a job, there should be
I
something
will
on
just
record.
make my lordships about hierarchy of the dates. The application was filed on 8/6/2022. It was filed on 2022. The order was passed on 23/5/2023. Immediately they come up with before a lordship by filing one writ petition 14/715 of 2023. Because they said that 20,000 was very high, they want it reduced. And my lord, later on, my lord, the matter was sent back to the court saying that both the parties will have to file fresh documents. I have filed all the documents, but this person comes to court by filing only the documents till the date of filing of application, not after that. When matter was referred back to the court, he should have filed all the documents pertaining to the date of referring. He has not filed. Only to see that my latest salary should not be disclosed. This is the intention, because my lord, for a software person, my lord, the salary increases on annual basis, half yearly basis. Let us go for a while holding salary as 94,000 rupees. And later on, my lords, 1/3/2024, the matter was sent back. My lord, I was pursuing in running the case, getting the, and my lord, for getting the money from my husband, I filed execution petitions. First WP passed, I filed execution, and he got stayed. Then there was an order to remit to 3 lakhs, out of which.
Place before the court the medical record to show that she is unwell right from 21 till now. The respondent shall place before this court the medical records to show that the respondent is suffering with depression and the treatment that is taken. Yes, list the matter after vacation.
Much obliged.
Serial number
In
66.
para 20 of the judgment itself, your lordship, court observes, she has taken money, drawn the salary, the amount, went to shopping, my lord, at foreign trips. That is the observation made in.
No, my
para
lords,
20.
her father, her son, her brother stays in America, some other place. Once she had gone at his request. It's not a foreign trip.
Yes, next.
66. Vasundhara TP for petitioner.
Interim order earlier granted.
Interim order earlier granted is extended. 66.
66, respondent, my lordship. They filed the recalling application to recall the PW1 before the family court. That application came to be rejected.
On behalf of the petitioner, this is matter after vacation.
Serial number 67. K. Ravishankar.
Beg to appear for respondent bank. I placed my objections on record. Now here is the contention of the petitioner that the land which has been mortgaged, in addition to that, the property that belongs to the petitioner has been taken possession by the respondent bank. My respectful submission is the same is a matter of adjudication of fact. Now the contention what the bank has taken is the land belonging, the land which has been mortgaged with the bank has only been taken possession of. Now, as per the survey reports are to be yet to come a lot to that effect. In addition to that,
You didn't do the survey before taking.
survey has been conducted, Mala. The report
Where
is
is
not
the survey report?
report has not been produced.
They have conducted knowing fully well that this is a property belonging to the petitioner has been taken. If my statement before the court is false otherwise, lost my order for the appointment of the court commissioner through ADLR, the cat will be out of the.
Millards, the same may be agreeable to, but it is a matter of adjudication of fact, Mala. Now, to that effect, that
Whatever it is, like when he's saying, why can't the bank be fair?
Please,
No, you have to take possession of the property which is mortgaged.
Correct.
Beyond that, if you take, when that is his case that you have taken beyond that,
We have taken
then
the
you have to conduct.
They
the
have
survey and you
admitted
should-
in their statement of objection.
To say that this property is, we have taken what has not been mortgaged.
My lord, to that effect, now what has happened is there is a house, my lord. Now there are two particular survey number 45/3 and 45/5. Now there is a house which is on 45/5, the major portion, which is also coming on the portion of 45/3, that is the land which has been mortgaged with the respondent bank.
Whatever it is,
Please, ma'am,
as
thereby
per the
the
boundaries, you are supposed to take the possession.
thereby only the land which has been mortgaged has been taken possession of. Since the house that is on the adjacent land is coming on the land which has been mortgaged, now they make a contention that the property that belongs to them in the other adjacent land has also been taken possession of. Malad, the contention pertaining to ADLR, appointment of ADLR or court commissioner for the purpose of survey is a matter of fact which needs to be adjudicated in the right forum. My respectful submission is DRT. We will not take any precipitate action till such time the court orders. Let them file an application.
I am neither a borrower nor a secured asset. I cannot.
It's a very simple issue. It's a very simple issue.
Please.
With regard to the survey. So
Please.
why don't the bank carry out that,
We
that
shall, my lord.
exercise?
We will, my lord. My lords may
Do it,
kindly
do
grant some time. We will conduct a detailed survey. We'll also issue notice to the petitioner. They may come to the place.
Let them not conduct a survey, bank survey. I am requesting the court to appoint an ADLR attached to the office of Taluk of the office of Hassan district. Let an independent survey be conducted. If the survey is conducted by the bank, the same result will come. Kindly have a look at their objection at paragraph.
File an IA, make them as somebody should be there. Somebody should be representing the respondents.
Only 1 second. Objection statement filed in WP 15105 paragraph number 14. They have admitted they have taken possession of petitioner's land. Kindly have a look at me. Apart from this, nothing is needed. Objection 5 in WP 15105, ink page number 14, paragraph number 16. Kindly have a look at this averment.
Paragraph number
16, 16. The one second, brother. Hold me.
I made a submission to that effect, my lord.
The averment?
The averment made at paragraph number 6. It is submitted that the respondent number 2 conducted a survey and a report for survey number 45/3, that is the mortgage property, for an area mortgaged with the second respondent to an extent of 20 guntas. The borrower, that is the respondent number 3, was not able to produce any documents to evidence before the court commissioner to back up the claim of the petitioner herein. Why should I produce, Millard? Next. Further, the property belonging to the respondent number 3, situated in survey number 45/5. This is utterly wrong. It is 45/3. 45/5 is belonging to the petitioner, and that a portion of the house in 45/5 extended to the adjacent survey number 45/3, including the gate and the entrance of so and so. Therefore, the house demonstrated in the statement of objections that it is situated in 45/5, which is exclusively belonging to the petitioner, has been taken in possession. Kindly have a look at the photographs appended below in the writ petition.
Land counts for the petitioner submits that the petitioner's property is situated
May I
in
make one submission?
survey number 45/5. It is submitted that the property that is mortgaged by the respondent number 3 to the respondent number 1 or 2 bank.
Please, no.
Respondent number 2.
1 and 2.
1 and 2 bank is situated in
45/3.
It is submitted that under the guise of taking possession of the property of respondent, the petition, the respondent number 3, the respondent number 1 and 2 have taken possession of the petitioner's land. It is submitted that in the objection that are filed to the writ petition at paragraph number
16.
Paragraph number 16 also supports the case of the petitioner. The position is already taken.
Already taken, Millard. Residential house.
Take one submission.
Millard, kindly have a look at 1 second. You lost me. Kindly take the photographs appended.
After my learned friend finishes, my lord, I may be permitted to make one submission.
In the writ petition, kindly have a look at page 61. The photographs appended while drawing the measure. All the keys, go downs, and the residential house from the petitioner has been taken. I produced the key, handing over the key also. Forcibly, they have taken possession Kindly have a look at Millet page 68, 69.
All the rules that apply to the borrower also apply to the bank.
Please, my lord, with respect to the interpretation of
Article
para 16, my
300A.
lord,
Article 300A of the Constitution, Millet.
my lord, very well,
been
my lord.
violated.
In the writ petition number 15105, my lord, petitioner has also filed a suit for partition. That is fact is also on record, my lord. Subsequently, with respect to interpretation at para 16,
What
my
is the
lord,
relationship between the petitioner
Millet,
and the
the sister,
respondent?
brother and sister.
the petitioner in 15105 is the sister of the borrower.
This property is a joint family property.
No, no, no. It has been the self-acquired property of the mortgagee, that is respondent number 3, which has been sold much prior 2006, Millet. I obtained the loan, he has obtained the loan in the year 2016. It is not that a collusive. 2006, it has been parted with.
My lord, that is with respect to other writ petition. That is the.
No, no,
What
no.
this
I have produced the
05?
15. Kindly have a look at the CLD. I have produced. That is dated. Kindly in page number D, annexure 46, page 46. The dated 25/5/2006. The schedule is 45/3, subdivided after Millet code is conducted 45/5. Loan is obtained in the year 2016 by mortgaging the property of 45/5/3. Where is the question of collusion here?
The
My last, may this one submission. With this pertaining to the paragraph 16, which my learned friend refers to, the interpretation is we are saying that the survey was conducted with respect to the land at 45/3, which was mortgaged, and a portion of house at 45/5 adjacent is also coming on the portion of the land which has been mortgaged. Portion of the house that is on the adjacent land, that is 45/5, is also coming on 45/3 is what we are.
What is the nature of the land?
Not agriculture property. Even that extent, if I am going to argue, it is an agriculture property, loan obtained for a poultry purpose within the meaning of section 2I of the Karnataka Land Reforms Act, and under section 15 of the Surface Act, it is debarred.
Right? What is that?
That is.
If I have to argue.
Suppose the case with the land counsel for the respondent submits that they have only taken the portion of the mortgaged property that is mortgaged to the bank. The petitioner is not a borrower. According to him, his property is
45/5.
45/5. Considering the objections that are filed and the photographs that are placed before the court, there shall be. Let there be a status quo.
Status quo now, they have taken possession where Millet, a residential house.
You said it's an agriculture land.
No. In the agriculture land, Millet, I constructed this go down and a residential house to reside there. Millet, there is no question of obtaining a license in agriculture property. This property, apart from this small residential house, I don't have any avocation. That is why I pleaded before this court. Kindly have a look at Millet, get it surveyed. If the possession is taken, my property.
That's what, without conducting the survey,
yes,
basing on what you say,
yes,
the court cannot give any finding on that.
I'm not saying that court should.
Such time, that's what I'm saying. Till such time, let there be status quo.
Status quo now, the possession is.
But it is virtually saying that you redeliver the possession without a survey.
I have pointed out to your lordships by reading the paragraph number 16,
still,
where they will have admitted.
Unless and until a survey is conducted, what we do is let them not do anything else. Let there be no.
Livestocks are there. Livestocks are there.
What are
livestocks? Millet feeding.
Deciding there.
There are no. In both the writ petitions are filed. Two.
I'm referring to only.
Yes. There is a residential house.
No, please come to the photographs.
Yes.
There is a residential house in that. It is a go down. You have the shutters to that.
Yes. Kindly have a look at Millet. After that,
something is like you have stored something in that.
Yes. You lost me. Kindly turn to page 72 also. 72, 73.
Page 70.
2, 73, 74.
Yes.
This is a residential house. So far. And in the merger also gas stove, everything has been seized.
Without considering, without the survey, survey, we can't
I understand.
direct them to
But,
redeliver the position. That is
but
not
the-
right, because now, first of all, entertaining a writ petition when you have an alternative remedy itself is not maintainable. When the court is showing the indulgence, that should be
Yes.
basing on some
Very well.
exercise.
As your lordship's desires.
Yes. The bank, and there shall be status quo with regard to the property, and the, the respondent shall get the property surveyed through the ADLR department. And shall
Attached to the Taluk office of Hassan district.
attached to the Taluka office of Hassan district by giving notice to the petitioner, and shall file a survey report before this court. List this matter on the reopening day.
Oblige. Great.
Oblige. Good.
Cell number 68. 68.
Petitioner, your lordship. Your lordship, I'm challenging the order dated 12/12/2024, that is IA number 8. Petitioner husband I am for, and for visitation rights, it has been filed by the husband, IA number 8. And also I am, one more writ petition is there, challenging the order dated 19/2/2025, IA number 2, which has been filed by
We'll
respondent.
see this WP 24657.
It's for visitation rights, your
Let's see
lordship.
that order.
My lord, proxy advocate for respondent, my lord, kindly have it day after.
Your lordship, matter has been listed tomorrow at family court, your
IA
lordship.
number 2 filed by the petitioner so and so is allowed in part. The respondent is hereby. Where is the operative portion of the order?
Your lordship, page number 53. That is writ petition number 24657. Page number 53, your lordship, the order is that however the respondent is entitled to visit his son on his birthday, your lordship, 13/12/2024 from 3 p.m. to 5 p.m. It is incomplete order, your lordship. There is nothing, only on the date of birthday they allowed me
No,
to
what
see
is the
my son.
application that's filed?
For visitation of my son, your lordship, on
the
every
court-
weekend.
In the court premises on every Saturday and Sunday.
Yes, your lordship. But the thing is, they ordered only on birthday that day.
Let us read what is the
Yes, your lordship.
consideration. No, if this matter is taken up like on his request on some other day, what is that? What is the prejudice to the?
Your lordship, tomorrow matter has been listed,
will happen?
and even maintenance, I also have challenged.
No, as far as this matter is concerned, if the matter is coming up tomorrow, what will happen? This has attained finality. this
Court below
order.
is insisting to pay entire arrears tomorrow, your lordship.
But it has nothing to do as far as this is. The respondent is direct to pay 10,000 to the petitioner towards conveyance and other.
One more writ petition connected is there, your lordship, 68.1. Both the matters are interlinked and interconnected, your
No,
lordship.
we will decide it independently. You tell why this matter can't be adjourned. This is only for, your visitation is on.
Your lordship, 13 December 13, my son's
That's over.
birthday, your lordship. Kindly allow me to,
2024, when is this order passed?
very long back, your lordship, but day after tomorrow,
Because there is no limitation for this order dated 12th December 2024 is questioned when on 7/8/2025.
Yes, your lordship.
And you insist for that
I
there is
already-
urgency in the matter.
Lordship, kindly it may be taken up because day after tomorrow, my son's birthday, your lordship. It's on December 13th. Last year also, they failed to
this
comply the
court-
order of.
Now this court will pass an order independently giving your visitation on 13/12/2025. On an order where you are
Not
granted-
independently, every weekend it may be taken, ordered.
No,
This
first of
IA
all,
may
why
be,
did you question this order belatedly?
your lordship, it's incomplete order. I have filed for every weekend
Who
for the
stopped you
visitation.
from questioning this order for a year? Why were you not? Why
Your
did you
lordship,
not
both the
question?
prayers were questioned in single writ petition. Then again, my lordship,
No. This is filed. on
again
7/8/20.
separate writ petition was filed, your lordship.
That is within, that you have come to the court in the month of August for
Yes,
an
your
order
lordship.
that is already worked out. An order that is worked out on 13/12/2024, you come to the court on 7/8/2025.
On the instruction of my client, your lordship.
But we can't now, without any application before the family court, seeking what is this?
I have already filed seeking visitation rights, your lordship. That is IA number 2. IA
To
number 8.
celebrate the birthday on 13/12. This is not how the orders can be passed by this court.
Your lordship, kindly page number.
Whenever the party he feels like coming to the high court. we
Kindly
don't
page number
entertain.
53, your lordship. Kindly.
No,
The
you want
present
two things.
application
No,
is,
no, you want two things. No,
Yes,
you
Your
want
Lordship.
visitation, you will not pay the maintenance.
Your Lordship, I will pay, I want to hear this matter, Your Lordship, kindly. There are so many things to be submitted before this honorable
Yes,
court.
you submit.
That maintenance application also, Your Lordship.
In this order only that is passed.
This is pertaining to visitation rights, first writ petition.
First of all, what is wrong with this? The respondent is directed to pay rupees 10,000 to the petitioner towards conveyance and other expenses.
Yes, Your Lordship, along with 10,000, along with my parents, I waited till 5 p.m. but they failed to comply the order even after serving order on them, Your Lordship.
So that is a contempt, violation of the orders of the court.
Yes, Your
For
Lordship.
that, there is no other separate writ petition will not lie.
I am seeking for visitation rights every weekend, Your Lordship. But they have ordered only for a day, Your
That we
Lordship.
will see. Where is the other writ petition? Yes.
One more writ petition is for maintenance, Your Lordship.
Yes. Yes. This order is passed on 12th December 2024. Yes.
Your Lordship, both of them have led a happy married life for 7 years, Lordship.
Which page is impugned order?
Annexure F, page 50, Your Lordship.
Same order. This is the same order in the, like the other petition.
Your Lordship.
When do you want?
Your Lordship, Annexure C, Your Lordship. Annexure C.
Page number.
Annexure C, page number 30.
So the court has
Directed to pay 25,000 rupees, Your Lordship.
What is
Kindly
your
come to
salary?
the. His salary is 1,50,000, Your Lordship.
Then what is the difficulty?
And she is also working as a senior manager in Federal Bank. She earns more than 1,57,675
The
salary, Your
respondent is
Lordship.
hereby directed to pay 25,000 towards the interim maintenance of her son from the date of the application till the disposal of the case.
Yes, Your Lordship. And she is also working as senior
She's
manager
working.
of Federal Bank.
What are the expenses of the child? What is the age of the child?
6 years old, Your Lordship. Kindly come to assets and liabilities, Your Lordship. That is page number 59 of the, it's respondents, assets and liabilities, Your Lordship.
Yes.
Page number 59. In page number 60, there is a 17th paragraph, Your Lordship. Assets and liabilities of respondent.
Yes.
She told that mother, Mrs. Uday Kumari, and diagnosed with so and so, she has to spend more than 40,000 for her medical expenses. And her mother is no more, Your Lordship. To that effect, I am producing this document. That
Can't
under
be a
that
document
heading.
like that. There should be by way of a memo, some application.
Yes, Your Lordship. But her mother is no more, Your Lordship. And she is also working as a senior manager. She earns more than 1,50,000, Your Lordship, but wrongly mentioned as 62,000. She is a senior member working in a bank.
Where is that?
More
Where is
than
the-
10 years.
where is
That
it?
is in page number 59. Her salary has been.
Yes.
And petitioner has to look after his parents, Your Lordship. There are 3 dependents on him who are staying at Nellore, Your Lordship. Again, he is working in Bangalore. It is not that I'll take up the maintenance, Your Lordship, but it's very, 25,000 is very high. Your
No,
Lordship.
please show where is, where from you get that her salary is 1 lakh and odd from the assets and liabilities.
Your Lordship, there is a Google search wherein it has been mentioned that the estimated take-home salary of senior manager of Federal Bank in India typically ranges from 1,57,675 to 1,63,068 per month.
The court to take that into consideration, then in that case.
Let her give the salary certificate, Your Lordship. She has not produced anything to show that her salary is only 62,000. She is working as a senior manager in Federal Bank more than 10 years, Your Lordship.
Whatever you want, they will come, but I'll not grant stay in this.
Your Lordship.
Yes.
Your Lordship,
This is
kindly
not a
maintenance may be reduced, Your Lordship. Kindly 20. I will look after my kid, Your Lordship.
After vacation. Yes,
Number 69. Shankar Avinash, 69.
I'm for respondent, my lord.
Purushottam,
My lord,
Any interim order in this?
I have been filed enhancement petition, my lord. The kindly tag with the
List along with so and so, no representation on behalf of the petitioner. This is matter after vacation.
my lord,
Yes, sir.
my lord, next week.
Nice.
number 70, number ಬರ್ಕೊಡಿ.
Serial number 70 appearing for the petitioner, my lord.
Yes.
It can be.
This has to be heard with the second list in the afternoon, my lord, list number 2.
List along with so and so.
Branch matters.
Yes, in the
Cell
afternoon.
number 71.
It will come in the afternoon.
Cell
Yes,
number
71.
I appear for the respondent bank.
A. Rajendra.
Yes, very simple in order.
Petitioner, my lord. I am before Lordship. I am not agreed by the order passed by the DRT. Any order passed by the DRT, if they are agreed, any party, appeal has to be prepared before DRT under section
There is
18 of the.
efficacy remedy available under section 18 to
Let
prepare.
us see what is the
Yes, ma'am.
relief that is
Yes, ma'am.
sought. Let me look
Yes,
at
my
the
lord.
prayer. Where is
Yes,
the
yes,
prayer?
yes, my lord.
Page number 13, my lord.
Quashing the impugned order passed in essay number. And you are saying that you are not agreed.
My submission, annexure A, page number 17. That is the order passed by the DRT, is a common order. Wherein essay 136 2017, I am benefited. This order 136.
Please read your prayer before we go.
Yes, my
further.
lord. Issue writ in the nature of certiorari or any other appropriate writ of direction quashing the impugned orders passed in essay number so and so. In essay number so and so. By modifying the impugned common order so and so. It means to say that any of the measures initiated by the bank under section 17(3), the DRT has got the powers. When I have challenged the 13(4), the possession notice, it got dismissed. Against that, I filed my RA, got dismissed. And section 14 also a challenge in the essay number 110, RA file 6 got dismissed. When I challenged the auction in the essay number 136 2017, the DRT has upheld the application filed under section 17, setting aside the entire auction proceedings. When such being the case, when the auction is set aside, when the bank has delivered the position to the auction purchaser, sale certificate is set aside, and I have filed my MA miscellaneous application, which the DRT considered and gave direction to the sub-registrar office to cancel the sale certificate, and it has got transferred in my name. That is the MA which I have filed. The MA also is allowed in my favor. When such being the case, now the auction purchaser, when he is in possession.
Modification of an order dated 15/11/2023.
Yes. Yes, because there cannot be a common order. Suppose if you say 13(4) is set aside, dismiss or.
For an order which is passed on 15/11/2023, there is no urgency. Let them come up with their objection. Yes, list
Yes,
after
ma'am.
vacation.
Cell number
Respondent to come up with their objections. Yes.
72.
After vacation, Miller. Now the bank is preferred appeal before the DRT with regard to essay 136.
Yes, 72.
No, last but least, 1 second, my lord, only one word. What he is telling challenging that order, now it is the subject matter of the appeal before the DRT is pending, and he has made a representation there.
I am
Now he is
responding.
playing again
I
and
am
again before the
responding.
DRT.
After lapse of 2, yes, please.
Please. After completion of his SC dismiss, and he filed a review petition. That also, that is a subject matter. And
Now, I am not passing any orders. You file your essay,
No, no,
please pursue that.
No. Since I am the institution, I have to make represent my
Yes.
my job.
Cell number 72, Manjunath H for petitioner, Jagdish HT.
Your ladyship, pursuant to your orders in seriatim, they've taken a flat and the housewarming ceremony is tomorrow. So hopefully they'll have a good new year. We can come back after the new year.
It is submitted by both the councils, the parties have secured an accommodation, separate accommodation for them. And hence request the matter to be taken up after vacation. List this matter after vacation.
Please apply.
Yes, in 72.1, Mr. Manjunath H is directed to take notice.
Please, they have not served me the copies.
So serve the copy.
Please.
Cell number 73,
My lord, I seek for Passover, my lord.
What is that?
Mandamus for OTS, my lord. And they have suppressed. Suits are decreed.
Ask your senior to come. It is before 1:30, not after that.
Please, my
Yes.
lord.
5 cases have been similar, same parties is dismissed. That is not,
Now itself will call. Wait.
74.
in the month of July, it was dismissed.
My lord, applying for petition in this case.
Qazi Salim,
I am
74.
serving the copy, respond number 3 and 5.
Respondent number 5, ma'am.
No, it's for respondent number 3 of the bank.
In this case, petitioner is a purchaser of flat.
Mm,
He is first owner of the flats only.
mm.
The respond number 1 is a sell the flat petitioner on 11/2/2019. Thereafter, same flat is sold by respond number 1 to respond number 2, 17/12/2019. And thereafter, 6/1/2021, another sale is created, same flat number. Respond number 3 is a bank, Bank of Maharashtra. They issued a possession notice against my flat. I am not borrower. I am not taking any loan. I am in the possession of the social property.
The court, how this court will deal with all this? No, some fraud has been played by somebody. It's all a pure question of fact. Who sold, when it is sold, whether they're competent to sell it or not. So what is the relief you are seeking from this court? You should avail the appropriate remedy. How will this court decide all these issues?
Same set of facts. The cover by judgment, page number 129. This honorable court passed the order. Same person, respond number 1 and 2 is cheated in ground floor GF flat number 3, page number 129, my lord. Cover by judgment. Here in respond number 1 is same, is my writ petition. Respond 2 also is same. Same created also another flat.
Lord, kindly pass over, my lord. Senior is in DRT and we have received the copy of the petition
It's covered by
yesterday evening
judgment.
only, my lords.
This is matter tomorrow.
Cell number 75,
Grateful, Your Honor.
75, Sridhar K. Vivek S.
Waiting for respondent in this
Kindly
case.
pass over the matter. My senior is held up in Kotal 8, madam.
If they come before 1:30, if the court is able to take, then only he'll take, or else I'll adjourn these matters after vacation.
Kindly pass.
Yes.
Cell number 76, final hearing matter.
Appearing for the appellant, my lord. The
My lord, I am
claimant
for the
appeal.
second respondent, my lord.
Only enhancement, my lord, enhancement, my lord, only one ground. My lord, the income was taken for 10,000 instead of 14,000, but the future prospectus was not taken. That is the ground. Case of death, my lord, that is 2019. Only two ground.
My lord,
Otherwise,
future
my lord,
prospectus is not applicable because according to them only he is aged more than 60 years. Kindly see, my lord, para 2.
Yes.
Page 6, my lord.
Which year is the accident?
My lord, the date of accident, my lord, 2019 and 27/7/2019, my lord.
What is the income as per the chart?
My lord, the 14,000, my lord.
14,000.
14,000. The tribunal was taken 10,000.
For the future prospects.
No future
That is,
prospectus.
Then How
My
many
lord,
are the
please, my lord.
dependents?
My lord, the tribunal was already, my lord,
Mr. Vijay Kumar, if I want anything, I'll ask you because the
Please,
advocate is here. Yes.
please, please,
my lord,
please.
already, my lord, tribunal was correctly awarded the, my lord, compensation is, my lord, concern is consortium, already, my lord, 1/4.
So let's do the calculation for this.
Please, my lord. Why, my lord, 4, my lord.
One of
5, 2 to 4 are the
one
children.
fourth or one third?
1/4,
Major
my lord.
children, all are major children.
What is the multiplier?
My lord, multiplier 9, my lord. It is correct.
It comes to 11,34,000.
Yes.
Consortium is granted how much?
My lord, 1,60,000 already tribunal was granted. Medical bills, my lord, were 2,40,000. My lord, funeral expenses 50,000. Loss of estate 50,000 was granted.
Expenses?
15,000 was granted.
That is, no. You said 4.
Please,
4 into 44 is 1,76,000.
please, my lord.
Funeral expenses 36,000. It comes to 15,86,000. How much was awarded?
My lord, 12,40,000 was awarded before the
12
tax.
lakh?
40,000, my lord.
Salary was taken it?
My lord, 10,000 was taken.
Ink,
Please
not
come.
salary.
Agreed with her. Award passed in MBC number 1080 of 2019. Date 22nd of August 2022. The claimant is before this. The claimants are before this seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. Where is the table?
My lord, ink page number, my lord, 30, my lord.
Para 27.
30. Ink page number 30. Para.
Paragraph number 27 extracted. Land counsel appearing for the appellant claimant submits that this accident had taken place in the year 2019, but the court had taken the income at 10,000 instead of 14,000. It is submitted that under the conventional heads also, the amount that is awarded by the tribunal is just and reasonable. Next parallel counsel appearing for the respondent insurance company submits that the court had rightly considered and granted the compensation. There are no grounds to interfere. Next, having heard the counsels on either side, fits the material non record. There is no dispute about the fact that this accident has taken place in the year 2019. And as per the chart prepared by the Karnataka Legal Services Authority, the income has to be considered at 14,000. There are 4 dependents. The 1/4 has to be deducted towards the personal expenses. It comes to 3,500. Then the contribution to the family is 10,500 into 12 into 9. Under the head of loss or dependency is entitled for an amount of rupees 11,34,000. Towards consortium 4 into 44, 1,76,000. Medical expenses as it is, that is 2,40,000. Funeral expenses 36,000. And in the light of the law laid down in Mekala or so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 15,96,000. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 12,40,000 to 15,96,000.
My lord, name of B. Pradeep may be deleted, my lord. Kindly delete the name of B. Pradeep.
You have already filed. What is the difficulty now? Please tell Mr. Vijay Kumar.
Because both names will be reflected in the judgment, that is why.
It won't be reflected because you filed the wakalat, only one name will be reflected.
Much obliged, much obliged.
There is a delay of 617 days.
There is no interest.
Condone on
to
condition.
Already, my lord, condone.
Yes, next.
But no interest, no interest on the enhancement.
Kindly pass on.
77.
Senior counsel is coming.
My lord,
He's
no
on his
interest on
legs.
the this, my lord, delayed period.
Sir, it is ordered, sir.
Much obliged.
Yes.
7 SCS.
Kindly pass on, my lord. Senior is on his legs arguing a matter.
No, it is not possible for the court to take it now. Let's
2:30, my
after
lord.
vacation. After vacation, call the
No, my lords,
pastor.
I'll make my submission. I'll make.
Alright.
Yes,
My lords, I'm filed an application. My lords, may I just pass on this invitation card?
yes.
There is a function held on Sunday, my lords,
For that reason, I'm requesting this honorable court to just extend one more day of visitation rights of the kid, my lords. That's
I'll
only.
pass the final orders, no interim.
No, my lords, the function will be held on this Sunday.
The court has made its best effort.
Please, ma'am. Yes,
Neither
my
the
lords. Very true, my
father,
lords.
neither the father nor the grandmother are not understanding what is in the interest of the child. No, it is for the court to pass orders.
True, my lords. Very true, my lords.
Because father is not understanding and he is doing whatever he feels like.
No, my lords,
Not adhering to the order that is passed by the court.
No, my lords.
I think no indulgence is required by this court. We will say, let you meet in the mediation center or in the child visitation room in the Bangalore mediation center.
There is no
Will
such
not-
allegations against the father.
That's what is happening. They have produced the photographs before the court to show that, like, where he is taking the child. And I said the grandparents should be there. The grandparents are at any point of time, they are not there. And they have filed the photographs to show at that relevant point of time, the grandparents are at their native place. And I told them to take a house near to the place where the grandmother is residing,
Yes.
so that it would be convenient for the child, and the council submits that it is not possible.
We shall adhere, my lords. We shall advise him properly. May I request at least tomorrow, my lords, so that senior will come and make a subject. Tomorrow, my lords, at least.
My lord, actually date for
Either
the
2:30
final
or
hearing
tomorrow.
is fixed on 18th of this month. My lord. 18th of this month, final hearing date is fixed by this honorable court, my lord, in the last order.
Then why it is? Why
My lords, the only,
So
the
they have
indulgence
changed
is
the
because of
council
the.
and they have come with this application, my lord.
My lords,
At the
because of-
fag end of this,
No,
one day-
I've rejected it when the council has,
Exactly.
made a submission before in the chambers. I said I will not grant all that.
this function was fixed very early, my lord. On the day also, he didn't mention about
He
this.
mentioned it, but I said it is not possible. This is matter after vacation.
My lords,
On
just
18th.
at least kindly have it tomorrow, my lords, so that senior will come and address his
Tomorrow.
arguments. Please, my lords.
Yes,
Highly-
all the passwords.
Passover matters. Serial number 3.
Serial number 52.
What to do if the councils are not there when the matters are called?
No, when the matter was calling 45, I was about to reach. In fraction.
Yes, what is it?
It's insurance company appeal, my lord, on the liability.
Liability on what ground?
Liability. Because my lord, the claimant is none other than the brother's son of the deceased, my lord, as claimed by the petitioner. No material evidence has been placed before this honorable court, before the tribunal.
Case of death or injury?
Death, my lord.
How much is granted?
5,09,196, my lord.
What is the age of the deceased?
My lord,
Deceased age?
Deceased age was 60 years, my lord. The dispute is, the tribunal has relied upon section 10 of Hindu marriage, Muslim Mohammedan law, my lord. Mohammedan.
Then comes for the petitioner submits that. Then comes for the appellant submits that the insurance company is before this court on the question of liability. And as the parties are close related to each other, no other independent evidence is adduced, considering the same 50%, 4 weeks notice to respondents.
Same can be disputed.
Yes.
Serial number,
Much
Passover matters, list number 1, serial number 3. Nagaraj.
Yes. The office objection, the land council submits that. As per the award, as the claim is 20 lakhs, he has stated that the valuation of the appeal is 20 lakhs. This is an appeal filed by the owner of the vehicle, and the amount that is awarded by the tribunal is 3.5 lakhs. Where is that? 3,85,000. As he being the owner of the vehicle, he cannot, he is aggrieved only as far as 3,85,000 is concerned. As such, the court, the tribunal has rightly, the office has rightly taken an objection with regard to the same. The petitioner shall comply with the office objection.
Serial number 10. Nagashri.
Yes.
And 13B petition has been filed.
Yes, yes. The writ petition is filed questioning the order dated 28/10. What is the date of the order?
1710 and 2810. 2810.
No, no.
To comply
All
the.
on 28/10.
Yes, my lord. To comply the conciliation.
That order before 28/10.
Well, applications for two applications for statutory.
Oh, this order, this MC 51.
Please,
Before that, what is the date of that? That
2810.
Huh?
2810.
Oh.
Please,
28/10 is the next order.
First order, my lord, consequently, the statutory cooling period of 6
Then
months.
you are aggrieved.
Yes, my lord.
That order date I'm asking.
That is 1710. Page 22, my lord.
The petition is before this court. Questioning the order dated 17/10/2025, whereby the family court in an application that is, in a petition that is filed under section 13B of the Family Court Act had dispensed with the statutory cooling period of 6 months. However, directed the appearance of the parties and their parents for conciliation along with their photo ID and directed the matter to be called on 28/10/2025. Again on 28/10/2025, the matter was adjourned to 15/11/2025 to comply with the order dated 17. It is not 17, it is 15.
Next, again it is same order.
To comply with
To comply
the last
with the
date
earlier
order. Last date
previous order. That is on 2810.
17/10/2025. Learned counsel for the petitioner submits that in a petition that is filed under section 13B, the presence of the order of the court directing the parents to be present is not warranted. And in fact, the parents are staying at faraway places and it is difficult for the parents to come. Next paragraph. In the earlier, when this was brought to the notice of the court, that the learned judge is insisting for the parents to come in this applications filed under 13B. This court has already directed not to insist for the presence of the parents, but in spite of the same, this order is passed. The order insisting for the presence of the parents dated 17/10/2025 is set aside. Yes. According to the petition is allowed.
Matter may be sent to the mediation center. Direction may be issued to matter may be sent to the mediation center. Again, the matter will come.
The
parties may be directed to present before the mediation center next day. Any Monday, Tuesday, any day. Date may be fixed.
Parties shall appear before the mediation on 19th, remember?
Oblige,
Yes.
Sale number 20.
Even the reports, my lord, the learned judge wants the modification of the report. She will not accept the report, my lord. That is the difficulty. Well, I just made my submission.
Sale number 29.
My lord, I'm appearing for the respond number 1 and 2 bank. My lord, I'm filing my synopsis along with the documents to show that the disbursed amount.
Take that.
I appear for the auction purchases. I am yet to begin only after conclusion of the arguments by the learned senior counsels. In brief, my
Before I
lords-
start.
1 second, sir.
No, 1 minute. Let me
You have
complete.
completed.
You are only a purchaser.
Could be. My stakes are very high.
No, let's see the first, the documents.
Yes, ma'am.
Yes, where is that?
No,
So that,
she has to say.
Where is that?
Let's, before they commence, can I show one document? Please come to, in their statement of objections, annexure R10, page 88.
88.
88, my lords. Annexure R10.
That is filed today or earlier?
My lords, statement of objections filed earlier, 5/9/24. It's dated 5th of September 24.
Where is that?
Statement of objections. Out.
Yes.
This is the
Page number?
page 88, my lords, annexure R10.
This is the registration of the security interest, my lords. Please turn over to page 89. In that, my lords, your lordships will have the current view heading. Please see in that the third type of security interest. Equitable mortgage, your lordships have that, my lords. Also at the page 90, your lordships will again get type of security interest, equitable mortgage. And borrower's details is at page 89 and 90, both, my lords. Your lordships will see my name is not mentioned. I'm just showing the borrower's name. So they register this as per, my lords, section 26E, 26D. That's the equitable mortgage. I just wanted to bring that to your lordship's notice to say now the latest judgment of the Honorable Supreme Court in Cosmos case, my lords. 20, it's this was dispute between two banks which went to the Honorable Supreme Court from Maharashtra relating to charges, my lords. In that, my lords, your lordships will see the concept of equitable mortgage was considered from para 27 onwards. That will be internal page 19. This is it. Para number will be same. Sorry, the page now I am looking at SEC, my lords. Concept of equitable mortgage. It starts from para 27. But they go into what is equitable mortgage, what is a legal mortgage.
Concept of equitable mortgage.
Yes, my lords. They go into that. What is a mortgage? In that, please come to para 30. My lords, para 30, last 5 lines, my lords, in that para 30, it starts with, in other words.
Yes.
Yeah.
It starts with, in other words, where under about 5 lines, my lords, 6th line in para 30.
Para 30?
Para 30, my lords.
30.
Sorry, 30, 30. Page number illa, sorry.
Para 30 says, however.
However, it starts in that, my lords, last 6 lines of that para. In other words, it starts with. In other words, where under the law no mortgage or charge is said to have been created over a property, that is, no conveyance of a right or interest over the subject matter has been effected. Yet, if the intention of the parties to create a mortgage is clear, equity would demand that such intention is not respected but given some effect to, and the said property be deemed to have been mortgaged so as to enable the lender to assert its rights over the same. It is known as equitable mortgage. Then please, I will not say, my lords, then they have gone into legal mortgage and other things. But please come to nature is mentioned, that nature of equitable mortgage starts at para 36. But please come to straight away to para 43. I'm skipping we don't need the differences between English law and other things, they have settled it. Para 43 starts from thus, if your lordships have that one. Thus, where equitable mortgages have been created based on deposit of part deeds or documents purporting title or evincing intention of parties to create an interest, all such deposits will be a valid mortgage in equity, and the charge that might have been created prior in time will assume priority over any subsequent charges or mortgages. However, since such a mortgage is an equitable mortgage, any rights flowing from such mortgages are only of personal character and only rights in personam, and as such will not operate against any strangers or subsequent encumbrances unaware of such equitable mortgage. This stems from the rule that equity acts only in personam. The very basis of creation of an equitable mortgage is the intention of the parties alone, and as such any action or remedy can be directed only against the parties so involved. This is because, unlike a legal mortgage where a charge is created directly on the property itself and the title of any proprietary interest therein is transferred to the lender, thereby becoming a right enforceable in rem in respect of the property, in case of an equitable mortgage, no such charge is said to have been formally created on the property, nor any transfer or conveyance of interest as said to occur. Rather, on the contrary, the de jure title or ownership continues to vest with the original borrower, and only the documents thereof is ordinarily retained by the lender, and as such, the right of the lender in such a situation is being enforced through the party having title over the said property alone. That is the borrower, and thus is only a right in personam. Then, my lords, they quote. I just wanted to show this, and my lords, my statements regarding payments made in my rejoinder, we have set out everything. What amounts we have received, that was already there on record.
How much? 10 lakh.
My lords, please come to my rejoinder.
9 crores.
No, from ICICI. I think if my learned friend waits, he will get his turn, I'm sure. Please come to the rejoinder, my lords.
When is it filed?
My lords, it was filed on 17th March 2025, my lords. Thought they flag it. In that, please come to para 6, my lords. This, though the heading says payment to respondent 3, it should be payment by respondent. Respondent 3 is a borrower and a sale agreement holder. Now, please see, I have set out details in that, my lords. I have said what details as per agreement at clause 1. 6 crores 40 lakhs was the payment to be made for 2 flats, my lords, in that para 6 clause 1. Then, my lords, I have set out, please see 2. Clause 2 is important there. Out of the said amount, respondent number 3, Balaji and Company, has paid 3 crores 84 lakhs, which was released by Karnataka Bank, Sadashiv Nagar Bank on 24/3/2014 from the loan account number so and so in 2 parts. That is 2 crores 22 lakhs 99,451 to the loan account of Shri Venkatramani. Lords, Venkatramani was the earlier agreement holder, third party, on 24/3/2014. And the remaining amount of 1 crore 61 lakhs 549 was credited to the petitioner. Respondent 3 has further paid the following amounts to petitioner I have set out. Hence, in total, advance sale consideration paid by respondent number 3 to the petitioner is aggregating to 413,25,000 on account of 2 flats out of sale consideration of 6 crores 40 lakhs, which does not factor into account the cost towards increase in built up area. Then I have given the statement of accounts. Then, my lords, I have said 2 crores 26 lakhs 75,000 was the balance consideration which was to be paid by respondent number 3 for the sale of the flat. So far as 4th respondent is concerned, the same figures I have set out. Please see in that also clause 2. 7, para 7, clause 2. Petitioner submits respondent number 4 has paid 3 crores 84 lakhs to the petitioner.
What is to be paid to you is 2 lakh.
2 crores
26 lakhs 75,000 each.
Each, my lords. That is what we have set out by giving the details that.
So you have received how much?
My lords, I have received, that is exactly what is
6 crores.
8 crores for 4 flats.
8 crores.
8 crores and 26 lakhs. We have, if your lordships adds up in our synopsis, we have said we received that. But now that was towards the sale consideration, advance amount. Today I have a balance, and my instructions are all the 4 flats are sold for 9 crores and 9 crores. So, my lords, I lost out money there. I have lost out money here, and it's an equitable mortgage. Security interest, it does not even come as a security. Subject to what they say, my lords, I'll come back.
What do you say about your undertaking?
Please see my undertaking. That's exactly why I said, my lords.
Whatever amounts you have received, you will give it back to
I will receive, my lords, yes. But what is received? Please see. That's why I said, the loan amount of dispersal is to the other fellow.
With respect of the 4 flats, you have received 8 crore 26 lakh rupees.
Yes, 8 crores I received, not from ICICI Bank. My lords, I take it into account. That's why, my lord, 6(2), clause 2, I said, the earlier agreement holder, it is paid to him because he had entered into an agreement. That agreement got cancelled. So he receives that part consideration. It is not paid to me. But for purposes of sale, my lords, I will have to take it into consideration for setting off that amount. But I don't receive it. From ICICI, which gets it assigned, my statement was
Few from ICICI except
10
10
lakhs.
lakhs, we have not.
Only
received
10,
any.
and that also they have said so. In my learned friend said that please come to para 12 of their statement of objections. I mean, sorry, page 12. It is numbered as in 14, in 16, my lord, 17. It is numbered as Roman 8. Page 12 of their statement of objections.
Page 12.
Page 12, Roman heading 7, my lords. Statement of objections. I'm sorry, statement of objections, not the rejoinder. That's a little bulky statement of objections.
Yes, that is filed on 5/9/2024.
Yes, ma'am.
Page number?
Page number 12, running page 12. In that Roman 7, your lordships would get clause Roman 7. It is further submitted that for carrying out certain modifications to the apartment of the borrowers, the petitioner had raised additional sum of 10 lakhs and even the same was released to the petitioner on 5/3/2016 by 2 checks bearing so and so. And the same has been encashed by the petitioner through his syndicate bank account number so and so. Copies of the checks are R9 and R10.
Yes.
So this is what ICICI pays me. But today, my lord, they could have gone against the borrower. That is why they filed a OA. Now, my lords, my property I lose. First of all, agreement of, and I am neither treated, my lords, if they had to treat me as a borrower or a guarantor, they should have issued notice to me. They have neither treated me as a borrower nor as a guarantor, nothing. It's only an agreement of sale. That's subject to, my lords, what my learned friend says, if a reply, if time permits.
Yes. Yes, Mr. Senior Counsel.
Lords, the petitioner, as I can understand, wants to become unscrupulous for this reason. The first of the loan transaction.
Anita? Yes.
The first of the loan transaction is pertaining to the apartments where there were different buyers. That was funded by the Karnataka Bank. Karnataka Bank funded about 3.5, about 7 crores, 8 crore rupees. They funded this project at the instance of 2 other borrowers. That is one Venkatramani and one KBR Infra, something like that. There are 2 buyers. Now they could not complete the payments, as I could understand. They were not completing this. Now, in order to ensure that the funding is not enforced by the Karnataka Bank, it had to be either, because it would have been treated as NPA if the payments would not have been made. So what this petitioner does is 3 and 4 is set up. This is what we could understand after going through the papers. They set up these 2 persons as the prospective purchasers. Loan which was already advanced by Karnataka Bank in favor of the petitioner is taken over with additional loan having been sanctioned as to the value of these apartments. So that is how I will show the letters minutes issued by the Karnataka Bank, which says that we have no objection for the loan being taken over. Now, in the agreement which they executed in favor of the present respondents 3 and 4, there is a categorical statement that this is subject matter of a mortgage to Karnataka Bank. Karnataka Bank says you take over the loan. Even for us, they give a letter saying that we have no objection for this mortgage to continue in favor of ICICI Bank in view of the takeover. After having said all these things, we do not know, because respondent 3 and 4 are not before the court, because apparently they have been set up by them. 2.6 crores is what they are calling, but the entire consideration is shown as 4.5. They have already pocketed 9 crores. Now, with this on hand, there is the contention which they want to raise at this juncture is that what was executed in favor of the respondents 3 and 4 is an agreement of sale. Therefore, that would not lead to sale of the secured assets is what they are, that sale of the apartments is their contention. That is the substance of their contention. Nothing beyond that. That's what they are not submitting is, this is a special statute. These are regulated under special contracts per se, my lords, which comes within the purview of the statute. Now, there is no dispute about the fact that there was already a mortgage in favor of Karnataka Bank. Your lords may kindly take the petition itself. Page number is the petition? Yeah. 80.
Page number?
Once I just point the page number. I folded it. Yes. Is that page number? This is the one. Yes. I'm sorry. Page number. Annexure A, page number 34.
Yes.
Agreement without possession. This is a registered agreement. Vijay Kumar, the petitioner, my lords, is the person who is shown to be the vendor. Balaji and Company, my lords, if your lords were to see, this Balaji and Company is the third respondent in their favor. In this, your lords will kindly see what is that they have said, how they have started this transaction at page number 43.
Yes.
The purchaser hereby expressly stated that A schedule property is mortgaged to Karnataka Bank Limited, Malleshwaram branch. Hence, all sale proceeds shall be routed through the Karnataka Bank, Bank Limited, Malleshwaram branch. But there is a reason why I am submitting this, because the entirety of the property in respect of which, if your lords were to see A schedule, the entirety of the property in respect of which they were putting up the construction was subject matter of mortgage already before the Karnataka Bank. So they can't say that this was not the subject matter of any mortgage. There was already a mortgage. Now the only question is to what extent we have taken over that mortgage. To what extent we have been assigned with that mortgage. That's essentially the point. Now, having admitted to this fact, now what happened is, after this Balaji Enterprises comes into the fray, if your lords were to take our statement of objections.
What is the loan extended by ICICI Bank?
Lords, loan extended by us is about 9 crores. Lords, how this 7 crores, how we have, Lords, how we have disbursed this is, now there is an intermediary who is the earlier borrower. On account of the earlier borrower's account, certain monies are paid by him, are shown to have been paid by him. So it has to be paid to him. We have produced the statement of accounts. So we deposited this entire amount to Balaji. Balaji repaid what was paid by Karnataka Bank in favor of this Venkatramani, in favor of the petitioner, and also KBR in favor of the petitioner. That is deposited towards their accounts by this Balaji and the other purchaser. Remaining amounts have flown into the accounts of this petitioner. We have produced a statement of accounts. So it is not as though they are submitting that nothing has happened. This was a pre-existing loan transaction pertaining to these apartments.
According to you, how much is the amount flown to this petitioner's account as per the documents?
8 crores is what they have admitted.
Not from ICS.
No, not from ICS.
Lords, now question is, I will point out to that letter. If your lords were to see that letter by the Karnataka Bank, if your lords were to see at annexure, is the one? Annexure R6 along with the objection. At page 57 in the same volume which your lordships were holding.
Yes.
Takeover of loan account by Karnataka Bank. Lordships will see to the ICICI Bank manager.
Page number?
Page number 56, 57. Both the paragraphs. Lords, what I propose to do in the matter is,
Where are these documents?
Lords, we are having some of the documents. Karnataka Bank is having some of the documents. They handed over the documents pertaining to the agreements which was executed in favor of the erstwhile purchasers. Then the later agreements were also mortgaged in our favor. In every loan transaction where there is a large complex, let us assume, there is a large complex which is coming about. In such matters, whenever a apartment owner wants to approach us for the purpose of loan, the Title documents, let us say, my lords, it is being carried out in 10 acres of property and what he is purchasing a 2 BHK. So those property documents will never come to us. They will give him the authority to mortgage his interest in the property, which will become a secured asset in our hands. Now, what is a secured asset and how it becomes a security agreement, I will definitely demonstrate
So
it.
necessarily he'll be giving you that agreement of sale.
He will be giving the agreement of sale. He will be giving consent letters saying that, yes, we have no objection for this piece of the property being mortgaged in their favor. This is the documentation which.
What is the guarantee that he will pay the amount, he will get the sale deed executed in his favor?
Lords, that's the reason why I said the assurance is the mortgage of the rights which is created in favor of the purchaser, qua the seller.
No,
So
in
we
this
get
case-
this entire rights.
In this case, what are the rights?
Lords, the right is, the right in respect of this apartment itself is the secured asset. The whole of the secured asset is this apartment. Because what happens? The borrower is an intermediary who wants to purchase this. Borrower says, I want to purchase this, you fund it. We fund it either through his account or directly to them. It doesn't matter, but the funding goes to them. Once the funding goes to them, this is an apartment for which I have funded, and that is the secured asset. Now, what is the contract between the person who is developing as well as the bank is? They give this letter saying that we are authorizing so and so, or we are ensuring that this is done. If your lordships were to see, section 58F is exempted to the bank's number 1. That's the Transfer of Property Act. 58F itself says that this can be done either by himself or through an agent. Lords, once such an authorization is given, these are all the regular commercial practices, which is taking place in every bank. Whenever I have constructed 100 apartments, all 100 apartments funding takes place in the same fashion. That they will give us the authorization letter, they will give the letter, they will give the letter to the borrower, borrower enters into an agreement with them.
Whatever the money that you've given, you have extended as loan,
Yes.
that is not given to the.
Lords, usually what happens, now this is, since it is a takeover loan, this is how your lordships is finding. That's the reason why I wanted to say this, Lords. What I want to do is, I will implead Karnataka Bank in this matter. At my instance, your lordships may implead Karnataka Bank, and Karnataka Bank will come out with the full details of what the money is flown to them. Because these are the kind of matters where the money flows to their accounts through the various loan accounts. Ultimately, if it does not come into the loan account, it will not flow into their accounts. So this is something to which I am not a privy to. But fact remains, they are admitting that 8 crores is what they have received as sale consideration. It is not a sale consideration which somebody has paid it. This is the funding given either by Karnataka Bank or which we have paid to Karnataka Bank and taken over the loan. So it is not that, they are not done anything. Whatever funding is done for the purpose of construction is based on their assurance of the mortgage of this property, without which we will not fund. We will not have undertaken the funding of this property at all if they don't give us the assurance. This itself constitutes a security agreement.
What do you say about is it necessary, or we can take it that you have that amount has been transferred from Karnataka Bank?
Lords, I have said what is transferred, that is, it goes to him. He wants to implead, I have no issues. Let him implead Karnataka Bank. We are very straight on this point, my lords. Because ultimately, what is conveniently forgotten is, my lords, at best, what could let's assume this. What could the purchaser get, my lords? He could get the flat, subject to paying the entire sale consideration amount. Today, see what has happened. He owes me money, 2.67 crores, admittedly. You sell the property at 9 crores when the agreement of 2014 said it is 12 crores worth property. You have sold it for 9 crores. You have pocketed your money. You say, I have this for 1 minute.
Whatever was outstanding
Yes.
against the borrower's
But-
account, if on that day they had paid,
What
that's a
happens to
different
my
matter.
balance sale consideration amount? I don't get the balance sale consideration amount. I have lost the property. ICICI is walking off with 9 crores.
Which is
I
lent
think
to
with
them,
this
admittedly.
tripartite agreements, that
My
is
lords,
what is
ultimately,
happening.
my lords, I know for a fact that when there is a construction agreement and a sale agreement, there is always a tripartite agreement. It is not some letter of NOC that any builder gives. It will be because the bank also,
Never you lend,
it
it's
is
a
always a
tripartite.
tripartite agreement.
This is a construction in a very small 4,000
Ah.
square feet of property for apartment which they are constructing. If they have a tripartite agreement, they have it. We are based on, that is the reason why I said, there were tripartite agreements in relation to subvention schemes. Subvention schemes is where the developer will undertake. On the funding by the bank, he will continue to pay the interest till such time the possession is delivered. That's the subvention scheme. There will be tripartite agreements. So whereas these agreements are concerned, we are more than happy as long as the property, entire property is offered to us as a security. Once the property is offered as a security to us, now the person cannot come and say that, no, this property is not offered as security. You
One
cannot
more,
rely upon.
Lords, it is better he impledes Karnataka Bank
Anyway, I will
because
implead.
the entire property is not mortgaged.
What is a reference?
Counsel appearing for the respondent submits that originally the property, they obtained the loan from Karnataka Bank by mortgaging the property. And the Karnataka Bank has addressed a letter to the ICICI Bank that they have no objection. If the same is transferred to the ICICI Bank, it is submitted that the Karnataka Bank is a proper and necessary party to the writ petition. Then appropriate application shall be filed, including the Karnataka Bank.
Lordship may record the oral submission
and
Lordship may permit the Karnataka Bank to be impleaded on the oral request, or because that could be done, my lords, instead of the matter coming up again. And I will take out notice on the standing counsel for the Karnataka Bank so that we can expedite the hearing. Your lordship has spent substantial time.
Branch.
Karnataka Bank as a respondent to the
Malleshwaram branch.
Karnataka Bank Malleshwaram branch.
Yes.
As respondent to this, which respondent, just look at it. Respondent to this writ petition. The notice registry is directed to issue notice and.
Divya Purandar.
Oh.
Divya Purandar appears for.
So and so is directed to take notice on behalf of the bank. This is matter after vacation.
Lords, respondent number 8.
Respondent number 8.
Lords, sir, can I request
The
that this can be treated as a part-heard matter since your lordships have for further hearing?
Please, my lords.
My matter, kindly tomorrow if it can be heard.
He's in parting person. The matter is in 57. Serial number 57. He's in outside. The matter is going to after vacation. He's filing a memo for urgency because.
It's already adjourned. Matter is adjourned.
No. In family court is in 28th. He deposits the money. That's why matter is.
No, is it a matter in the list or out of the list?
In the list. Actually, I went outside to call her. She's a legal aid. Because of some confusion, matter went to the after vacation. It's very urgent. Please give tomorrow. Because next week I have to give final order. Next week Saturday I have to give final order to principal judge family court. That's why I filed a writ petition and connecting matter and list on Monday or tomorrow. This is very urgent because otherwise arrest warrant will be issued against me.
My lord, MFA is going on. My
Kindly.
My lordship.
My matter was next to be heard, my lordship, today. There is a stay on the vacation custody. I lost multiple.
Vacation is still yet to start.
Yes, my lordship.
If it is passed over, it will be taken some other day. I can't take the matters now. I have at 2:30. I have a separate list.
Tomorrow or. Kindly list matter tomorrow, please, because very urgency. Kindly list matter tomorrow, my lord. There is a very urgency. Kindly
can be taken up tomorrow or Monday, my lord. Serial number 59, my lord.
Serial number 60.
Well, at serial number 60, there is
kindly.
They make one submission.
Yes.
One more passed over matter. There is some urgency. Your lordship may kindly have this matter top of the list tomorrow because 12 o'clock.
Because tomorrow I'm sitting till only 1:30 because there's a larger bench. I can have it on Monday.
Tomorrow is the date of action. It's scheduled tomorrow. That is the reason I moved the matter. Well, at serial number 60.
My lord, kindly grant on.
Well, at serial number 60, there is a compromise, my lord. Kindly, my lord, serial number 60, there is a compromise. Filing.
This is a.
My lord, serial number 60, there is a compromise, my lord. Pass on the joint memo in the compromise, my lord.
My lord, please.
All the matters, the court officer will give the dates. Please tell the.
My lord, please grant this one.
Yes.
My lord, serial number 60 is.
Please. My lord, please.
Serial number 60 is.
Please grant on Monday.
Monday, my lord.
My lord, please Monday. Please. Madam. Monday.
Wait ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
Beginning ಅಲ್ಲಿ.
ಅಲ್ಲ ಯೂಶಲಿ ಎಕ್ಸ್ಟೆಂಡ್
Court officer.
Sorry, sir. Sir, ಇದು obvious. ಸರ್ ಒಂದ್ ನಿಮಿಷ ಸರ್ 40 ಹೇಳಿ ಸರ್. ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಹೇಳಿಲ್ಲ ನಾಳೆ ಅಂತ ಹೇಳಿದ್ರು. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಹೇಳಿ? 48.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 49. ಮೇಡಮ್ 32 ಮೇಡಮ್.
ಸರ್ 48 ಮಾತ್ರ ನಾಳೆ ಹೇಳಿದ್ದಾರೆ, ಬೇರೆದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್. 48 ಹೇಳಿ ಸರ್. ನಾಳೆಗೆ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 75 ಮೇಡಮ್.
ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಹೇಳಿಲ್ಲ.
ಅವ್ರು ಹೇಳಿ ಕೇಳಿದೆ ಹೂ ಅಂತಿದ್ರು. ಇಲ್ಲವ್ರು 12 ಗಂಟೆ ಒಳಗೆ ರೀಚ್ ಆಗ್ಬೇಕು, ಅದಕ್ಕೆ 11 ಗಂಟೆ ಒಳಗೆ
ಮೇಡಮ್ 32 ಮೇಡಮ್ ಹಂಗೆ. ಮೇಡಮ್
73.
32 FC ಮ್ಯಾಟರ್ ಹೇಳಿ ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವತ್ತು ಮೇಡಮ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಮಂಡೇ ಅಂತ ಕೊಡಿ. 15, 12.
ಸೀರಿಯಲ್ ನಂಬರ್ 75 ಮೇಡಮ್. ಪಾಸ್ವರ್ಡ್ ಮೇಡಮ್.
ಡೇಟ್ಸ್ ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ ಸುವರ್ಣ ಅವರೇ. ಡೇಟ್ಸ್ ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ತಾರೆ ಅವರು.
ಸೀರಿಯಲ್ ನಂಬರ್ 59.
32 ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಆಮೇಲೆ ಒಂದ್ ನಿಮಿಷ ಸರ್ 48 ಆಯ್ತು. 48 ಆದ್ಮೇಲೆ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 60.
48 ಸೀರಿಯಲ್ ನಂಬರ್ 60.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಅದು ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀನಿ, ಸೆಟಲ್ಮೆಂಟ್ ರೆಡಿ ಇದೆ.
ಯಾವಾಗ?
ಈಗ ಬಂದ
ಮಂಡೇ ಕೊಡಿ.
ಅಲ್ಲ ಅಲ್ಲ
ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ, ಮಂಡೇ ಕೊಡಿ.
ಅಲ್ಲ ಮೇಡಮ್ ಅದನ್ನ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಷ್ಟೇ.
ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಂಡೇ ಕೊಡಿ, ಬಿಕಾಸ್ ದೇರ್ ಆರ್ ಬ್ಯಾಚ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್. ಈಗ ಮತ್ತೆ ಮಂಡೇ ಕೊಡಿ.
ಅಲ್ಲ ಅವ್ರು ಈ ಬಂದ ತಕ್ಷಣ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ, ಇಫ್ ಪಾಸಿಬಲ್ ಆದ್ರೆ.
ನಾನು ಹೇಳಿಲ್ವಾ ಮೇಡಮ್ ಹೇಳಿ ಹೋಗಿದ್ದಾರೆ, ಯು ಅಸೈನ್ ದ ಡೇಟ್ಸ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ, ಎಕ್ಸೆಪ್ಟ್ ದಟ್ M.R. ರಾಜಗೋಪಾಲ್ ಸೀನಿಯರ್.
ಅದು ನಾಳೆ ಆದ್ರೂ ಆಗ್ಬೋದಾ ಮೇಡಮ್? ಮೇಡಮ್ ಅಲ್ಲ ಅದು ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್
Court officer.
Court officer. Court officer.
Court officer. ಅದು ಲಿಸ್ಟ್ ಟು 230 ತಗಂತೀರಾ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್? ಆಯ್ತು.
Not a request to the court, the audio is completely muted, if I can be.
One point 23268.
The writ petition is filed, seeking the following prayer. The memo is filed on behalf of the bank, that is the third respondent.
Fifth respondent.
Fifth respondent bank,
33.
stating that during the pendency of the writ petition, but the petitioner borrower has settled the loan account and a one-time settlement of an amount of 70 lakhs. Hence, in view of the settlement, the writ petitioner does not survive for consideration. Accordingly, the same.
Please, my lords. My lords, I appear for the petitioners in this matter, my lords.
In the light of the memo, we'll dismiss the writ petition as infractious.
My lords, we will file a reply to that memo, my lords. We may be given an opportunity to file a reply to that memo, my lords, because other prayers are, my lords, will sustain.
No, when you settle the entire dues, what remains?
My lords, I have paid the dues. I may have paid the dues, but other issues regarding the payment they have disbursed to the.
What are the other reliefs? Let's see. What are the other
Yes,
reliefs?
please, my lords.
And whether this court will go into those reliefs?
Yes,
Prayers that can be
my lords,
granted to this
prayer
court?
5. Prayer 5, my lords. Issue appropriate written directions or order directing the RBI and NHB to inquire or appoint a committee to inquire the connivance of the respondent bank and respondent developer in relation to disbursement of loan amount without verifying the construction work. Because this is regarding the instructions and the standing orders of the RBI. The other prayer is not somewhat same.
No, after paying the amount, it has become more or less an academic interest, nothing else. Yes,
that they have, it has to be seen whether they were complying the RBI directions or not, Manoj. I may be given an opportunity to file a reply, Manoj.
Not required. Yes, in the light of the memo filed with the bank, the writ petition is the writ petition is disposed of. Then counsel the petitioner submits that there are other prayers, and this court is not inclined to go into the other prayers. Yes, 1.1. What about this?
My lord, in this case, HDFC matter,
We filed objections, my lord. My lord, so apart from these matters, my lord, all the matters are Ojon's matter. My lord, as far as HDFC is concerned, the other 47 matters are also I will be permitted to file a memo to club these matters also pertaining to the same projects. 47 writ petitions, other 47
They are not listed today.
not listed today.
Yes.
I'm filing.
Along with
If all the
this-
matters are listed, my lord, the allegations are similar in all the matter.
This 1.1 shall go along with that.
1.1, I am representing on behalf of the HDFC Bank.
That's what I'm saying. 1.1 is connected with other.
Yes, my lord.
Yes, list 1.1 along with the other connected matters on Tuesday at 2:30.
My lord,
Yes.
1.25 may be delinked, my lord, because we have no objection to proceed against the builder, my lord. Last time also same has been submitted.
No,
And the builder,
1.2, I'll call each, please wait, I'll call every matter.
Sorry,
1.2,
Same connected.
Please, my lords, I appear for the petitioners in this.
My lord, the project wise, if you take my lord, 1 is also belongs to Ojon projects.
yes.
May-
1 What he is saying is he has given another list of 40 matters. That I
All
will
this
take
could,
up on
all this
Tuesday.
can come on Tuesday, my lord. All this can, so principally in all the petitions, the list is the same. The list is, the banks have disbursed.
Because I have specifically listed.
Yes,
these
yes, your
matters.
lordships are right, my lord.
Whatever are there in the
Is
list.
in
we
fact,
will
your
hear.
lordships directed us to place certain documents that has also been done.
We will
My lord, I'm
hear-
just scaling down, my lord, the lists in all the petitions, my lord, whoever is the builder, whoever is the customer, the list is that they have, my lord, the loans have been sanctioned, housing loans have been sanctioned in favor of individual LRTs, and individual LRTs, my lord, loans have been given to the builders. Builders have not delivered the possession, and there is action for recovery by the banks. That's all.
As far as that bank, the matters are not listed.
Yes, my lord. Yes.
We'll hear it.
The
on
disposal was
Tuesday.
proper, my lord.
Whatever the order that this court is passing in this petition.
That's all. Your lordships may kindly call all the matters on Tuesday, my lord.
No. I'll hear the matters that are listed today.
Greatly obliged.
Yes.
Greatly obliged.
Yes. 1.2 along with that matters on Tuesday. 1.3.
Same, my lord.
No, same, my lords, I appear for the petitioners.
Code of 15506 1870.
So what is the difficulty? Whatever the order that is passed in this,
Yes,
that
my
will
lord.
follow.
I am permitted to play.
Because these matters are
Yes,
specifically listed.
1.1, my lord, 1.1.
Hmm.
1.1, their contention is that, my lord, I have violated, I have not advanced the money in a phase-wise manner.
Council argue first. 1.1, who appears?
I appeal
Please-
for the
Yes.
petition.
Please, my lords, I am also for the petitioners, my lords. 1.1. Sorry.
My lord,
Sorry, my lords.
the issue involves, my lord, here, there is a tripartite between, agreement between bank, home buyer and the developer. The entire issue comes to a point
Only goes
where
the writ petition. Yes.
it pertains to a subvention scheme, my lord. That is, what happens in the subvention scheme is, out of 100% sale consideration, 10 or 20% of the sale consideration will be the own contribution of the petition. That is from their own money, that is booking amount. The remaining 80% of the money would be availed in the form of home loans, different banks, depending on this. What the RBI guidelines when it comes to subvention scheme way back in the 2013 itself, which says that the banks which gives these kind of loan subvention scheme, they have to release the amounts based on the stages of construction, not at once. Based on the kind of fraudulent activities which has taken place, there is a guideline which in the 2013 that the
Where are
scheme.
the guidelines? Have you filed?
My lord, in this petition, I have not produced that guidelines. In the connected petitions, in every petition, there is guidelines. If it,
Pass on.
I will.
This must be the writ petition.
Lord, grant me leave of 2 minutes, my lord. I'll just come.
Yes.
Grant me leave of 2 minutes,
Yes,
my lord.
yes.
Great.
I will read the provision, but before I'll explain the case, my lord. Then, since the issue involved here is a future construction, because for 3 years there will be a time given to the developer to construct the property. So, in the event of cancellation of
Where is
allotment,
that tripartite agreements that you must have filed it? Where is it?
yes, my lord, it is at page number 86 of the petition. This petition.
Hmm. This is not the one.
With my lord's kind permission, may I be permitted only one sentence, my lords? All these, my lords, the customers, that is the purchasers, were asked to file a memo or an affidavit indicating whether they are interested in pursuing to buy the
Where is that
apartment.
order last time order that was passed?
Please, my lords.
That is passed in which petition?
You
done? Pursuant to this order dated 10/11/2025, anything is filed by the petitioners?
And no, I am ready. I'm ready with the memo. I can file it. All the petitioners do not want the property. They are proceeding with the petition. They do not want to retain the property. It's the intention. It may be recorded. I'll file the memo also to the.
Because there will be some.
But also, my lord, the banks have been directed to state the disbursement.
Yes, that is it. So,
With respect to intention and retaining, I am making that mention. All the
so
petitioner.
in which petitions?
This is 1.1, my lord.
1.1 not interested.
We are not interested to retain the property. We are proceeding with the petition.
Then where are the other matters you are appearing?
There are other matters in all my petitions, my lord.
Where are your all petitions?
Serial number 1. I'll make mention, my lord.
1.2 Rajesh P. No.
Please, my lords, appear for the advocate Rajesh, my lords.
Serial.
No, 1 minute.
1.10, my lord.
1.10. 1.10. You're not interested in this also?
Yes, my lord.
Then?
Next matter, 1.11, 1.11 also not interested. We are proceeding with the petition. 1.11. 1.12, I am filing a memo of withdrawal. I'll withdraw the petition because they are retaining the property. Wherever I am retaining the property, I file memo of withdrawal today. And
already filed?
No, I'll file it today, my lord.
Give it during the course of the day so that it doesn't have to release
Much
again.
obliged. Much obliged. 1.13, not interested to retain the property. They are proceeding with the matter. Then 1.15, my lord, I am withdrawing today. There are 3 matters apart from 1.15 to be withdrawn. I'll be withdrawing today. 1.16 continue. 1.17 continue.
17 also.
Yes, my lord. 1.22, I'll be continuing with the petition. 1.26, my lord. The intention of the party is to retain the property, but they are trying to some sort of settlement with the banker. So it may be kept in abeyance for the next 1 week, my lord.
Next. That's it. Your matters are.
1.28, I'm continuing, my lord. And 1.34. These are all my matters, wherein 3 matters I'll be withdrawing.
1.3 also will continue.
Continue.
Then what about 1.4?
1.4, I am appearing for the respondent.
No, petitioner.
1.
Rajesh.
1.4, my lords, I appear for on behalf of Rajesh Pandey, my lords, advocate Rajesh Pandey.
So you want to retain the property or?
My lords, we have following the home buyers, my lords, because we have also batch matters, my lords, a lot of home buyers are there, but because of not specified timelines, my lord, they are having a difficulty to make a call, my lords, because builder was also directed to file an affidavit or memo to that record, my lords. What is the timeline they will complete the project? Please, my lords.
So we have to take that you want to retain the property.
My lords, we will take, first call is this, my lords, but we have to take a call after the timelines can be specified because the builder has not filed that memo, my lords.
As of
In
now,
what
as
timeline
of
they will
now.
construct? Please.
Mr. Counsel, as of now. As of now, you want to retain the property. Next, 105.
I'm for the petitioners, my lords. My lords, 3 of the petitioners have settled with the bank in this, and remaining 3 want to exit the product. They don't want to retain the, so we'll continue with.
Not interested.
Not interested.
106. Rajesh.
I appear, my lords, in same instructions, my lords, to read.
Then 107, 1.7.
Same, my lords.
Rajesh.
Yes, my lord. Same instructions, my lords.
Not interested.
1.8.
We'd like to exit the project. Not 1.8.
interested.
Not interested.
You want to not withdraw. They're not interested with the security.
Because in these cases,
1.9.
most of them have RERA orders, my lords, for refund. Or that is.
I'll call links of that. 1 point Vikas.
Those are not interested to retain the property.
So at least we'll have a clarity. By this time, you should have filed the memo. Instead of,
Memos are ready, my lords.
in all the matters filed.
It's ready, my. We'll file it today, my lords.
114. Rajesh P.
Please, my lords. Same instructions, my lords. In all the matters, my lords, the instructions are same.
So that means you have no instructions.
Yes, my lords.
18.
They have to take the call, my lords, after the builder can disclose what timeline they will take to complete, my lords.
Continue. Then 19.
Same, my lord. Exit.
Ketan.
1.19, 1.20, and 1.21, my lords. Exiting the project.
1 point, or in all your matters.
1.20 and 1.21 as well.
Then 2-3. Shivani Shetty. Respondents. Then 1.24 interested.
Please, my lord.
1582 for the respondent bank or lordship. In this matter, we will proceed against the.
1 minute. 1.25.
Senior counsel is in the another court hall. Matter may be passed on.
Whether you're interested with the secured asset or not.
Senior counsel will make the submission.
He'll only say.
My lord, in this matter, there may be de-linked, your lordship, because we are proceeding against the only builder, my lord, as a prayer has been allowed, my lord. That is the instruction from the bank, your lordship.
I had
Kindly dealing this matter, my lord, have it tomorrow, your lordship.
May I submit? On the last hearing date, the same submission was made saying that the writ petition could be
You
allowed.
appear for the builder.
I appear for the builder. So therefore, I had made a submission that the petitioner has already approached RERA. And I am facing the same reliefs which are sought here, there.
Yes.
So therefore,
Then
my lords,
1.27.
my lords is 1.25
Please,
passed over.
my lords, I appear in 1.27, my lords.
Then 2.9. So Rajesh P. Continue. Next, Ramaya. 30. 1.30. Next. Sharon BT. Take that memo. Not the withdrawal memo. Take that memo. Not interested. No, keep it. Next.
So we will see some time to get back regarding the settlement of
No, please wait. Then 3-3, Kavita. This matter, then we'll dealing this, dealing 1.33, list this matter on Wednesday. No, why for the parties to come? 2:30 on Wednesday. Next. This also same. Then 136.
1.36, we don't want the property. We
Oh.
want to continue the petition. Filing memo to that.
Take
My lords,
that.
I appear on behalf of respondent 8 to 10, my lords. I accept notice on behalf of.
Please wait. Continue. Then Rajkumar. Not interested. Take that. Take all those memos and keep in the respective files.
My lords, in 1.40, I appear for the petitioner.
Yes.
My lords, am I audible?
Yes, yes.
My lord, the petitioner has neither received the possession nor is he interested in receiving the possession. They are willing to continue with the petition itself.
Yes.
Serial number 1.41,
Same.
same.
Same, my lord, same. From 1.40 up. Same, my lord, same.
4243,
My lord, same instructions up till 1.51. From 1.40 till 1.51 in all of them.
Yes.
1.52,
Hmm.
We don't want the property and not continue. Filing memo to that.
1.53,
Memo is your next.
1.54,
I'm for petitioning. In this case, notice has to be issued. Thereafter, I will file my memo.
This notice is not ordered. Which is the
Notice
bank?
is-
Union of
See,
India.
SBI, State Bank of India.
Who takes?
Minutes.
SBI.
Minutes, I take.
For Union Bank?
Union of India.
SBI,
SBI.
bank is SBI.
State Bank of India.
Vijay Shetty. Turan.
Harish?
Notice.
Disbursements.
The Patel is directed to take notice.
And
This also dealing 1.54. Then 2. Next 2.
Serial preliminary and B group serial number 2,
Joshi.
Joshi.
Actually, 32 matters were moved. Almost 10 matters have been discussed. They may also be connected and
No,
this is not easy. I filed the necessary memo for all the petitions.
All you are not interested.
No, ma'am, I filed the relevant. So there are some
No,
properties where
no,
I'm
no, no.
interested, there are some
Do you
properties
have instructions about the matters that are there in the list today?
Thank you for, I do not, yesterday I moved the.
Yes, yes. Come to the first matter. There's 1.1. Yes.
Let them serve the memos, my lord, which are all the cases there. We will also file a wait. Memo.
All that, please advance arguments. All that are not relevant. Yes.
Similar matter, my lord, the coordinate bench has passed an order regarding the subvention scheme.
Hmm.
I am permitted to place their judgment also. They will permitted to place their judgment also. I came to know that an order has been passed in one of the petition. Subventional matter.
When was it passed?
When the order? Last month.
What is the order?
Order that writ petition has been, I came to know that my lord of construction, it has been dismissed with petition. We permitted to place that judgment.
Is it so?
There is one matter, it might have been dismissed, but my lord, the present matter, in the very similar matter has been allowed by the single judge of, a single bench of this honorable court, which is pending in appeal, and it is yet to be adjudicated. And there has been a very same interim order, which is subsisting as on date, my lord. So a final order has been passed in the similar matter, which
Where is that order? You
um,
have the copy of that order where the writ petition is allowed and dismissed as well.
I may be permitted to produce it.
You also don't have?
That is PNB's matter.
Huh?
Monthly projects that matter.
You have the number?
Yes, 17696.
Look at it. 17696
696 of 21.
My lord, the argument in that matter, my lord,
W.
State and.
addressed.
If I may, Your Lordship.
You have?
This is the writ appeal order where the bank had challenged the writ petition, which had reached
Allowed.
finality, and the stay has been granted and protection was continued. The writ appeal order.
Writ petition order is also there.
Illa Swami. No, Your Lordship.
Yes, look at it.
Easier. I have the Himanshu Singh.
Lordship, if I may, to be permitted, there is one more matter, similar in nature, pending before the Honorable Supreme Court. I am producing that.
Take that.
I'm producing the interim order. Point number 9 is relevant to this set of matters. Your Lordship.
36780/2025. my lord.
All these matters pertain to a tripartite agreement and a subvention scheme. Your Lordship.
When is this order?
That is in a similar matter, my lord. Supreme Court has also stated. In the
This is
subject-
Suryakant's order.
Yes.
Yes.
Yes, madam. And
that
the
builder
High
bank-
Court order, which clearly has granted the relief at page number 149 of serial number.
Please take that. Court officer.
My lord, the recent judgments of coordinate bench, my lord, writ petition number 36780/2025.
It seems he has it.
36780/2025.
No, this is dated 14th September 2022.
Yes,
The
my
order
lord.
was
This is
passed
the
by-
final order, which is in appeal as of now, which has been we are mentioning about this. So page number 140.
This matter, the writ petitions are allowed.
Yes, my lord. The very same relief, it may be seen at the operative portion at page number 149. Single bench.
My lord, that matter, my lord, I am permitted.
Maybe
One minute.
making a submission.
Oh, thank you. My lord, in that matter, monthly's matters, my lord, the argument addressed by the other side, not even a single brick has been let off in the project. On that context, the order was passed by the coordinate bench.
That's why I will
May I
understand.
permitted to make that clarification here, my lord, with
No,
respect to that.
before both of you submitting the arguments, let me look at the order. What
It
is
is
the
at
contention
149, my lord, operative portion.
considered?
This matter is already project has been completed.
Let's see how how this case is, the other cases are different from the decided case.
They have. They have.
No, in which paragraph issue is decided?
My lord,
This is the current state.
the page number 77 of the judgment, that is 148, my lord.
That's operative portion of the judgment.
No, my lord, 149 is the operative portion.
148, yes.
Yes, my lord. Wherein the very same maintainability of the petition was questioned.
We will not go into that about the maintainability. Well, factually, what is decided?
My lord, that is at page number 134, 134, 135, 136, my lord.
Let's read that.
My lord, before that, I may make the submission with respect to issue involved here is the tripartite agreement, my lord. Once the cancellation of a booking either by the borrower or by the developer for whatever reasons, what happens to the money which is borrowed by the developer in the name of home buyer? This was the question. To protect it, my lord, in the tripartite agreement, there is a clause. In the event of cancellation of the booking apartment, it is the developer who has taken the benefit of the loan. In reality, has to repay the entire amount to the bank immediately. This is the clause in all these petitions, my lord. The entire petition is based on
That is where there is a cancellation.
where in the event of cancellation, either by builder or the thing. In all these matters, my lord, all the banks have entered into, if I may say so, 95% of the banks have entered into tripartite agreements with builder and the home buyer, wherein based on that assurance, the loan amount have been dispersed to the developer. Now, in the petitions, my lord, what is being discussed here, that was the ground which was raised to seek these kind of relief, that all the petitioners herein, due to the failure of the builder to complete the project, have withdrawn from the purchase of this apartment unit, which is intimated to the developer.
In all the cases?
Yes, my lord. In all 35 cases which were decided this, the same was been intimated to the developer, same has been intimated to the bank. But still, banks are proceeding only against the borrower, despite of the clause that they have to go before the developer. This was the issue involved in the matter. And the no reliefs has been sought against the developer at all in this, except for a direction to adhere to this. So in these matters, my lord,
that is one of the issues.
That was one of the major issues over here, along with the.
And if I remember on the last occasion, arguments were advanced stating that there is a collusion between the bank.
Yes, the second most important ground on this is how the financial institutions have been aiding the developer by not proceeding against them and dispersing the loan without investigating or without conducting.
So, as per the tripartite agreement, how the dispersal of the amount should be?
That is not as per the as per the tripartite agreement. They say the money will be dispersed as per the demand, made as and when it is required. But the moment the tripartite agreements have been signed, the loan agreements have been approved, 80 to 90% of the sanctioned amount within 1 day or within 2 days, within 2 transactions, entire amount has been transferred to them.
There are no guidelines of the RBI also.
Yes, there is, my lord. There is. If it may taken up serial number 1.24, I have produced the policy which is issued by NHB as well as RBI, my lord.
1.24.
That is repetition number 24137.
1.24, that is WP
22. 1 to 24, 130. Maybe.
2 point.
Take that.
2.24, sir.
Yes.
That is the policy, my lord, issued by NHB, who was then governing all these regulations with respect to that. That is page number 85. Point number 3, my lord. It's point number 2. It has been brought to our notice that some of the HFCs are making upfront disbursal without linking the same to the stage of construction of housing projects. Further, some HFCs are approved certain projects for the advanced disbursement facility. HFCs are once again advised that the dispersal of the housing loan should be strictly linked to the stages of construction, and no upfront dispersal should be made in case of incomplete or unconstructed projects. The prevalent schemes of HCF, if any, need to be reviewed on the above lines in order to remove inappropriateness of funding exposure with the concomitant of risk of diversion of funds. This is the entire gist of our petition, my lord.
No, please come to that tripartite agreement.
Yes, my lord. In the very same petition, my lord. 1.22.
1.2.
Yes.
1.22.
I appear for the.
My lord, as far as the tripartite agreement is concerned, my lord, that's what I wanted to try to submit before the court. My lord, each and every banks will have different tripartite agreement, not a similar tripartite agreement. The terms and conditions stipulated under the tripartite agreement varies from bank to bank. My lord, it is not similar. The judgments, my lord, which came to be passed by the coordinate bench is based on the tripartite agreement entered into.
No, we are not looking at that judgment. We will look independently with each agreement.
Yes, my lord.
Tripartite agreement,
Yes, my lord.
all of them are having. So coming to this case.
72, my lord. Page number 72 is the tripartite agreement.
72.
Yes, my lord. Relevant portion is page number 74. Point number 4. That in the event of developer cancelling the said booking for any default committed by the borrower, or project is shelved by the developer, or any other reason whatsoever, the developer shall, subject to terms and condition of the agreement of sale dated so and so and agreement of construction, pay the disbursed / entire amount received from the borrower to the SBI after deducting dues. My lord, this very same kind of, the wordings may be different, my lord. The very same kind of.
Coming to this case, when was this agreement?
Agreement is dated 2019. I mean 21st December 2019.
What is the stage of construction in this?
It is not complete, even as on date. It is not ready.
How many floors?
In many cases, only the structure outside is being constructed. In many cases, there is no building at all. It is been abandoned by the developers. The stage.
Their amount is
Yes, my lord. The very first day the loan is granted, my lord, with respect to one flat, the developer has received the 100% sale consideration towards that property, even without construction. The day an agreement is entered, the 20% will be paid by the borrower, the home buyer. Remaining 80% within a month, the money would have gone to the developer.
Now the circular which you are relying on is of the year 2016.
Yes, my lord. By the date they entered the sale agreement, the day the banks have sanctioned the loan, this circular have been there. And even before this, there is one more circulation of a circular of 2013 as well, my lord. This protection that not to give an opportunity for the developers to make undue advantage of it is there from 2013.
Which bank in this case?
In this is SBI, my lord.
In this matter, my lord, 1.22, the demand letter placed by the petitioner along with disbursement request form has already been placed on by way of memo. The advocate who is appearing is on his way. I also appear for State Bank of India, but not in this matter, my lord. My lord, there is a specific clause, my lord, of tripartite agreement which is absolutely binding on the borrowers, irrespective.
No, all the clauses will bind everyone.
My lord, most of the matters, what has happened, my lord, the petitioners, the borrowers have intimated the State Bank of India by way of mail that they want to withdraw from this said purchase. They want to back out.
That is one aspect. That is one aspect. No. When before they have come before the, why they have come before the court? Because you have initiated the proceedings under the Act. So when this clause number 4, when it clearly stipulates, in case of any of this nature, you have to take action against the for the recovery against the builder.
I was completing, my lord. My lord, the clause 2, my lord, is very specific.
Let's read the clause, let's read the clause.
Yes, my lord. That the builder agrees that, my lord, this is not, print is not correct.
Developer has a.
The developer agrees. The developer agrees that it has no objection to the borrowers agreeing to mortgage the said townhouse with proportionate share in land to the State Bank of India as security for the said loan agreed to be advanced by State Bank of India for the purpose of purchase or construction of the said townhouse. Now, my lord, this is very important, my lord. In the event the default of the repayment of loan and or the borrower committing any other default which makes the borrower liable for the repayment of the entire amount outstanding in the said loan as per the terms of the loan agreement executed between the borrowers and the SBI, the developer shall. Now, this is very important, my lord. The developer shall, at the call of SBI. What has happened here, my lord? The borrowers, they have intimated that they are withdrawing from the said purchase through email, and only after giving 2 days time, they file the writ petition and obtain interim order. The opportunity for State Bank of India to recall the loan from the developer to invoke the provisions of tripartite agreement was never given. Otherwise,
If
my lord,
no, if now at this stage, no, you can proceed against.
that is what, my lord. My lord, this
That
is
is
the
one
case
aspect. Then how you are dispersing the entire amount?
on the request of the petitioner themselves, my lord. That is what I said, my lord. They have produced, I don't know, the advocate has produced. I was instructed that it was produced by way of memo. In fact, in the other matter, I have brought the memo, my lord. The demand letter and disbursement request forms are placed by the petitioners themselves. They themselves are surpassing the guidelines which they have read. This is
My
the
lord,
issue, my lord. This is
while
the case.
while granting the loan, the booklet which contains that mandatory provision of you should sign all these documents, which contains one of the slip that it may be dispersed in their favor. The reason what the banks give it to that is, if not for this, we will not be able to disburse the loan in favor of developers. So you should make a request that money should be disbursed in the favor of developer. My lord, even that is considered, my lord. The stages of construction is the guidelines, is the rules which is casted upon the banks independently of all these things. Independently, if they have to disperse the loan, they have to make sure whether the building is being constructed or at what pace will they be able to complete it. So these are all the checklists they have to follow before granting this. They cannot now put the burden on the home buyer saying they have signed the document, we have dispersed it, it is their request. This is what is the very same point what is taken up by my learned friend was answered in the judgment which is placed before this court. They make the very same contention in the very same tripartite agreement. There are other clauses which makes it clear that it is jointly and severally on the home buyer and the developer, my lord. That has been answered at page number 135, 136.
Is it correct that what he is submitting that immediately after sending a email to the bank, you came and filed the writ petition before the court?
Yes, my lord. Yes, it is not within 2 days as the this. We waited for 15 days. We did not even get a response or to that email.
No, in all these cases, what is the stage of the proceedings?
In stage of construction.
Proceedings.
My lord, in 5 matters of mine, that the construction is taken by the association saying that they will complete the project. The project is not complete. In few others.
So what proceedings the bank initiated?
Nothing. Only against me. They have been filing check.
What is the stage
Check
of this
bounce
proceedings?
case that has been closed now. All these check bounce cases which was filed by different banks have been withdrawn based on the interim order granted by this honorable.
Then what is the other what are the other proceedings?
TRT proceedings. DRT proceedings is being initiated with respect to the property. My lord, my grievance is not with respect to the secured property at all, because I am not interested in it. But my lord, when the property is not in existence, if they initiate recovery DRT proceedings, they'll be unable to sell that property in an auction. Immediately a recovery certificate will be issued in my against me. They can come after my personal properties for that. This is the grievance why we had to approach this honorable court within the short span of time without giving an opportunity to proceed with all these matters. If they go before the secured asset and they want to auction the property, I have no grievance at all, my lord. If the secured asset is ready and they are going against it, and in the event if they fail to do it, if they undertakes to say that we are proceeding against the builder, my lord, I have no grievance at all. I will say I am agreeable to this. The problem here is, my lord, the properties are not yet ready, even after 8 years of delay. And we don't know when it is going to be ready as well. Once it cannot be sold in auction, either surface proceedings or this thing, they can come after the personal assets, personal accounts of all these petitioners, saying that that property was unsold in an auction. This is the grievance why we have come before the court, saying that we are not restricting the bank from proceeding or initiating any action. We are only requesting the bank to adhere.
Two sets of petitions. One who is not interested with the secured asset, and the others who wants to retain the secured.
Yes,
asset.
my lord.
Then who wants to retain it? What is argument?
No, my lord. In those matters, I'm withdrawing the petition. I'm withdrawing the petition. I have no argument over that. My lord, as long as I cannot seek the relief of both retaining the property and not to proceed against me. As long as the people say, any petitioners say their intention to retain the property, I'm withdrawing the petition without proceeding further, because there is no case which can be made out. But I am concerned with the places where the property is not yet ready, and for nearly another 1.5 years also they cannot complete the project, because except for the structure in few there are not even the basement which has been laid. And these are all the cases.
Let us come back to the from 1.1. Yes. Where is that? 1.1. 15506. It's here. Yes.
My lord, maybe.
All of these transactions cannot be just termed as commercial transactions. The right to residence is a right that's guaranteed. This is the latest judgment of Division Bench of Supreme Court on September 12th, and it applies number 20 of this judgment date.
Yeah, point is not yeah. Possession
she wants to know what is the maintenance. ಅದೊಂದು ಬಿಟ್ಟು 3 years. 3 years you're talking.
Yes, 20.
This court, in the canon of decisions, consistently held and reaffirmed that the right to shelter is an integral part of the right to life under Article 21 of the Constitution. This recognition casts a corresponding duty on the state to ensure access to adequate housing, particularly for weak Indeed, various schemes such as PMA have been initiated by the government to provide affordable housing. A home is not merely a roof over one's head. It is a reflection of one's hopes and dreams. A safe space for the family, a refuge for the very city world. With India rapidly industrializing and rural to urban mobility proceeding at lightning pace, the demand for housing has risen sharply. Yet the plight of tax-paying middle-class citizens paints a disheartening picture. Having invested their lifelong savings in pursuit of a home, many are compelled to shoulder a double burden, servicing EMIs on one hand and paying rent on the other, only to find their dream home reduced to an unfinished building. In some cases, construction has not even commenced despite full or substantial payment,
An average home buyer may be a teacher, lawyer, doctor, IT professional, or government employee who has poured his or her hard-earned money into the pockets of a developer. For such individuals, a stable roof over their family's head is all they desire. The anxiety of not having a home despite paying a fortune.
Come to paragraph 21.
Yes.
Paragraph 21.
This code reiterates that while investors are integral to any industry and their interests, warrant protection, speculative participants driven purely by profit motives cannot be permitted to misuse the insolvency and bankruptcy code. This was with respect to insolvency and bankruptcy code. But the other paragraphs just before that, if I may be permitted to read, 20.4, those are the essential. 20.4 says, thus it would be thoroughly erroneous to treat home buying as a mere commercial transaction or worse, to reduce housing to a status of speculative instruments such as stocks, debentures, futures, or options to creative contractual devices. Housing is neither a luxury nor a commodity for speculation. It is a fundamental human need. The right to secure peaceful and timely possession of one's home is therefore a passage of fundamental right, Article 26. Therefore,
Yes.
they hold that it is not in the commercial transaction spectrum.
Yes. Come to this 1.1.
My lord, last
Who appears for the respondent in this?
1.1.
1.1.
That is Omega.
I am for the petitioner.
Respondents I'm
Respondent,
asking.
that is Madhukar M. Deshpande, SG Sumati, TC, Francis Xavier.
None.
You appear for the bank.
And for the bank in this matter.
So in this case, they are not interested with the secured asset.
Yes.
My lord, if I may make one submission. The last occasion, how there was another direction which was issued to bring out that what is the amount of disbursement amount and the date on which.
That is not fine.
Okay, prepared, my lord. It's ready. In this case, what they argued now, we disbursed the 100% of the loan amount of spread, which is incorrect in my cases.
It is disbursed 100%.
No, it has not been disbursed.
So that's fine.
100%.
Now you must be having the data in 1.1.
1.1.
How much amount you have disbursed, when you have disbursed?
15506. There are as many as 16 petitioners in this matter. Not only one petitioner.
My lord, that
All
is
of them, 1 second, sir.
How can there be 16 petitioners?
All of them.
Cause of action is different.
Yes,
all of have
But
them.
amounts are different.
Yes.
Amounts are different, my lord.
Then how can you maintain 100 petition?
My lord, in all these things, we are not disputing the amount. We are not going through the amount what has been dispersed, and we are not talking about the date of agreement or anything. The only point of consideration is whether the builder has failed to complete the
Now in
project.
this case, if they have to say how much is an amount dispersed, when is it dispersed, how is it dispersed, in respect of 100 petition for 16 people, so different dates, different amount, everything has to be stated now.
Different date of agreements.
My lord, except this matter in all these cases, all other matters are individual.
So then please come to this.
It is only exceptional case.
Yes. Now,
My lord, kindly see my lord 15506. The chart.
take that.
Chart.
Take that. Take from them.
Next matter, 17 petitioners. 1871.
That is a different petitioner. I am making my
Petitions are maintainable, right? It's an independent cause of action for each individual, and that is also already it's a commercial transaction.
since there was no dispute with the facts, my lord, only on that. ಏನೋ ಕೇಳಿದ್ರು ಸರ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಏನೋ ಕೇಳಿದ್ರು ಆನ್ಸರ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಪರ್ಮಿಷನ್ ಕೊಡಿ.
This is the we are submitting before the court. Submitting before the court.
Disbursal date.
Disbursal date. Only 85% of the amount has been disbursed, not full amount.
From when to when?
My lord, I have marked 15.
In a span of
15506, 2014, 2015, 2016, 3 years.
3
years we disbursed. That is the reasons, my lord, we permitted to demonstrate the photographs. Kindly see the photographs, my lord, in this matter. The building has almost constructed, completed almost. And my lord, their argument is that they, when only structure is there, which is incorrect. The building is Vojan as far as the Vojan project.
No, in this matter,
yes,
all these petitions have communicated to you that they are not
they
interested.
are not communicated. Let them say, my lord, when they are communicated to us.
All the complaints failed by them for refund of the money which is granted before RERA. Even they have appeared in those cases, my lord.
No, these
They
petitions
are not
are,
the parties in RERA.
no, it will be easy if
madam.
only to whomsoever I'm asking, if they answer, I think we'll be able to.
Yes.
Now, all these petitions have gone before the RERA.
Yes, my lord.
And got your amounts, whatever paid.
No, no, my lord. They've got only orders saying that they have to refund the money with interest.
Even that order is also there in favor of the petitioners in this writ petition.
Yes, my lord. That is there and which is pending in contempt
Please
now.
come to the tripartite agreement in this writ petition.
In this, yes, ma'am. It is at page number 86 to 95 is the tripartite agreement.
86. Which is the clause in this?
Point number 16, my lord.
There are no.
Page number
Yes.
94.
16.
In the event occurrence of any default under the loan agreement during the liability period, which would result in cancellation of the allotment as a consequence thereof, or for any reason whatsoever in allotment is cancelled, if the allotment is cancelled, any amount payable to the borrower on account of such cancellation shall be directly paid to the HDFC. However, if it is agreed that between the parties, such payment made by the seller directly to HDFC shall not absolve the borrower from his liability. Both the clauses are in the same, my lord. And point number 14 in the very same page. If the borrower fails to pay the balance amount representing the difference between the loan sanctioned by the HDFC and actual purchase price of the residential apartment, or in the event of death of the borrower, or in the event of cancellation of the residential apartment for any reason whatsoever, entire amount advanced by HDFC will have a charge on the said apartment, and agreement of sale of undivided share and the agreement to build both dated so and so. Borrower hereby subrogates all his rights in respect to the said residential apartment in favor of HDFC.
Yes.
So the wordings are different, my lord, but that is the purpose of tripartite agreements, is the protection to all three parties, because the money would have been granted by the bank for a property which would be constructed in the future. In that meanwhile, anything can happen between all three parties. All three parties should be protected, is the purpose for which the tripartite agreement is existing in all the petitions, my lord. That if builder fails to complete, or if I fail to pay the amount, the bank should not suffer. They have every right to go against the secured asset and the builder who is the real beneficiary of the loan. Now, my lord, only the loan is standing in my name. The property is not yet ready, which there is a delay of more than 8 years. Still, it is not ready.
Where 8 years it is? You're saying it is 2019.
My lord, the 2 years there will be a gap of the construction period. In all these projects, my lord, what happens is they show the land, they get a sanction plan, and they get the loan for the construction of the property. There will be no property, there will be no secured asset at the time of granting of the loan itself. So there will say, like, for example, my lord, in 2019, if I enter into an agreement, there will be a promised date of delivery of possession, which will be in 2019. And for the very same construction, they avail the loan. That is the reason why there is a delay, there is a gap, there is a cooling period of 2 years, 3 years in different cases. My lord, one more issue I want to bring it to notice. In those 3 years, my lord, the promises are made by the developers to pay the interest on the loans, whatever borrowed by the builders, because they are the real beneficiary of the loan. The loan interest portion of the loan for the 3 years would be paid by the developer to the bank directly. My lord, even these they have breached. Even these they have breached. Ultimately, the petitioners have been paying EMI to the property when there is a delay from 2018 onwards or 19 onwards in few cases till 21, 22 up to the date of filing of the petitions. Only when the courts, this honorable court was pleased to grant a issue an order protecting the home buyers, that is when they have stopped. Until then, my lord, no money is being invested apart from the land. Even for the construction, indirectly banks have been given the loans in the name of these subvention schemes. But as on the date of loan sanction, for every flat in an apartment, the developer has received 100% sale consideration, approximately around 80 lakh rupees to a property which has never been constructed completely. And in those,
I understood. Yes. Now, what do you say about this tripartite agreement? Why did you proceed against the borrower?
Since there is an obligation under the tripartite agreement, I am permitted to read. We only chosen one paragraph.
Please read.
I will take my.
Now, in this writ petition, there is an order by the RERA to refund the entire amount to them.
I am not a party in the RERA proceedings.
The builder is a party.
I am not a party in this RERA proceedings.
Who appears for the builder in this writ petition?
Please, my lord.
Who appears? You appear for the builder.
In this case, engaged counsel, senior engaged counsel, M.S. Shamsundar will appear, my lords. He is on his legs.
My lord, I am not a party. If they have already approached the RERA and got some orders. My lord, my instruction is that they file execution petitions also to enforce the order passed by the RERA. But we don't know what type of order has been passed by the RERA.
So now please read, let's read the
tripartite agreement. I will take my lord to page number 88.
80?
88. Tripartite agreement. My lord, obligations. My lord, I don't want to trouble my law. And my lord, last paragraph. And whereas the borrower and seller have entered into a separate arrangement and undertaking between among themselves, wherein the seller has agreed to underwrite the obligation of the borrower insofar as it relates to interest payment obligation by assuming borrower interest payment liability from the date of first disbursement plus fractional period of the month in which the disbursement is made October 2016. My lord, it is expressly stated that the seller has no liability with relation to the loan other than making the aforesaid interest payment to the HDFC till October 2016. Save and except the interest payment for the aforesaid period, the due repayment of the entire loan amount along with the interest for the same would be sole obligation of the borrower. This is one of the class. My lord, this agreement has.
This is one of the tasks when everything is going well, when he is when he is ready for that, when he wants to cancel the same, then what is it?
There is no cancellation as of now. My lord, no mail have been received. They have not communicated to us in writing that they are going to cancel the tripartite agreement and but the bank is entitled to.
In this case, have you addressed the bank?
No.
Any email is sent to the bank?
Individually have been addressed to the bank, my lord. And even at least if they say that we were not addressed to the bank or anything, the day on which the petition filed in 2021, we have expressly stated that we have got a RERA order, refund is being ordered, we are no more interested in the property. Well, now at the age of, on 2025, they cannot say we were not aware of.
My lord,
and my lord, interim order is only the protection granted to the petitioner. There is no embargo for the bank to proceed against the developer, even as on date. If the intention of the bank is to recovery of the money, no matter what, they can always proceed.
One of the coordinate bench, my lord, has taken the view since they approached similar matter, ozone matter. Since they approached the RERA, writ is not maintainable and accordingly writ petition has been dismissed.
and appeal has been filed on this.
My lord, my respectful submission in this matter, my lord, till today, my lord, since my lord directed them, whether they are interested over the flat or not, till today, there is no undertaking before the court that they have no interest or they are interested over the flat or not. There is no undertaking at all.
Particularly in this facts of the case, where they've already had an order from the RERA, where they're seeking entire reimbursement from an order is passed, you don't require any other specific affirmation before this court. That is sufficient. Order from the RERA, where they wanted to, want the reimbursement of the entire.
My lord, if such.
In those circumstances, taking it that they are not interested for the secured asset. No, what is your submission?
My lord, that will not absolve their liability as per the tripartite agreement is concerned. My lord, the tripartite, that is the reason I am permitted to read the tripartite terms and conditions stipulated in the tripartite agreement. My lord, they never disputed the tripartite agreement. In fact, their case is that there is a tripartite agreement. And in fact, their case is that certain terms and conditions have been stipulated under the tripartite agreement, which they have to follow. My lord, my case is that not that they are referring the RBI circular stating that the bank has violated the guideline issued by the RBI and upfrontly disbursed the amount to the builder. That is their case, the first submission before this honorable court. The second submission before this honorable court is that, my lord, some of the projects, it is only a skeleton structure has been put up. The project has not been completed. That is their second submission. My lord, my submission before the, as far as the HDFC banks are concerned, my lord, once they entered into a tripartite agreement and certain terms and conditions have been were admitted, agreed and admitted in the terms and conditions. That will not absolve their liability. I am permitted to read the next clause, my lord, in the tripartite agreement. In the tripartite agreement.
Yes.
And whereas the borrower agreed that in an eventually HDFC granting the said loan to the borrower, the repayment of the said loan shall be secured by creation of the security interest and the residential apartment and the finance on all rights, title, benefit that would accrue from the residential apartment till currency, and the term of the said loan to be advanced or advanced. The seller agrees to confirm they shall not take any note of the said security interest created by the borrower and undertake not to create any third-party rights of security interest of any sort whatsoever on the residential apartment without prior written consent of the HDFC. I will skip the next two para. I will take my lot to page number 90. And whereas the HDFC considered that the said request with clear understanding and irrevocable undertaking by the borrower that the subsequent to the disbursement, if any, as requested by the borrower, there would not be any repayment default for any reason whatever, including but not limited to any concern or issues by and between the borrower and the seller. Next. And whereas the borrower has represented and such representation being continuing representation, the borrower obligation to repay the said loan shall be the distinct and independent obligation, more particularly independent of any issue, concern and dispute whatsoever nature between the borrower and the seller. Then I will skip, my lord. I will take to page number 91 para 3. The said loan advanced to the borrower by the HDFC shall be repayable by the borrower by way of equated monthly installment.
That I think you don't have to read all these. All
Yes.
these will be there.
Yes,
Now we are
ma'am.
talking about an eventuality.
Yes, ma'am.
Where the builder is not interested with the secured asset, or there is any cancellation. Then which clause governs that? That is your for the clause number 14, 15, or 16.
16, my lord. The 16. I
Let's
am
read for 14 first.
first 14. After 14, I am permitted to read para 16,
Yes,
my lord.
yes,
If the
15.
borrower fails to pay the balance amount representing the difference between the loan, if the borrower fails to pay the balance amount representing the differences between the loan sanctioned by the HDFC and the actual price of the residential apartment, or in the event of death of the borrower, or in the event of cancellation of the residential apartment, for any reason whatsoever, entire loan amount advanced by the HDFC will have a charge on the said apartment, and the agreement of sale and undivided share and the agreement to build both dated sorry. The borrower hereby subrogate all his rights in respect of the said residential apartment in favor of HDFC.
Yes.
Next, my lord. Further, if the
No, please tell the court what is this?
my lord, in any event of cancellation by the or whatever may be the, my lord, the money which has been lent by the HDFC,
You will have a right over the secured
secured asset. My lord, again, my lord, 40. The 14 has to be read in conjunction with para 60.
No, let's read 15 also.
Para 15. If the borrower commits breach of any terms and conditions of this tripartite agreement, it shall be treated as an event of default under the agreement for sale of allotment, cum agreement for sale, or any agreement or document signed by between the borrower and the seller for the seller for the sale of the said residential apartment. That is speaking about the event of default.
Yes, next.
My lord, para 60. In the event occurrence of default loan agreement during the liability period, which would result in any event occurrence of the default under the loan agreement during the liability period, which would result in cancellation of the allotment as a consequences thereof, and or for any reason whatsoever, if the allotment is cancelled, any amount payable to the borrower on account of such cancellation shall be directly paid to the HDFC. However, it is further agreed between the parties that such payment made by the seller directly to the HDFC shall not absolve the borrower from his liability to pay the residual amount, if any, from the outstanding under the loan agreement. My lord, para 17. The borrower agrees that unconditionally and irrevocably subrogates its right to receive any amount payable by the seller to the borrower in the event of cancellation of the agreement of sale of the undivided say of agreement to build both dated HDFC. The said act of the payment by the seller to the HDFC in this clause shall be valid discharge to the seller of the obligation of the borrower. Such cancellation amount, all the right and title interest undivided and concentrated with the seller. My lord, such being the case, my lord, whatever the money, if the firstly, my lord, on any event of cancellations, my lord, whatever the money which we have dispersed to the developer has to repay the money on any event of cancellation. They are telling that they got some amount from the RERA. I don't know what is the order of the RERA. My lord, clause 16 says, my lord, that will not absolve the borrower. My lord, if any residual amount after adjusting that money, if any amount my lord remain pending, that I am entitled to proceed against them under the loan agreement. My lord, that my lord, first of all, my lord, there is no communication from us. Secondly, they are telling that they went to the RERA, they got some orders. My lord,
this writ petition is pending from 2021.
Yes, my lord. My lord,
if you want this matter to be taken to a logical end, I think the stand of the bank should be more clear.
Yes, my lord. My lord, in this case, my lord, apart from this agreement, they have also entered a subvention agreement. My lord, subvention agreement, it is not for their domestic necessity.
No, ultimately, it's for you to have the money that you have given to them from the borrower or from the developer. Now, as per the agreement, when it facilitates you to proceed against the developer, why do you want to advance this argument? Your interest is money.
Yes, my
bank's interest is money. You have the secured asset there. If either the developer is not paying the money, you have the property. You will sell the property and will have it. So the bank's stand, I think, should be very clear on this. It is like as if like the bank is arguing for the developer.
No, we are not bank.
Only from the bank side, the only issue is one, whether the bank is following the RBI guidelines or not.
In this case, we followed the RBI guidelines.
What is the RBI guideline?
The RBI's
how the disbursement shall be made as per that 16 circular he has read.
Yes, my lord. Accordingly, we funded the money. My lord, in this case, my lord, in all the commercial projects, my lord, the upfrontly they are asking 30% of the amount. Once the foundation is started or the going to be put up or started, and my lord, 30% of the money in all the commercial the transactions, the builder will demand 30. Builder issued the demand letter. My lord, the demand letter forwarded by the borrower, and the borrower has given the letter along with the demand letter to my lord to release the funds in my cases. Accordingly, my lord, not that we dispersed like other my friend has argued in one of the bank upfront they dispersed under 100% of the amount. In my
the stages of construction which they are want to show the photos
in tower U,
in tower V, U and Y of the very same project, my lord, is this.
Sure.
A construction which is started in 2019, for which the entire amount is disbursed.
Entire amount is disbursed.
This is the towers U, V and Y, my lords.
Which bank?
HDFC as well as India Bulls.
No, we have
Ozone. Basically ozone project we are showing it.
case number.
So
We have not. Ashish Misra. My lord, Ashish Misra's. Huh? 73?
7330.
One second.
So from 2020, so I'm sorry to interrupt. From 2021, their stand is that the project is ready. Even till today, they say project is almost ready.
No, which date is this photo?
This is
2022, my lords. This is the update sent by the developer himself, my lords. This tower U,
By the
V
time
and
the entire amount is disbursed
Yes,
by
to
2020.
2019.
60%, my lords. In this case, 50 to 60% has been disbursement. In fact, one of the petitioners.
I think here it is still the excavation is going on.
Yes, my lord. It is the update sent by the developer to the petitioners.
Where is the senior counsel for ozone?
He's working.
My lords, in fact,
5 minutes. He'll come.
And there is a CBI inquiry which has been ordered against the developer, ozone developer, the very same developer which we are talking about, stating that there is a nexus between the bank developer to defraud the home buyers.
Under
The
this
CBI
very-
inquiry is pending, my lord.
under this very same subvention, FIR has also
What
been
they
filed,
are
my
referring
lords.
my case.
Here in Bangalore or?
Yes, madam. My lord, what they are referring in my case, Asim Misra's case. Now they are telling foundation has not been started. We only funded 10% of the loan amount.
Plus 48 lakh has been disbursed, my lords.
10%, sir.
10% of construction, 48 lakhs been disbursed.
No. Asim Misra's case, the May 2/3/2018 and 2/3/2018, we disbursed only 10% of the loan. We have a chart, we will place
My
all
lords,
the
I'll
documents.
produce the loan sanction.
I will give the-
receipts also, my lords. 48 lakh rupees has been disbursed, my lords.
In my case, there is no foundation also. They have disbursed almost 40 lakh rupees.
My lords, in fact, you have a look at the memo. There have been double sales which have happened. There's active loan of HDFC Bank. Ozone, the developer has
But I
sold
am
it to someone
permitted
else,
to
my lords.
please at least kindly see the photographs, my lord, the construction. Almost all over.
In fact, my lords,
But-
the same bank has given loan. This is not HDFC, it's India Bulls, my lords, in their party to this proceedings. Here also.
My loans are concerned.
Just please come. In this WP 15506. In this, there are about 16 petitioners who have purchased flats under the tripartite agreement from the fourth respondent developer. And where is the bank?
Five.
Respondent number
Last three.
Three,
my lord.
Housing
Housing
Development
Development
Finance Corporation have the third respondent. There is a tripartite agreement between the petitioner, the third respondent, and the builder, that is the fourth respondent. It is a case of the petitioners that they have entered into an agreement in the year 2019, and immediately after the agreement, the bank has the substantial amount is released by the bank. And in majority of the cases, according to the petitioners, there is no much progress in the construction. It is submitted that all the petitioners have approached the RERA. An order is passed by RERA directing the builder, that is the fourth respondent herein, to repay the amounts that are paid by the petitioners. And they have also filed execution for the same.
No, that is in the form of civil contempt, my lord, which is pending, because it cannot be filed execution. It has gone to revenue recovery proceedings.
The land counsel appearing for the bank submits that they have as per they have followed the circular issued by they have been following the circulars issued by the Reserve Bank of India from time to time, and they have not disbursed the entire amount. In fact, they have disbursed in a phased manner, and according to the land counsel appearing for the bank, the construction is almost complete.
Many of the,
Huh?
in most of the blocks.
I'm talking about only
15506
this. Is completed.
Almost complete.
By the next date of hearing, the petitioner, in respect of each petitioner, what is the stage of construction, and the petitioners, whatever is the material available with the petitioners, they shall place before this court, and the respondent bank, in respect of each petitioner, how much amounts they have paid, they shall place, not like this kind of a thing. What is the
They
date,
got it.
when, how, where, that you have to.
I
They have dispersed the amount, shall be placed before the court. As far as the tripartite agreement is concerned, and the liability of the borrower, liability of the developer in case there is cancellation, that is very much clear. Hence, this court is passing the following order. 1, the borrowers shall file their file that undertaking memos that they are not that will technically come in your way, whether it is RERA is there or not. The bank will say that they have never communicated to us because we are not parties before RERA. So because any other matter is getting adjourned, file a memo.
I may be permitted also to produce any relevant documents to show that it's been intimated.
Yes. The petitioner shall file the memo about their unwillingness for to retain the secured asset. Second, the orders passed by the RERA, and also any other material to show that the bank has disbursed the amount, and the stage of the construction as on 2021 or when the writ petitions are filed. The bank shall place before the court the amounts, when the exact dates and the amounts that are disbursed in favor of the developer, and the stage of constructions in respect of each petitioner's case, because they are all under different blocks.
Yes, please.
But if what they say is correct, then both the bank and the developer both have to face the consequences.
May I make one submission, my lord?
Yes.
Since this petition, only one petition is taken into consideration in the list today, my lord, the 90% of the cases are with respect to.
That's why I'll call the next matter.
What I suggest is there can be a independent commissioner may be appointed to verify the construction, my lord. Verify the construction, because it is within respect to one premises. One day we will all assist. It can be all the every petitioner's stage of construction can be brought before this court. It may be.
We will place the documents first.
That is, anyhow, this is also.
Yes, my lord. We will not on affidavit. We are placing the document. We will not. We are not there to place some other documents. Whatever is there, we will place it before the court, my lord.
Mr. Counsel, all of you can independently.
Let them also take. We will also take photographs.
Place the photographs.
My lord, the difficulty is in few cases they would not even let the petitioner or the advocate enter into the premises.
Such being the case, builder is there, my lord. Builder may be permitted, directed to enter, permit the borrower to the customer to enter the premises.
We will give the memo of instruction. We will assist him, and it can be done within one day. All the petitioner's property can be finished.
So,
my lords, I have a request, my lords. Let one court commissioner be appointed, so that, my lords, the commissioner would be submitting the report. That would be acceptable to all, so that there shall be.
Who is the advocate in this court who is unconnected with these matters?
Lord, it can be.
Different projects and different developers here. It's not just ozone here. If we take serial number 2, it's all related to different.
So no, like one is ozone, the other is
Ghulam Mustafa, GM Techistown.
GM
Techistown.
Techistown.
High life developers, my lord.
There is one more GM.
Your ladyship, there is also Landstar Homes.
Malats, two names are also there, Malats. Prisha Properties and Vivansa, Malats.
My lords, in fact, there is.
1 minute, 1 minute. Yes, what is that?
There are already 5 reports on record, my lords, of the RERA, the Gram Panchayat, of the Town Community Bank, which are all been ordered by the Honorable High Court and the RERA. All indicate that even as of today, it is incomplete. Even the
Incomplete in the sense?
2017 is supposed to be my delivery. OC is in fact in 17, it's a pre-RERA. Even till today, it says that.
Position is not given.
Not given, I'm not aware. I've already in 2020 itself, I've terminated, I've indicated my bank, I've indicated the builder. Neither the builder wants to give me back my money, nor do they want to pay the bank the EMIs. This is also a subvention scheme where they're supposed to pay the EMIs.
Because in fact,
So in fact, in my case also, the CBI inquiry may be required.
my lords, in fact, there's a petition that I have filed on the court bench, my lords, directing up investigation to the subvention matters, my lords. As per the directions of Honorable Supreme Court, I have also
No,
filed a.
All these, whatever the prima facie material to come to that conclusion that there is some kind of collusion between the bank and the builder, then we can do
As I
something.
produced this particular memo, my lords, which
Supreme Court
clearly
judgments, my
states
lord,
that the
what
same.
they are referring super tech judgments. There, my lord, the project is not even started. That is the reasons, my lord, the Supreme.
However, like still
My
not
lords,
even started, or a
Ozone,
project which started
my
in
lords, Ozone is a party to
2017,
that, and FIR.
What the
not completed.
Ozone is
There's a FIR already filed by the CBI, my lords, on the directions of the Supreme Court in this particular matter, this particular project.
The very same project
Very same
in
project.
Bangalore, my lord.
In fact, one of the petitioners also filed an intervention application directing the relief. Notices have been issued in that, my lords.
But every time when the matter is come up, even though the builder may not say that the project is complete, banks have been consistently telling it's complete, it is
I
complete.
have to say that.
Then let them go ahead with the auction. Let them go ahead with the auction.
And every time that is the incorrect.
If that is the case, let them go ahead with the auction. Relieve us from this.
My lords, in fact, the
Sell
same.
it for the higher price and take it.
My lord, in fact, the same bank has given the loan twice on the same apartment to two different people, my lords. I produced that particular document as well, my lords.
Which bank, sir?
India Bulls. India.
You,
We are
my lord,
generally talking-
let him say which.
Even HDFC Bank, my lords, where there's active
You
loan
have
on
to,
the
you have to
particular.
state which bank. Same bank
Even
means
your
so
bank.
many banks are there.
Even the HDFC Bank, when there's actively loan ongoing, Ozone has already sold this particular apartment. The sale date has been done. The loan has not been closed, my lords, and they're still taking recovery action with my client.
No, who represents the Reserve Bank of India?
Okay, King and Partridge. King and Partridge.
Where is he?
We have retired from these matters, we believe.
Hmm.
I am with King and Partridge. We had retired from this, we had retired from all matters where the Reserve Bank is a party. I believe another advocate had filed Wakalatnama.
I've learned ASG is also well apprised of this particular matter. The one
I think he was appearing on the last occasion. I think last occasion DSU was appearing.
And RBI on the last previous occasions have agreed to
In
the
the name
set.
of, what is the name of the DSU?
Shanti Bhushan.
Shanti Bhushan. In the name of Shanti Bhushan. No, it can't go on like this. There should be like by the next time we come, there should be a clear what is the case, what in each, what is the stage.
The commissioner may be appointed for this purpose to clear all the issues, my lord.
In fact,
with respect to construction, there can be no dispute with respect to that if the commissioner has been appointed.
Then only it is possible.
Each developer has multiple projects.
Then what I'll do is, I'll take up these matters also on Monday. On that day, you like whatever the matters that are listed, from that you prepare one list where like, which builder is, which is a developer in each cases. Then we'll appoint an advocate commissioner to take the photographs, what is the present stage of the construction, and the bank will come and submit before the court. What is how the amount they have released? 2017 entire amount is released, whether it is as per the guidelines of the Reserve Bank or as per their own whims and fancies, will understand.
In as per.
I apologize, my lord, I had to. But I have 3 submissions. My lord, I completely empathize, my lord, the anguish of the home buyers. My lord, I have only 3 submissions to make. Necessarily, all the petitions are directed against, my lord, the recovery by the banks. That's, my lord, the core subject matter. My lord, I would certainly not say, my lord, this honorable court, my lord, will not consider it for other reliefs. My lords are, my lord, certainly, my lord, generous enough to consider the other reliefs. Lord, what would happen is, in respect of, my lord, particularly, my lord, ozone group, my lord, which has several number of petitions here, my lord, they lead the show. The same home buyers, my lord, went before RERA authorities. RERA authorities, my lord, passed several orders for recovery by way of land revenue. My lord, those recovery proceedings are in place, and the land revenue authorities, my lord, have caused certain attachment of properties. My lord, this is number one. The same home buyers, my lord, would go cross section of them before the consumer forum. There are, my lord, the decrees of consumer forum. Thirdly, my lord, the same home buyers would go before the police authorities. Kindly, my lord, appreciate this. The police authorities, my lord, the story before the police authorities is that you have taken money, you have not constructed and handed over the possession, therefore you have committed a criminal offense. There have been charge sheets, there have been investigations, my lord, that is being headed by the police, which have been stayed by this honorable court. My lord, thereafter, the same home buyers, my lord, very importantly, this is very important, my lord, they would go before NCLT under, my lord, IBC code, Insolvency and Bankruptcy Code, saying that we are all financial creditors. No doubt, my lord, they are all considered financial creditors under the IBC. They would go before NCLT and say that please push this company into resolution process, try to resolve or liquidate it because the company has failed to repay our debt. This is what is their story there. Finally, my lord, after all these things as icing on the cake, my lord, this is very important, which I want to submit, particularly in respect of ozone builders. Same set of home buyers, my lord, had complained to ED, Enforcement Directorate, complaining that since we have registered certain cases in various police stations, they become the predicate offences, and this is all proceeds of crime. Therefore, take up investigation. We went and gave detailed statements before the ED. The buildings are in place. The complete development has taken place. There is nothing to invite proceeds of crime here. In spite of that, ED has attached all the properties of ozone builders today. There is not even a single centimeter of, my lord, properties are left out. Entire property, entire project of ozone builders has been attached, my lord. A provisional attachment order has already been passed. We have filed a writ petition which is pending before, my lord, a coordinate bench of this honorable court. And, my lord, there is another coordinate bench, my lord, which has passed an order. The attachment shall continue in respect of, my lord, the properties of ozone. Lord, I ask myself, the buildings are ready. My lord, in fact, last time your lordships directed us to place, my lord, the status report. We have filed by way of, my lord, a memo, photographs, the occupancy certificate, the completed portion of the building, and, my lord, the present status of, my lord, the construction, what is going on, and some of the projects, my lord, individual projects of this entire big project is also funded by nationalized banks and, my lord, Swami Fund, directed, overseen and monitored by the Reserve Bank and Government of India. When this being the case, my lord, I ask myself, if you want the flats to be delivered, you have purchased it at some X rate. Today, my lord, the price of the same, my lord, apartment unit must have increased at least 6 to 7 times. My lord, this is my statement. Now, if you want the apartment, or if you want the refund, or if you are claiming that bank should not recover against you because it is the bank's money, banks cannot come against you, that you are blowing hot, cold, warm, medium warm, everything from the same gun. Now, my lord, all these entire properties are now attached by, my lord, ED, Enforcement Directorate. Now, to even pull out this, they are, my lord, we are making efforts. They would come and implead and say, don't cancel the attachment. I'll place all those details. The home buyers, my lord, in those ED petitions would come, implead and say, don't cancel the attachment. Lord, what justice is this, my lord, I ask? That you want the building to be completed, you blame me for not completion in spite of the COVID period, and at the same time, you are hindering the entire show by encouraging an attachment both by the revenue recovery authorities and as well as by the Enforcement Directorate and as well as by the police. Lord, how are we able to, my lord, function? How am I supposed to, my lord, repay the banks? Lord, today, if there is a decree of the Honorable Court, my lord, on the same subject matter, there are already, my lord, judgments passed by this Honorable Court. This Honorable Court protected, my lord, a big cross section of the home buyers, that there should not be recovery against the home buyers because the entire corpus is consumed by the builders. Therefore, my lord, the recovery as against them under the SARFAESI Act is already stayed. Now, my lord, that particular stay order is presently pending before, my lord, a division bench of this Honorable Court.
These are, my lord, the matters in the periphery, which is not being brought to the notice of this honorable court. Now, my lord, all these matters, if are kept one next to each other, the sleekness of this particular petition, my lord, would remain only to that extent that whether the recovery under SURFACE by the financial institutions against them is proper or not. Insofar as the other reliefs, my lord, commissioner be appointed, all these things.
What is your submission on that?
My lord, my lord, I would rather say, my lord, I would rather say this. True, my lord, whatever the bank loaned them is disbursed towards the buildings, disbursed towards the development. My lord, we can't have any version on that. We can't have any version on that. Many of them have already taken possession. In respect of many of them, the possession is ready. They don't want to take because they want, my lord, the RERA order also to be implemented where the RERA has imposed certain penalties and interest. My lord, it's like I don't want only the cake, I want the cream, cherry,
so
everything.
many of them made it clear, like when you were not there, that they are not interested with that secured asset.
If, my lord, they are not interested with the secured asset, my lord, I would put it this way. If they are not interested with the secured asset, my lord, they don't want the property, they don't want the flat, then, my lord, what remains is that they have not, my lord, paid the 100% amount. It is the bank with the, my lord, the bank has a right to take action against me.
No, but that is not the stand of the bank. That is
No, my lord, the bank entire, my lord, the.
No. Just now, the council was
Mr.
arguing.
Francis.
Arguing, you were not there in your absence.
I'm sorry, my lord, I'll have to, my lord, realign.
No, he's filling the gap that he's arguing on your behalf.
Kindly, my lord, look at this, my lord. I'll make only this submission. My lord, the secured asset for the bank to proceed against is none other than the unit. Now, my lord, now the bank's interest.
According to him, independent of that, they can still proceed against the.
I wouldn't make any comment on that, my lord, because if I support the bank, my lord, I'll be going against them. If I support, my lord, the home buyer, I'll be going against the bank.
It's not a question of supporting them. What is that?
At the end of the day, my lord, at the end of the day, I have to, my lord, with all the humbleness, admit that the monies which was disbursed by way of loans have been finally, my lord, I was the terminating point. The monies have come to me and I have invested the entire monies on the building. My lord, even it is not, my lord, the monies have been diverted, etc., etc. One second, sir. One second, sir. 1 second. Can you please withhold your anguish, sir? Am I going against you? Yes. Kindly wait, sir. Kindly wait. It's my request. Now, my lord, I don't dispute that the banks never disbursed money to me. I have kept, your lordships, that's the reason, my lord, your lordships directed me to keep accounts at what has been done with the monies which the bank disbursed to you. My lord, they are all audited. I have kept it before the honorable court. Now, my lord, monies have not gone anywhere. They are all, my lord, standing there by way of brick and mortar and, my lord, the buildings completed. Now, my lord, this being the situation, if the bank has to recover, my lord, I would with all the humbleness say they'll have to go against the secured asset.
Yes.
They'll have to go against the secured asset. The secured asset is none other than, my lord, the apartment concern.
Which is not constructed in some cases.
Yes, it is constructed. If the bank would say that I have not constructed, then, my lord, I am answerable to the bank. My lord, at the same time, they can't be saying apartment is not constructed, the bank should not recover. It is now, my lord, between me and the bank. I have made settlement with the bank.
I don't think that's their argument.
No,
what they say is, as per the tripartite agreement, the liability, once they are not interested for the secured asset, it is a response that the bank has to recover from the developer.
Certainly, my lord. I bow down, my lord. I bow down.
If that is,
I bow down.
If that is there, they have nothing in the petition.
Nobody shall be left high and dry, my lord. The bank should not. There can't be any judgment, my lord, of any honorable court in this country till today. Taken money from the bank, but don't pay. I bow down, my lord. The bank has to be, my lord. Bank has to meet with justice. Bank, my lord, has to recover. It has to recover against the secured asset, my lord. I bow down for that. I bow down for that. And insofar as the judgment of this honorable court on a previous occasion that says the home buyers are neither given the apartment nor, my lord, the disbursement.
That's why we'll call this 1.4, Mr. Rajesh.
1.4, sir. Sir Rajesh P.
No, wherever I noted down, wherever they say that they want to retain the asset. So what is that?
Let them retain, my lord. We are ready to handle.
For that we want to know what is the.
I appeal for R5 in this 1.4 minutes.
1.4. Yes. 5 is who? You're representing?
The NBFC.
Sir Rajesh P, sir.
Please, my lords.
You said that your client wants to retain the
Malats,
property.
I have to seek proper instructions because they are confused. The builder has not filed their memo. What is the timeline of the possession, Malats? They are there to take the call, Malats. Or more so, Malats, there are 350 home buyers, Malats.
Now, what are your instructions with regard to what is the stage of the construction in?
Well, we have placed already, my lord, a memo with all the documents, my lord. This we have filed it on 18th November 2025 because your lordships, my lord, particularly directed us to do this.
23,268 is the
Yes.
I believe we don't have a copy
Brother,
of
I
that.
am referring.
1 point, sir.
Brother, I'll give you.
1.4.
My lord, we have filed this in my lord writ petition number 23268, my lord, that is 1.33.
Have you served it on the council?
My lord, I am afraid of that. My lord, we'll serve it, my lord, because this concerns only.
From that, what is the stage of construction in 23268?
My lord, many towers have already been completed, and my lord, a couple of towers have to come up, and finishes have been done, my lord, in most of the units. And my lord, I would rather say entire plan, my lord, has already been placed before, madam. Entire plan has already placed before, my lord, two authorities. That is, my lord, before the NCLT, because my lord, the same home buyers are there. Because NCLT, my lord, was concerned with how do we resolve this entire situation. Therefore, my lord, we have filed a resolution plan before the NCLT. I'll place the same plan, my lord. It has minute details as to when, and my lord, whether I have simply saying that I can do it, my lord, I can't simply say I'll fight a tiger unless until, my lord, I am capable of. That report captures, my lord, my capability, the assistance coming by way of what source, etc., etc. My lord, kindly give me, my lord, a day's accommodation. I'll place the same resolution plan before your lordship so that there is a dilated view, my lord, whether my bona fides are made out or not.
Commissioner. 1 point? I'm not saying 1.4, I didn't say 1.3.
My lord, let them file an affidavit, my lord, whoever don't want the unit, my lord.
That's what I've already said.
We will say, my lord, how best they have to be compensated, my lord. Because once they say we don't want the unit, my lord, they will be still entitled, my lord, I would say, my lord, standing in their shoes, my lord. They might still be entitled to recover certain compensations. My lord, I'm not saying, my lord, once they don't want the apartment, I can't say, my lord, just go out of the fray. Because till today, they've been wanting, and today they don't want. Today they don't want. They'll have to, my lord, surrender the unit, which I'll have to, my lord, once again trade. Otherwise, my lord, what would happen, my lord? They don't want the unit. My lord, once they say they don't want the unit, my lord, I am sure that the banks will not go against them because the secured asset is perfect. Banks cannot go against them because, my lord, I undertake that liability. I take, my lord, that liability on an assignment. I take that liability on an assignment because, my lord, I have to give here a solution, my lord. I can't leave the things, my lord, with an open end.
Such being the case, we have no objections, my lord. If the builder is taking the assignment.
In that case,
whoever don't want, my lord, we will take over their unit, and my lord, we will give an undertaking to the bank.
In that case, let there be an undertaking affidavit from.
I will, my lord. I'll place.
All the cases, whoever doesn't want.
Doesn't want, my lord, let them say it on an affidavit, my lord, we'll place.
Let him also file them affidavit.
Yes.
Because
I'm
going
obliged
to undertake and the assignment of the liability on behalf of the borrower.
Then, my lord, let the banks not go against them.
Certainly, we have no objections, my lord. We are.
Now you will interpret the terms in a different way now. With this undertaking.
My lord,
we have been caught in between at the hands of the builder and at the hands of the borrower.
No, my lord, certainly they are not between, my lord, a devil and the deep sea. They are, my lord, more powerful than the builder and the home buyer as well, because, my lord, the law of the country is there to support. My lords, may kindly record that I will give an undertaking based upon those who are surrendering.
Yes, my lord.
Yes, along with the amounts, my lord.
What about
Amounts they have returned, even let them mention it. Let them the date of payment when we are returning, when we are surrendering and they are taking the liability. The payment what is being made by the petitioners, how much they are paying, what time, what is the timeline they are paying has to be given.
Whatever that is financed by the bank is between me and the bank interest.
Now you're complicating the issue, and that would be beyond the purview of this court. Now it is like this. All of you, particularly in your petitions, you have already approached the RERA. You have an order. So let them not say now what would be the amount, how it should be. It is not required.
Yes, my lord, that they can recover always. ED case is there, attachment is over.
Forget about it. Now the moment if they file an affidavit before this court,
much obliged.
so whomsoever says, then it's their
Yes,
responsibility.
we take over the unit.
Not, bank will not come in the way.
Much
Yes,
better.
there is a small lacuna. Before there are many cases, my lords, on which the same terms wherein the developer has taken over and he said, I will give an undertaking. But then subsequently that phase goes away, the liability shifts from me. But the loans never get closed. Those accounts are still open and there is a liability still on me. In
Then
the
what would-
CIBIL
what
score,
would-
my
one
lords.
minute. Once he files such an affidavit, what would the course of action from the bank?
They have to novate the contract and, my lord, put me in the place of, my lord, the home buyer. That's all, my lord, as simple as that.
Isn't it?
No, I'm sorry, my lords. I appear for State Bank of India, which is also the petitions have been clubbed. Now, my lords, if my senior counsel is to be accepted, it's all semi-finished. Neither can the bank, my lords, auction those semi-finished units. There will be no identification of numbers, no kata numbers. There is no way this could be auctioned. Now these builders would
But that's
sort of.
how unfortunately banks are granting loans. That you should think about this eventuality while granting it, not at this time.
No, my lords, it's a public money ultimately, my lords. Public at large, public money should be safeguarded. That needs to be addressed as a primary
Public
concern.
money, public board should be safeguarded.
My lords, my lords, I can make one suggestion, my lords. Even that should be of some use to my senior counsel, Shyam Sundar. Let it be said that bank can proceed against the project. Let it be said. Otherwise,
It is all secured, my lord. The right is, my lord, with them. My lord, unit is secured. That's already a secured asset.
No, my lords. We need to be
No, it
protected
is
in
there
the
in
sense.
all, the clauses there.
It's a secured asset. It's a secured asset, my lord. There is absolutely, my lord, it's they are
Please,
free
my-
to proceed, my lord, in section 13(4).
Please,
Whatever the
please,
way.
my lords, we will be.
There
is no mortgage as such that needs to be
Senior counsel is
appreciated.
only with respect to a single developer. My specific developer, Ghulam Mustafa, has not even appeared here. So in such a case,
They will interpret the agreement.
I am, my lord, making this undertaking only with respect to two developers. my lord. Ozone and Mantri. I am certainly, my lord, not concerned with the other developers, my lord. I think Ghulam Mustafa,
Then,
somebody, my lord, they have to take instruction.
I mean, the other developers are not served.
No, they have served, they never appear.
Oh, then we will interpret the clause and we'll as per the
I think, my lord,
other
this,
matters we will.
they should also, my lord, follow the same path, my lord. This is the best path that can be worked out.
Oh,
To ease them out.
If they are not appearing, then we
Yes,
will
my
say
lord. Then,
that
my lord,
as it is, in your case, you have undertaken, in remaining cases, the court will say.
But at one aspect I should clarify to this court. Most of in respect of financings made to the units, we are only retail financiers, my lord, for even the bank, State Bank of India. We are retail financiers. There is no mortgage as such. That aspect, my lords, I would have to place it on record.
Independently we'll hear when your case comes.
Please.
Majority cases are such, if it is yours is a different case, we'll hear it independently. So we'll have it on Tuesday.
Greatly obliged.
My lord,
In the afternoon.
any day other than Tuesday, my lord. Any day other than Tuesday. Monday or Wednesday. Any day other than Tuesday.
Wednesday, I'll be having the larger bench.
Monday it can be, if it.
Monday, the list is already, there are several.
It is for for him to file the affidavit, my lord. So it might not take up.
He says he will file.
No, if he doesn't,
No, my
then
lord, I have to, my lord, I'll, my lord, file a plain affidavit on, my lord, the next date of hearing that subject to the surrender, my lord, we take over the liability. And, my lord, that can be read in particular, whoever is subject. I am not saying that until they file, my lord, I will not file. I'll file, my lord, a plain affidavit.
no,
covering, my
today
lord,
the exercise has been done. It's only we have mentioned that all of these petitioners in the ozone in the 1.1, they are not interested. We are ready to surrender. So let him file.
All 16 persons are not interested.
Even one.
affidavit, my lord.
All the paperless rewards, all the papers which they have to do or complete and conclude should be done in a time bound manner which they state to be. It should not prolong beyond certain period of time and become a.
Because our CIBIL score gets.
They are all niceties, my lord, which we can certainly work out later. Principally, my lord, by the next date of hearing, I'll file this affidavit, simply stating that those home buyers who are surrendering their, my lord, asset, we will, my lord, take it over and we take over the liability of the home loan as against them. Like this much I will say.
Then senior counsel appearing for the developers, that is Mantri and Ozone, submits that wherever wherever the petitioners who are ready to surrender the flats, there the developers will take over the responsibility or the liability of repaying the loan. In that regard, they'll file an affidavit by the next date of hearing. This is matter on
My lord, one submission.
Give that, give all that. Another 30 years also given.
My lord, the best way is instead, my lord, wherever the builders are not yet represented, my learned friend should say, take my lord hand summoned and secure
I
their
think
presence.
wherever,
So that, my lord, it
in
can be
your
put
case,
to
I
a
think yours
quietus.
is a fresh matter in 70.
Let them take hand summons
70
and, my
that
lord,
the
get their
council is
presence.
permitted to take out hand summons on the
The lawyers
council
are all the
appearing for the
builders.
bank as well as to the builder. Builder? No, that's right. Because it's coming up on Tuesday or Wednesday. By the time you take out hand summons to the builder and file a memo.
So that, my lord, the presence can be secured before.
In any of the matters, if the builder is not served, that we cannot take up. So by the next date of hearing, take the council, the writ petitions where the builder is not served. The petitions are at liberty to take out hand summons on the respondent builder and shall file a memo to that effect. List these matters on Wednesday.
My lord, one submission, serial number 1.1. The previous council's name is forthcoming.
In 1.1, delete the name of Mr. Soma Gowda AN and print the name of Mr. Rajesh P. Yes.
No, Srinivas V.
Srinivas.
Wherein I am appearing.
My lord,
Respondents.
your leadership, similar. I have a similar request in serial numbers 1.40 till 1.51.
Yes.
Lord, my lord, in 1.27 and 1.21 and 1.8, 1.23, copies have not been served on me. Though there were so many.
1.28. My lord, that may be recorded.
So,
Will
your
serve.
matter?
One of them might be mine, my lord.
So,
We are just
whatever
like-
the numbers you have written,
That should
the
not be a
council for the
showstopper.
petition says on the copy on the council appearing for the bank. Yes.
Greatly obliged. Wednesday, greatly obliged.
Your leadership, I have a similar request for serial numbers 1.40 through 1.51.
Advocates appearing online, secondary treatment. First, we'll hear the advocates who are there in the court. Yes. Because anyhow, we are going to take it up on Wednesday. Again, why to? In all the matters, I said at the general order, in all the writ petitions, wherever the developer is not served, the petition is at liberty to take out hand summons. Yes. 35. Yes, in the first list, 35. That also on Tuesday. Look at it wherever interim order is there. In all the matters, wherever interim order is there, that will be extended. Then we will hear on Wednesday. No, we will not grant. Nothing will happen. We will not go into the interim order space now. This list. Where is that?
My lord, one submission. My lord, I have one submission.
To appear for the petitioner in this matter.
My lord, 1.25. I had mentioned that it is a slight matter.
That day, when the matters come, we will hear. But it's a different matter, we'll hear.
My lord,
I have a submission request in serial number 1.40 to
These matters
1.51.
is taken on record and dismissed. Yes.
My lords, I appear for. My lords, I appear for.
1 minute. Yes, Mr. Sharanya.
My lords, from serial number 1.40 till 1.51, the name of the council may be reflected as my own. It is being shown as a different council. I'm also on record. He is no longer representing them.
Look at that.
1.40.
1.40 to 1.51.
Retain his name and delete the other advocates.
The name of your, that is, sir?
Sharanya Singh.
Shreyansh Singh.
My lords, in submission, my lords.
Yes.
In 1.36, I will be permitted to accept notice for respond numbers 8 and 9, my lords. I'm already on record for the same respondents in
For
1.52.
all this, 1.36, so what's your name?
Manu Kulkarni, my lords.
So and so is directed to take notice on behalf of
Respond numbers 8 and 9, my lords.
respondent number 8 and 9.
No, I'm just
My,
giving the.
my lord, on submission.
My lords, on
My lords, 1.25 may be delinked, your lordship.
Petitioner do not want it to be dealing. Let it be there. Yes.
my lords, on submission. May I make my submission, my lords.
Submission for what?
My lord, in 2.16 and 19, my lord, I am representing National Housing Bank, which is one of the parties, formal parties along with the Reserve Bank of India. My lord, in addition to this, my lord, there are bunch of petitions which are pending for the subversion filed by many petitioners. If all are clubbed together, my lord, any of your lordship is finding some solution.
Let's deal with these many matters. What are there before the court? Yes.
My lords,
What is the
1.7 and
relief?
1.27, my lords.
Yes.
My lords, we have filed an
All the
application
matters
for
will come
paper
next.
publication, my lords, on builder, my lords.
It is not
Which
served so far.
Yes, my lords. We want
Please
the
take out
opportunity to
hand
paper
summons.
publication, my lords.
Please take out hand summons.
And someone.
Hand summons. No paper publication now. The time is not there.
Understood,
It's
my
coming
lords.
up on Wednesday. By that time, you have to file your memo by serving the hand summons. Yes.
Noted, my lords.
Let's see your prayer first.
Please, my lord. The first prayer being, my lord, to quash the order at Annexure A, my lord, in criminal miscellaneous number 7201 of 2024, my lord. My lord, in short, my case is this, my lord. I am the owner of the petition scheduled property, my lord. Thereafter, my lord, I got the knowledge after on 25/11/2025, the respondent number bank entered the petition scheduled property and ousted me from the property, my lord. At that point of time, my lord, two documents were given to me. One was this order at CMIS, and the other being the respondent number 2 had availed a loan as a personal loan, my lord, over a completely different petition scheduled property, not this scheduled property, my lord. That is forthcoming, my lord, from Annexure C to Annexure G are the ownership documents that are produced before this honorable court. I am neither the borrower nor the guarantor, my lord.
Yes, Mr. Vignesh.
I conducted the auction. I took a physical position. Everything is over.
No. First of all, you have to appreciate what is his case. According to him, he's not neither a guarantor nor a borrower.
In fact,
So that is not required. Whomsoever property you will take.
it's not so. 2021 the Supreme Court came for party in favor. Then I should have 32, 34, etc.
No, that's what we want to know. Who has mortgaged the property in your favor?
Second respondent.
Respondent number 2.
Second respondent has mortgaged the property in the year
28/9/2021.
28/9/2021. Proceedings were initiated when?
From 2020, in fact, they sold a copy on 130. I'm not able to take a complete instruction. What is my instruction, my lord? On 28/3/2024, that account became NPA. From 2021 to 24, he was paying.
When did you purchase the property?
As far back as in the year 2021, I have produced the sale deed.
2021 is his mortgage also.
No, my lord. Now that I do not have any idea, my lord.
No, you are
From
saying-
2003, I have produced the
No. Tell me when is
both the properties are different, my lord. Kindly appreciate.
No. Please tell the court when did you purchase the property,
That-
which is the subject property?
Please, my lord. That is at running page number 34, Annexure C, my lord, 18/2/2022. 2022.
But
Erstwhile, my lord, on 19/1/2021, over the very same petition scheduled property, a registered agreement of sale with my vendor is also produced at Annexure D, running page number 44.
Dated 19.
19/1/2021.
Then.
And the person who has sold the property, Mr. Prem Kumar, my lord, that is as far back as in the year 2003, I'm able to trace my title. The mother deed also I have produced before this honorable court. That is at Annexure E. as far back as on 3rd March
Have you
2000.
filed the encumbrance certificate? With
Yes, I
regard
have
to
filed the
this
encumbrance.
property?
It is showing my name.
Sure.
Please, very well, my lord. The encumbrance certificate is at EC code. One second. I have not produced it. I just got it now, my lord.
May make one second. Milord, it's a, Milord, orally they told me, Milord, we have affixed a notice, we did everything. Then
This is the EC, my lord.
the property. In this tension, Milord, no issue. Clearly show the plan.
Why not?
Both the properties are different, my lord.
Property.
I'll ask myself, Milord. Sale taken place. Physical position of the property has been already taken, and Milord must be
Without the notice of the owner of the property.
of objection and produce a document for this one. But no notice, one month.
But please don't do anything. You're thrown them out of the house.
Sale taken place, sale certificate issued, possession has been taken 1 month before. No, what?
No, everything in the air. If you're doing, what will happen to the?
No, for that, Milord, I have to file a statement of objection.
I am not going to grant any order without hearing you. That's why I asked him in the
Very well.
In this juncture.
No, if you get the instructions, tomorrow I will take up this matter again.
Milord, at least I needed 2 days time.
Now, interestingly, my lord, this is not a home loan. The Sandeep Patel, that is the respondent number 2, my lord, he has taken a personal loan, my lord. There is the joint next.
Secured asset.
It is not a secured asset. I do not know how they come at my property, my lord, when I'm inside the property. Kindly see the photograph, my lord. I'm a heart patient. I have produced the photograph at Annexure H, running page number 71.
Please come to this EC.
Yes.
Let's see the transactions that reflect. What is this 23/5/2025?
This is a loan taken by me from the chit funds on the very same property, my lord.
That's you have taken on
Yes,
23/5/2025.
Yes.
Then before that?
Before that, my lord, at 3rd page of that, at column number 3, my lord, it clearly shows it is written in Kannada, my lord. As far back as in 2021-22 with the registration number, from one Nirmala Gupta, I have purchased this property. That is the petitioners, the husband and wife have purchased. That is clearly depicting over this scheduled property. Now, clandestinely, what the respondent number 1 bank and respondent number 2 do is that.
Nowhere the mortgage reflects it.
No, my lord, I have nothing to do here. Kindly appreciate this, my lord, at Annexure A. When under 14 they go before the jurisdictional magistrate, my lord, at running page number schedule. The schedule is at running page number 23, my lord. This is the property they intend to secure, and they are now making a submission that they have.
Let's see that order.
Yes, very well, my lord. Running page number.
Where they have mentioned about the property?
Property is at running page number 23, my lord.
23. No, in 14 order.
That's a 14 order, my lord. Running page number 23.
What
In
they
criminal
say?
miscellaneous 72.
Piece and parcel of Northern Postal BDA site number 6th phase.
6th phase.
Bangalore, measuring
100 square feet.
Now, where is your property?
Now my property description is also at the EC, and in my sale deed, my lord, which
Where
is
is
at running page number 42, my lord. I'll be able to submit it. It's in Kannada. I will read it, my lord.
Yes.
So that is
Survey number? That whatever the.
no, my lord. That is this is completely different village, my lord. This is Saraki Old Village, Khata number 12/2. Property number is the same, number 660, and Khata number of Bomanhalli 367. Now in BBMP limit, it Puttenhalli ward 187, my lord. So their ward number is also completely different, and mine is measuring exactly 30 into 40 feet, east to west 40 feet, north to south 30 feet. Totally at measuring 1200 square feet with 2 square feet AC sheet roof, red oxide floor, forest wood windows, along with civic amenities. So this is my property, my lord. That is not mentioned in Annexure A, which is the CMIS petition number 7201. That's a completely different property.
Yes. Yes, Mr. Shetty.
Lord, my instruction is this. On 28/9/2021, my lord, the subject property, my lord, created a mortgage in my favor and availed a loan. And thereafter, my lord, account became NPA. We issued 13/2/34 and we have filed a section 15 application. And in the meantime, my lord, we sold a property.
So under the guise of that, you can only take possession of a property which is mortgaged to you.
It is not to me, my lord. My friend.
That's why please come to this. If it's a property is mortgaged to you, won't it reflect in the EC?
Let me take the income.
That's what is the present stage?
Please, my lord,
No, I am thrown out of the property, my lord. They've put a bank lock and seal, my lord.
When?
25/11/2025. Last month, 25th, my lord.
Sale took place on, my lord.
And I couldn't even secure the certified copy, my lord. I've sought for dispensation.
So I will take up this matter on Monday. by Monday, whatever you want to
I
submit.
need to file a
No, no, no,
statement.
not, but then I have to pass order saying that, whatever.
Because third party interest is created. In fact, sales certificate.
No, you can't say it so simply. The third part, you just create third party interest on the respect of somebody's property. How is it permissible?
I furnish details to my friend. Let him make the party. Because now sales certificate got registered, everything is got over now. Even though I
You register a sales certificate of somebody's property. It's not a valid one.
I have a charge of the property and
That you have to show.
I'll produce.
Let them substantiate the description of the scheduled property, my lord.
Please come. The
My lord may pass some interim management maybe, my lord. I need 1 week's time in this matter because
the petitioner, the writ petition is filed, questioning the action of the bank, questioning the proceedings, questioning the order that's passed under section 14 of the Surface Act. Then counsel for the petitioner submits that petitioner is absolute owner of the property, which is purchased by him in the year 2021, for which he has entered into an agreement of sale on
Agreement of sale, my lord.
the year 2019.
No, my lord. 19/1/2021.
In the year
Registered agreement of sale.
registered agreement of sale on 19/1/2021 and purchased the property by of a sale deed on 18/2/2022. On 18/2/2022, it is submitted that petitioner is neither the borrower nor the guarantor. The respondents have taken physical possession of the property on
25/11. 5/11/2025.
25/11/2025 and 25/11/2025. It is submitted that he has placed before the court the EC pertaining to the property and the property that is described as a scheduled property in the impugned order. It is submitted that there is no nexus between both the properties and the bank without any basis had taken possession of the property. When the matter is moved in the morning for when he mentioned for a lunch motion, this court has directed the petitioner to serve the copy on Mr. Vignesh Shetty, who is appearing for the respondent bank. On instructions, he submits that the bank has sold the property and a sales certificate is issued.
On 28/9/2021, my lord, loan taken pursuant to my lord treating a mortgage.
It is submitted that the property is the property is mortgaged to the bank. This court has
And pursuant to my lord 13/2/34 and I
this court has directed the bank, the land council to get instructions in the light of the discrepancy in the description of the scheduled property and the EC that is placed before this court. And the EC does not, there is no entry with regard to the mortgage made to the bank in respect of this property. Land council submits that he requires a week's time. In these circumstances, considered as a balance of convenience is in favor of the petitioner. If you are asking for not to sell, like they've already sold.
I did not know, my lord.
So what is to be done now? Let there be
I may be
status quo.
put in possession of the property, my lord, and let them not precipitate.
That's what.
I'm a heart
The-
patient. That's only property.
The petitioner, the bank shall not take any, there shall be a status quo for the property. So that they'll not give position to the third party. The property, they shall come up,
Any date may be given, we file out.
My lord, one more, they may be directed to identify the property, my lord, because we are very sure.
don't worry, on the day when they
Yes.
come up with the.
Yes, I
List
bowed
this-
down. I bowed
List
down.
this matter as part heard.
Great.
Serial number 29, my lord, senior counsel appeared in that matter, one matter between ICICI Bank and interim order needs to be extended.
In 29.
29.
29 interim order to be extended. This is part heard, list after vacation.
I lost a single submission, my lord. Serial number 59 and list 1 this morning. I was on my legs in another court where I missed.
What happened?
The matter is posted for after vacations, my lord. The lower court is, the petitioner is making a submission where he's asking for the dismissal of the matter in the lower.
59 tomorrow.
Wait.
No, keep it in the list because the same, whatever the others were entitled, they will also. That only.
ಸೆಟ್ರೇಟ್ ಮಾಡೋಕೆ
ಏ,
ಫಸ್ಟ್ ಕೇಸ್ ಬೇಡ ಅಂತ
ಒಂದ್ ನಿಮಿಷ ಬಿಡ ಬರೀ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಮಾತ್ರ ವಿಡ್ರಾ